It is a Zoom link.
Yeah.
Okay, we're live.
All right, good morning. Welcome to the public hearing of the Judiciary Committee for Friday, March 25th. It's that kind of day. March 25th, 2022. We like to get underway quickly, given that we have a lot of people signed up, and we'd like to give them all a chance to get to it. If there's a brief comment by my ranking members, my co-chair will be with us momentarily. You may make that comment now. If not, we'll begin with Commissioner Quiros.
Happy Friday, everybody.
It's a good comment. Seeing no others, Commissioner Quiros, are you in and ready to go?
Yes, Senator Whitfield. Good morning.
Good morning. You may proceed.
Good morning, Representative Stastrom and Fishbein, Senator Winfield and Kissel, and members of the Judicial Committee. I am Angel Quiros, the Commissioner of the Department of Correction. I am here to testify on Senate Bill 459. I am pleased to report that through consistent, collaborative, and productive conversation, the Department of Correction and Stop Solitary Connecticut have reached an agreement on substitute language for this legislation. I wish to thank Barbara Fair and the Stop Solitary group out of Connecticut for their advocacy and their willingness to understand the intricacies and challenges of our unique agency. As a commissioner, I must prioritize the safety of the people in our custody, DOC employees who are not only correctional officers, but also teachers, chaplain, medical staff, mental health counselors, and addiction service counselors, as well as volunteers and visitors. Collectively, Stop Solitary Connecticut and DOC focus on the objectives of minimizing long-term impact of incarceration while maintaining a safe and secure environment for our staff and the individuals under our custody. We had identified ways to continue to increase the out-of-cell time, to increase transparency by establishing a correctional ombudsman office and an advisory committee. Those are just two of the highlights contained in the agreement reached with Stop Solitary Confinement. Connecticut Department of Correction knows that this will be an ongoing, evolving process should the bill be enacted. I am committed and optimistic that through our joint efforts, Connecticut will remain at the forefront of progressive correction practice. I urge the Judicial Committee to strongly consider and accept the substitute language agreed by the DOC and Stop Solitary. In addition, I would note that the proposed substitute language includes provision which will require the General Assembly to provide funding for the Correctional Ombudsman, staffing, and operation. I will ask the Judicial Committee to work with the Appropriation Committee to meet these legislative defined needs. Finally, I would like to briefly speak on Senate Bill 416. Although I'm overall have a minimum concern, I would like to call to attention one section of the bill which the department strongly opposed. Section 8 of the bill requires that during a declared emergency such as natural disaster or pandemic, I must grant 22 days per month up to 224 days of a public emergency release credit, except for certain criminal convictions for individuals within 1 year of their end of sentence. Without discretion and input from the Department of Correction, individuals who may be of serious risk to the public or have caused serious damage to the victims or victims' families or their own families will be automatically released. We will also be in many situations where we will have to automatically release individuals into homelessness without adequate medical and mental health or substance abuse support in the community. In addition, these types of mass release could occur in the middle of a dire emergency at a time when the public assistance system is already very taxed. To ensure the safety of the Connecticut residents, crime victims, and the returning citizens, the department must have discretionary authority to determine those who should be awarded the public emergency release credit. I thank the Judicial Committee for the opportunity to comment on Senate Bill 459 and 460 and their impact on the Connecticut residents and the Department of Correction, and I will be happy to answer any questions the committee may have.
Thank you, Commissioner. Thank you for the great timing on your testimony. And your testimony, I think, is probably surprising to some people, but as you and I both said last year, there was an attempt to figure out how to do, I'm speaking about Senate Bill 460, there was an attempt to figure out how to do this, and that work has continued. And I think people can see that there are some fruits from that labor. Your testimony certainly, I think, surprised some people this morning. And my hope is that on the section of 416 that you have issue with, that we can do similar work. I think first I had Senator Kissel.
Thank you very much, Chairman Winfield. Commissioner, thank you for coming in this morning. First of all, I want to compliment you. Everywhere I go, people have nothing but praise for your leadership. I'm a little biased. I think that when you come up through the ranks, you have if not greater knowledge of our system here in Connecticut, maybe a greater sensitivity, and you bring that to your leadership position. But you're really doing a great job, and it's not an easy job. I've worked with a lot of commissioners over the years. Secondly, while I know that the reformers really wanted to see the governor sign the solitary bill last year, I believe with your input, knowing the concerns that you have and the issues not only of correction officer safety, but inmate safety and other concerns, the governor ultimately vetoed that bill, but the discussions continued. So it's my understanding, at least regarding that issue, sir, that it's not quite soup yet, but we're almost there. Would it be fair to say that we can be confident, if not by our JF deadline, in the very near future, that there will be an agreement such that we won't have to take sides on that issue, and that we can go forward in supporting what you and the advocates hammer out, with your acknowledgement that there may be some funding required of that. And on the upside to that, the first time I met Senator Austin, she was Lieutenant Austin of the Corrections Department, pushing to have lieutenants be able to organize into unions. So she and I go way, way back. And it's good to have an advocate that came from corrections that has a leadership role in the Appropriations Committee. So I just want to know, are we almost there yet, Commissioner?
Senator, thank you very much. I believe we are almost there. I believe that it is the right move. And my intentions is to move forward, and particularly with the out of cell time, that can be accomplished safely in the timeframes that it's detailed in the bill. And but I cannot move forward without the funds for the Ombudsman and the advisory committee, which I think is a great step in order to continue with the transparency of the agency.
And I guess, well, understanding that our cognizance is not the dollars, but what kind of dollars are we talking about regarding the ask?
We have now, my department is working with the OPM to try to get those numbers on the cost of the Ombudsman.
Okay, well, before I leave that issue, I just want to reiterate that we are in probably the shortest session that you could have statutorily. I said on the floor of the Senate a couple days ago regarding another issue, it's like the Wizard of Oz when the Wicked Witch turns that hourglass and the sand is zipping right out of it. So the sooner that those numbers can be crunched, the better. And regarding the reintegration, obviously one of the things that I've been really all about since I've started on this committee is breaking the cycle of recidivism. And there's a lot of moving pieces to that. But regarding the second issue that you discussed, how can we help you to achieve better results regarding positive reintegration back into productive society?
Overall, I think that it's not a cookie cutter approach. Continue to support the evidence-based programs that are out there in the community to address and particularly the mental health piece. We're working with the vocational village that we're trying to establish on jobs. Jobs are very important. I just started release my individuals back to work into Whitcraft. So I have females under my custody working at Plantville, and I got male individuals under my custody in Willis-Cybolski back in Whitcraft and East Hartford. So those are meaningful programs, meaningful job opportunities, the employment, the housing, continue to fund the housing. Just supportive on all the social needs that these individuals will need once they are released from my incarceration.
Well, Commissioner Quiros, I think you've done an awesome job. You continue to do an excellent job. I'm not bashful about saying throw the book at them if they really are bad apples and really harm either property or people. But we have so many diversionary programs. When I go out and talk to my constituents, it's actually really hard to get incarcerated in Connecticut. But once someone does their time, as has been imposed either by a jury or a judge or a plea agreement, I think that it's incumbent upon us to do whatever we can, especially if it's data-driven, to drive those recidivism rates down and to be supportive, because that just means, to me, I'd rather have tax-paying, law-abiding, reintegrated citizens. It's better for them, and it means less victimization. So I applaud you on your efforts. Thank you, Mr. Chair, for indulging me in my questions. And I wish you the very best, Commissioner, as you go forward with these initiatives. Thank you, sir.
Thank you, Senator.
Thank you, Senator Kissel. And I'll just say this, I'm sure Senator Austin will be diligently working to make sure that the stuff we need is funded, and myself as the subcommittee chair that deals with this section of the budget will as well. So you have eyes on the prize, as we sometimes say.
You're a man of many talents, Senator.
Representative Quinn.
Thank you, Mr. Chairman, and good morning, Commissioner.
Good morning,
just
President.
quickly, I understand that you worked out an agreement on 459 and there's substitute language coming. Has the substitute language been presented to the corrections officers union, or have they weighed in on it one way or the other?
Yes, so we've been talking. I meet with the MP4 union members, the presidents and their locals quarterly. We've been talking about the Protective Act since it got vetoed last year. And I've been very transparent with them that there is room for improvement to improve the system so that we can continue to reform. Yesterday, I kept them apprised to the fact that I was in conversation with Stop Solitary Confinement. So they knew that I was in conversation with them. It was not a big surprise. As a matter of fact, they even have met with Barbara Fair within recent weeks too. And last night when we finalized the language, they have exactly the bill that was finalized. I forwarded to them for them to review. And we've been in communication.
Okay. And I'm very happy to hear that. Have they had an opportunity to take a position yet on the substitute language? Or have they taken a position yet on the substitute language?
Not that I'm aware of.
Okay.
Yeah.
All right. Thank you very much, Commissioner, and appreciate your time and all your efforts.
Thank you, Representative.
Thank you, Representative. And just as a follow-up to that, I would assume that also means that the fact that they know hasn't necessarily traveled down the line to the members either. Representative Fishbein.
Yes, thank you, Mr. Chairman. Good morning, Commissioner. How are you?
Good morning, Representative Fishbein.
Commissioner, you when you were talking about the compassionate release bill, you referenced it as being 416, and am I to understand that it's 460?
460.
460. Okay. And basically your objection to that in concept is you have a third party that's not part of corrections, not dealing with these individuals on a daily basis, making a determination on compassionate release when DOC should have some input. Is that fair to say that's your objection to 460?
Fair to say, not in those exact words, but as a commissioner, releasing responsible for the individuals that I'm releasing into the community. I may have some information that individuals may not have, and I should be given the opportunity to review that information in order to make a determination if there's a public safety.
Understood. And I might also understand that that concept continues to be a work in progress, as 459 has been over the last couple of sessions.
Correct.
Okay. Do you have any comment on 458? Mental health of incarcerated individuals is something very important to me. And this is more like a data collection sort of situation. do you have any position on 458?
No, as a matter of fact, I welcome any improvements to our mental health system delivery, how we do it, best practice. At the end of the day, I'm responsible to making sure that these individuals get the proper mental health treatment while they're incarcerated so they can be productive. So I am supportive of any change that's going to enhance our current mental health system.
Okay, and then coming to 459, I too am happy that at least on its face, there appears to be an agreement. One of the areas that's of concern to me, I've always been in support of the Corrections Ombudsman. I think that liaison, that go-between is a healthy move forward. But the Ombudsman, is my understanding is they're going to have the ability to issue subpoenas. So am I to understand that it's going to be a qualification of the Ombudsman that they be an attorney in good standing, licensed to practice in the state of Connecticut?
I would hope so, but I'm not sure if that's going to be the criteria. That was not the subpoena power was a problem for me last year when I testified, and this year and during the in agreements, we voiced our concerns, but at the end, I agreed that the individual, he or she, could have the subpoena power.
Yeah, understand that I share that concern because the power to issue a subpoena without permission of the court is a powerful one, and our court process, our grievance process is in place to prevent the inappropriate utilization of that power. So here, giving all due credence, hopefully somebody is selected who is, a good person and all of that stuff. But if they overstep their bounds on this subpoena power, it appears it would be unchecked. If they were a lawyer, then somebody could file a grievance or some other, action. And that's of concern to me. So I do look forward to reviewing the agreement. I'm going to be looking for that. The other thing is the Ombudsman, can they be hired from anywhere in the state? Is that part of what you guys are talking about?
I believe that anybody that puts in for the position, whenever it's advertised and it goes to the advisory committee, that the individual can come from out of state, and if he or she meets the qualification and the advisory group submits names to the committee for consideration, I would assume it can be an out of state. I'm gonna think that it's gonna be somebody in Connecticut.
No, I said anywhere in the state.
Yes.
So it wouldn't be restricted as far as where they're from or anything like that.
Not my understanding. It could be anybody that's interested.
Okay, and then is it under the agreement? Is it one ombudsman for all our correction centers, or is it one per facility? How does this work?
So it's one ombudsman that's going to lead. That ombudsman is going to have additional staff. That ombudsman is going to have an individual that is going to be an attorney. That ombudsman is going to have an individual that has correctional expertise in corrections, individual that has expertise with medical and mental health.
Okay, and in addition, so the ombudsman, there'd be one ombudsman for the entire state, and then you said they will have staff.
Correct.
How many? What does this staff structure look like?
From right now, from what I can remember, those 4 or 5 individuals that I identify, I'm going to assume that he's going to need some clerical staff at his office or her office and additional assistance. So I would say anywhere from 1 to 8, 1 to 10.
Okay, so am I to understand that those individuals that work underneath the ombudsmans are like assistant ombudsmans, but are we looking at getting one embedded like at each facility? No.
Just one ombudsman for the overall program, and then the assistants to assist the individual with the job with the 13 correctional facilities.
Okay, and you said like 5 to 6 assistants.
Yeah, 5 to 6, well, the mental health one, the attorney, the medical expert, the mental health expert. I'm assuming he's going to need some clerical staff. So I would say anywhere from 6 to 8 is probably a reasonable number.
Okay, so they're not assistant ombudsman, they are assistants for the ombudsman.
Yeah, during the language, we did not go into classification titles of each individuals. So I'm not sure how the advisory committee is going to formulate that.
Yeah, I'm just thinking about, the amount of complaints that we do have in our correctional facilities. And if there's one individual who's going to be the funnel through whom those complaints go, just looking at whether or not that's manageable. I have both arms wrapped around the concept. I'm just looking at manageability. So I thank you. I look forward to reviewing in depth the language. That's all I had. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Representative Callahan.
Sure. Good to see you, Commissioner.
Good morning, Representative.
As you know, I've conducted thousands of risk assessments on people getting out, and one of the key components is meds. Getting meds to when they're transitioning to the community was always an issue at the probation end. How many days are they getting meds? Are they released with now?
2 weeks.
2 weeks. That's helpful. And as far as in each facility, is there a contact for transitional officers to work with them, for instance, with probation when they're coming into the community? So, as you know, there's a transitional unit with probation that works with the inmates. Each facility has one contact for that.
Yes, so each facility has a discharge planner, assigned to work. So there's a list of the individuals that are discharging within 90 days. That discharge planner will have the information, and there's going to be specific individuals that may have mental health issues that our health service units are going to get involved, and my psychiatrist will be involved. Sometimes it's planning with DMIS, it's planning with the provider who's going to serve the individual out in the community.
Okay, I can't express to you enough how important that is, that they work closely with them. It's the difference between someone coming back and not coming back. So I appreciate your answers. Thank you, Commissioner. Good to see you.
Good to you. Thank you, Representative.
Thank you, Representative. Representative Howard.
Good morning, Mr. Chairman. Good morning, Commissioner. Thanks for being here. Appreciate your testimony. And I want to apologize in advance. I didn't get an opportunity to see the S language that you're testifying on until just before this meeting. So I apologize that I haven't had the opportunity to go through it. I do have a couple of questions, though, and perhaps you could speak to maybe the S language addresses this. But I do know that, unfortunately, earlier this year, we lost 2 inmates in the DOC due to drug overdose. Can you tell us how the manner or manners, if it's plural, in which narcotics are getting into our prison system, and what, if anything, this bill would do to disrupt your interdiction tactics to stop that from happening?
Yeah, so unfortunately, at New Haven CC, probably about 3-4 weeks ago, we lost 2 individuals. We suspect that it was a drug overdose on fentanyl. However, there are investigations going on by Connecticut State Police, the medical examiner, and the inspector's general's office, Devlin's office, to determine the cause of factors. I will be transparent, and I'll hit the hardest one first. It's no news, and we've seen it, that out of 6,000 employees in the recent years, I've had staff members that have conveyed contraband into the facility. They've been arrested, they've been charged, they've been fully prosecuted and dismissed from state service. But the majority of our staff the majority of our staff that are coming to work are not conveying contraband into the facilities. The biggest entry points are visiting rooms with contact visits. The next area is the county jails, when individuals are going to court, coming back and forth from court. We've have countless of incidents where individuals have been taken to a county jail and dropped off by law enforcement, and we've had to call them back because during the strip search, we've found a contraband. Contraband is also sent via mail. 2 weeks ago, on a legal mail from an attorney in one of our facilities, we found like 25 strips of Suboxones. So there's many avenues of how this contraband is being introduced into the facility. I'm in support of any bill that's going to continue to provide the treatment to these individuals while they're under my custody to address their addiction.
Thank you for that. But the second part of my question was, is there anything in this bill, such as the increased contact visits or, you know, the restriction on searches that are going to inhibit your ability to interdict those narcotics coming to your facilities?
So the substitute language does not, I was totally against stopping the strip search. That was what was presented to me. I was totally against stopping the strip search because of the reasons that I've indicated before. So the substitute language does not provide me with any concern on minimizing the strip searches of the individuals under my custody.
Okay, thank you, sir. And again, I apologize. I don't have it yet. I haven't had an opportunity to see it, and so I forgive me. And the last question I have is just generally, well, I guess I should see the substitute language before I really ask you anymore, unfortunately. Well, thanks for being here.
Representative Howard.
Thank you, Representative Howard. Comment or question from other members of the committee? Comment or question? I see none. I'll just say this. This has been a discussion that's been ongoing, and substitute language has changed multiple times up until, as the commissioner suggested last night. Because we have asked and they have responded, it is difficult for you to be in possession of the substitute language. But I think we know that, particularly given that we were trying this last year, that the commissioner would not be here testifying to this if many, if not all, of his concerns had been addressed in the bill. I just wanted to take a second to step back to the conversation with you and Representative Fishbein. My understanding, as the latest version that I've seen, is that those assistants are assistants to the ombudsperson, not assistant ombudspersons. But certainly in the final language, we will see how it comes out. But I believe that to be correct. With that, Commissioner, unless you had something to respond to what I just said, thank you for joining us this morning and continue on with this public hearing.
Thank you very much, Senator Winfield, for the opportunity.
Oh, one thing, Commissioner, the those from DOC who were signed up, they were supposed to be with you, so they're not testifying. Is that correct?
They are with me. They was just here for support in case I needed it. You gave me a question that I couldn't answer.
Okay, I didn't want to skip them if they were actually going to provide testimony, but I appreciate that.
Thank you, Senator.
Thank you. Have a great day.
You too now.
Next, we have Jenny Carroll, followed by Fred Hodges. Jenny Carroll,
Yes.
you may testify.
Thank you. So thank you, Senator Winfield and members of the Judiciary Committee. My name is Jenny Carroll, and I am the director of the Arthur Lyman Center for Public Interest Law and visiting professor of law at Yale Law School. Though I'm loath to admit it on this public record, I've spent the last 25 plus years working in and studying criminal legal systems. Over the past year, I have worked with a coalition of community members, legal academics, lawyers, medical doctors, economists, and other experts to examine the impact of Connecticut's incarceration lien. That work revealed that this lien has a devastating impact, not only on those whom it targets, but their family, loved ones, and communities. The long-term downstream impacts our study documented, and which are the subject of the written testimony we filed, and testimony you will hear from others later today, demonstrate healthcare implications, economic implications, including the perpetuation of intergenerational debt and wealth gaps, and barriers to reentry as individuals have struggled under the weight of the lien, which at the current per diem rate of $224 or over $81,000 per year can exceed $1 million. For these impacts, the state of Connecticut can boast a collection that at its highest point is $6 million or less than 1% of the state's total budget. $6 million collected from the most economically marginalized people in our state, people struggling to reenter society after serving their sentences. Now, any of the things I've described are reasons alone to repeal the incarceration lien, and I'm happy to discuss them further. But the subject of my testimony is actually the legal implications of the lien, specifically due process concerns. As I spoke to folks around the state affected by the lien, I was surprised to learn that the first time they learned of the lien was when they received notice from DAS or when some portion of their legal settlement or inheritance was claimed by the state or through a whisper network in Connecticut's prison system. Speaking to court clerks who provided copies of paperwork upon completion of sentencing revealed no information about the incarceration lien. Attempting to gather information on collection mechanisms proved an equally fraught proposition. Now, on its face, this may seem like a simple lack of communication, but in constitutional terms, it is more serious. One of the cornerstones of due process is the notion of notice, the idea that the state may not take action against individual citizens, even those accused or convicted of an offense, without providing them with notice necessary to engage in informed and meaningful decision-making. The lack of notice around this lien creates a network of confusion and misinformation that contributes to the consequences I have described, but this lack of transparency also raises serious concerns about due process. Simply put, defendants are daily asked to plead guilty and accept sentences in our state without being informed of one of the most significant implications of that decision, the debt they will accumulate as a result. Now, I'm mindful my time is limited, and I recognize that this is a complex issue, so I look forward to your questions so that we might have a meaningful discussion. But in the meantime, I urge you to support HB 5390.
Thank you very much, Senator Kissel.
Thank you very much, Chairman Winfield. Professor Carroll, it's good to see you again. I enjoyed it was almost about a half-hour conversation earlier a couple of weeks ago. I had asked for a copy of the letter that goes out to the released inmates. You guys may have sent a copy of that to me, but I didn't see it. So if you guys could shoot me a copy of that again, just so I can see what comes from the government, the state government regarding a released inmate's potential lien and how it looks. I'm in agreement with you that we need to have better notice. Certainly, there's a slew of things that inmates are informed about right as they're being released, either to a halfway house or straight out to the public. And so I don't think that someone should, like 2 or 3 weeks later, just get a letter in the mail. And depending on what that says, it could be quite shocking. So I agree with you there. But I have said that I disagreed with the premise that there should be some sort of paying back for services, whether we're charging the right amount per day or it should be some sort of different amount. I think we can debate that. But even some states, I think you had indicated I think it was Tennessee charges like $1 a day. But there's some provision that allows an individual that's released to sort of understand that there was a cost for the incarceration and that they have a duty to society to pay it back. The other point that I'll make is that $6 million, we just talked with the Commissioner of Corrections looking for funding for an ombudsperson and other support services. And $6 million is $6 million. And I'm just not ready to say, oh, well, we don't need to do that. So I appreciate your advocacy regarding this. I'm not completely on board, but for what it's worth, I think there is some room to have some discussion. I think the word du jour this year is dialogue. We can continue to have dialogue regarding this issue, but I'm not ready to throw it all out right now, and that's just my position. But I wanted to reach out about that letter because I think seeing exactly what comes in the mail is helpful. And that would be a step towards making this process fairer going forward. But I appreciate your advocacy and your willingness to talk to me, Professor, earlier.
So thank you, Senator Kissel. It was a pleasure to speak to you. If I can just speak briefly to a couple of the points you raised.
Please do.
Yeah, so we did send to you a copy of the letter. I'm happy to send it again, though. Believe me, I understand a cluttered email box as well as anyone. So we will get it to you right away, because
It's not really the email box, it's my brain, but that's okay.
Okay, well, I'm with you on that front as well. But I did want to talk a little bit about kind of right pricing, right? Because I think this is something that gets discussed in this conversation about liens. And I think there's a couple important points that I'll make briefly. I recognize there's a lot of folks waiting to testify, and I'm sure you'll hear this again from others. But in terms of thinking about right pricing around cost of incarceration, I think one, it's important to stress that individuals do serve their sentences, right? So when we tend to think of debts to society as a result of a conviction, we tend to speak in terms of the legal sentence that carries with it all the protections of process associated with a trial or a plea. And again, one can debate whether or not those are sufficient, but those tend to be the way we think of repayment of debt to society. I think it's also important to stress, and this is discussed in the written testimony, that when you talk about the impact of certain amounts of money on different populations, it's important to keep in mind context. And if one of the goals of people getting out of prison is to ensure successful reentry, I think it's important to give people tools that allow them to reenter society successfully. And large amounts of debt is not one of those tools. Looking at the repayment plans that some folks faced as a result of periods of incarceration in Connecticut, they were literally higher than my mortgage payment. So the thought that a person would get out of prison, be asked to return to society, and then face massive amounts of debt for periods of incarceration, I think is just a fundamental economic error by the state. And you and I discussed, money is fungible, right? People who use $15 to pay off an incarceration lien are not using $15 to feed their children or pay their heating bill or pay their rent. And so you're putting people in a bad situation where they struggle economically and they may suffer with regard to reentry as a result. In terms of the $6 million, again, I'm with you on that. $6 million is $6 million. I always like to say I'd love that in my personal bank account, right? In the state budget, it's far less of a percentage. But I think it's, again, important to think, what does that $6 million do? And what are the consequences of drawing that $6 million from this particularly vulnerable population? And I think of all the reentry goals our state has, and this runs contrary to them. So that's kind of my brief statement. There's a more extensive statement about prison economies and calculating out these costs in our written testimony that I urge everyone to look at.
Well, I appreciate your students' efforts regarding this and your efforts, Professor. It was a really insightful and enlightening conversation for me. We're not exactly on the same page, but we're much closer than when we began. And again, I appreciate you taking the time to come this morning, and we do have a ton of people. So thank you, Mr. Chair, for your indulgence.
Thank you, Senator Kissel. Representative Blumenthal.
Thank you, Mr. Chair, and nice to see you, Professor Carroll. Thank you for your testimony. And by the way, that is a beautiful office. I know I was not alone in admiring your Zoom background. I just was hoping you would talk a little bit more about, first of all, whether other states have recently made the change that's implicated in this proposed legislation. And also what effects we've seen, if any, in those other states. And also if you could talk about where Connecticut fits in terms of our current law, whether we're in the mainstream, whether we're an outlier, both regionally and nationally.
Thank you for those questions. It's always great to see you, and I appreciate your support on this, as well as the compliment to my office. Always nice to hear. In terms of where we fall with other states, I want to start with, are we an outlier or not? The answer is we are an outlier. Connecticut actually has one of the highest pay-to-stay rates in the country. It is the highest pay-to-stay rate in the Northeast. And again, that's a $224 per diem rate, which, as we noted in our written testimony, exceeds actually the per diem rate for government officials in the state of Connecticut if you were to seek a hotel room, FYI. In addition to that, New Hampshire and Illinois recently repealed their pay to state or cost of incarceration laws. In terms of how that has affected their state budget, the answer is very little. And again, if you think of this money as fungible, right, it means that it's money going back into your state economy and others in other situations. That is all expanded on in our written testimony. And again, I urge y'all to look at that because I realize our time is limited here. And of course, you can always reach out to me if you have further questions. My email address is just my name at yale.edu. I welcome questions. So as I mentioned to Kissel, this is a very crowded email box, so please bear with me.
Well, thank you very much for your testimony today. I appreciate all your work on this issue, which I think is very important from both a justice perspective, but also from a smart justice perspective in terms of we don't want these people to recidivate. We want them to be able to provide for their families and be successful in the future. And so I'm really glad that you've been working on helping us with all the research and everything else we need on this. And I appreciate all the other people who are working on this as well. So thank you, Professor Carroll, and thank you, Mr. Chair.
Thank you, Representative Blumenthal. The comment or question from other members of the committee, comment or question. Seeing on Director Carroll, thank you very much for joining us this morning. Enjoy the rest of your day. We will next hear from Frederick Hodges, followed by Anna Van Cleve. Frederick Hodges.
Good morning, Chair Gary Winfield and the rest of the legislative body. My name is Fred Hodges. Man, I don't even know where to start at this thing because it's real dear to me. When I found out it about 10 years ago, I was incarcerated for about 17 and a half years. And after about 3 years after my incarceration, coming home in 2006, say 2009, I was in a car accident. And being in a car accident was some harm done to me. I received the money for the harm done to me to make me whole, so to speak. And course of incarceration, Lien came in and snatched the money from me, snatched about $4,000 or $5,000 from me. At that particular time, I had about 9 grandchildren. I have more than that now, but I really felt that it did impact me, and it could have impacted them in a positive way. And coming home and having something, I just heard Senator Kissel talk about breaking the cycle of reentry. And breaking the cycle of reentry, he was talking about helping and supporting the DOC on a pre-release side. Now we're talking about post-release. We're talking about individuals who are out in the community, who are successful out in the community, that might get an inheritance, that might get a lawsuit, and then the state is coming in and taking something from them. I mean, I can't express the hurt, the pain, and even the confusion that goes on with individuals when they come and tell me about what the state has done to them. This has been a process that the state has been doing a lot of good things as far as criminal justice is concerned over the past years since I've been home since 2006. But the cost of incarceration lien for myself, who have completed my sentence, and telling me that 20 years after my sentence that I still owe the state is really servitude bondage to me. It's indebted bondage. It's almost in close to what they did and after slavery. It's like the Black Code laws. And some people don't want to hear that, but I'm talking the truth. It still feel like you got a noose around my neck. I've been home for 15 and a half years now. I'm a homeowner. I work for agency, part of the Department of Corrections. I've been going into the prisons for the last 7 years doing pre-release groups. I have ran one of DOC houses and coming home. And I just hear from so many people that's in this thing in reentry and how the cost of incarceration lien has affected them 10, 15 years out of it. I heard Mike Lawler say, the undersecretary, had wrote a piece about he felt that going after someone is counterproductive into reducing crime. He also said that you don't want to disincentivize someone from getting a job, or even worse, a job off the books.
Fred, Um, your time is elapsed, so I'm going to ask you to summarize so that we can get to questions.
All right. Yes, sir. I'm gonna summarize it by like this here. Breaking the cycle here in Connecticut is not social justice, it's social responsibility. In closing, there is a phrase in the field of counseling we use: change the thinking, you will change the behavior. I'm appealing to the legislators to change the thinking, repeal this law, because human justice breeds human development. And if there ever was a law that will come in effect that will maintain inequality, create inequality, and sustain inequality over time, the cost of incarceration lien is one of that law. Thank you very much.
Thank you. Representative Blumenthal.
Thank you, Mr. Chair. Thanks for your testimony, Mr. Hodges, and for being here today. I just had a couple of questions for you on this issue. First of all, if you're comfortable sharing, when you had your lawsuit, did you have to give a deposition? Did you have to participate in discovery? Anything like that?
Nah, my lawyer told me that there was two things they had to file paperwork on. And one was if I've ever been incarcerated, and one if there was any child support liens on me. There's a law that says that if he doesn't do it, then he would have to pay the money that I would owe. So that's how we found out that there was a lien on me by filing that paperwork. I think it was with the DSA. So that's how it came about, and I never knew anything about it.
Okay, and once you found out about that, did you continue with your lawsuit?
The lawsuit was about to settle at that particular time, and he told me what DOC wanted, what the state wanted, and what I remained to get after that. I mean, I had no choice. I wanted to settle because I needed the money. I was home for just 3 years. I had a car accident. I lost the car, totaled the car, and the money would help me get to work back in Hartford. I was working at a halfway house in Hartford at the time.
Okay, and did you ultimately settle at that point?
Yes, I did settle at that point. I wind up getting, it was over $21,000. I wind up getting just $3,000.
Okay, and was the lawsuit process, I guess, stressful for you? Did it create work or?
Well, yeah, it kept me out of work for a while because I had my back was injury to my back. It kept me out of work for a while. It definitely was stressful because being out of work and just coming home from incarceration, didn't know if they was going to let me keep my job, knowing that, you know, I had a background and I was just starting out. And then after just a year and a half on the job, I get hurt. Yeah, it's definitely stressful. It was definitely a strain on my family because at that particular time, the little workman's comp that they was giving me, it wasn't what I was making. And I wasn't making a lot at that time. You can imagine coming home in 2006, the minimum wage was $7.60 an hour. So you can imagine what it was.
Representative Blumenthal, are you finished?
No, I'm sorry, I froze, I think. Okay. Sorry about that. So my last question was, did the process of bringing the lawsuit and carrying on with it until settlement, did that create additional stress in your life? Did it create additional work in your life?
Yeah, bringing in the lawsuit definitely brought a little stress in my life because I didn't know what was going to happen. You know, I could tell you, and talking about this now, and meeting with Sarah Russell, meeting with Jenny Carroll, meeting with Anna Devane and the Yukon and Quinnipiac and Yale interns. I mean, it really gave me some hope, and hopefully that individuals such as myself that completed our sentence that are home. I'm a homeowner, I'm a taxpayer. And right now, if I was to die or something was to happen to me, they would come in. I got 15 grandchildren now. When I first came home, I had 9. I got 6 more grandchildren since I came home. I got 15 now. To know that coming home now and something would happen to me, I'll lose my home, the little bit of money that I do have, that the state will come in and take that. And when they're saying that, and I understand 6 million, but what about, we're talking about reform. We're talking about breaking the cycle of recidivism. I heard Kissel talk about that. So if you're talking about real and you're talking about real change, then the post-release is just as important as the pre-release as individuals inside. It seems like nobody cares about us on the outside who completed our sentence that we're going to owe forever. For 20 years, that's a whole generation or two. And to keep us chained of a sentence for 20 years after, I mean, come on, man. If there's any humanity inside you, to think about us who had did our time, who are productive in society, went back to jail, I have not been arrested, that you still have an incarceration noose around my neck. I said, it's just injustice to me. It just doesn't make sense to me. If we're anything in a society that talks about in Connecticut, and we have done some good things. I'm not saying that we haven't done, but we have a road to go. And this is part of the mending the road of the things that we had stopped long ago. And when we had get tough on crime, now we need to start helping individuals that are out in the community and break this cycle for real.
Well, I want to thank you for your testimony today and for being here with us and for sharing your story and your experience. I think it's an important testimony that we need to hear. One of the things that concerns me about our current policy is that bringing a lawsuit is a stressful experience and can take a lot out of your life. It's often necessary for justice, and we want it to happen where it's appropriate. And I am concerned, first of all, about the fact that some people, if they know that this is going to happen, are not going to pursue justice for themselves because it won't be worth it for them if they know that at the end of the day, the state's just going to take whatever they get out of the settlement or verdict. And that will contribute to an inefficient and unjust allotment of risk and injury. Additionally, I'm very concerned about the idea that the state is essentially free riding on the efforts of plaintiffs who just happen to be formally incarcerated when they bring these lawsuits, especially because from a legal theory point of view, personal injury lawsuits are viewed as essentially compensating you for literal injury, literally physically and emotionally making you whole. And so the idea that the state is taking part of your settlement in a personal injury case is essentially saying, you got a part of your body back, your physical self back through this settlement, or your emotional self back through this settlement, and the state is taking that. That, to me, is very problematic from a justice perspective. And that's putting aside all of the concerns about recidivism and making sure that people who have served their sentences and their debt to society can continue to function in society successfully and be productive and happy members of our society. So I really thank you for your testimony here today. It's important to hear your story, and appreciate you bringing that story to us. Thank you, Mr. Hodges, and thank you, Mr. Chair.
Thank you, Representative Blumenthal. Representative Porter.
Thank you, Mr. Chair, and thank you, Mr. Hodges, for your testimony today. I wanted to ask you, you've talked about what you have endured personally through this. Just wondering, how many people do you know, right, that are actually dealing with this? Other men and women that have come home, and what the impact has been on them?
Well, I can tell you one that's very dear to me. There's a female that when we started this down this road and reaching out to individuals that was impacted by this. I know there's a female that been home for 19 years and about 8 months. And she had some homes left to her when her parents passed away. And she was about to sell the houses and move. And because her lawyer put in for that, the state found out that she was incarcerated 19 years ago, which was about 4 months later that she would have been able to get away with that, so to speak. But now they got the lien on her. I know individuals with people down in Virginia, when there's 2 friends of mine from my community, their brothers got killed in Virginia, down there in Virginia, back when they was going to Rolling Ridge, or back when DOC was transferring people out. And took from them 91,000 from them, 100 and something thousand from another individual. It's countless individuals that I know from my community. And this is one of the things that pains me, because sometimes like someone like you, Robin, Steve Strasser, Gary Winfield, because you are in the communities, you serve that community as opposed to individuals outside, maybe Glastonbury and other places that don't understand the impact of the cost of incarceration and what it's doing to individuals and families, because it's not touching them, because they don't see that. They don't understand that. But when you get a person that might have a lawsuit coming and then they snatch that money from it could be the chance between a person going back to using as opposed to a person starting on with life, maybe starting a business. So there's many, I can say off the cuff, what we have researched with Yale and Quinnipiac and doing the interviews in my office, we had like about maybe 9 to 12 come in, but we had a list of about 20 that need to come in behind that. And that was just a short list. We haven't really reached out to the whole state. We were just talking in the Fairfield County area.
Okay.
And so it's tens of thousands, I would believe, because you talk about now, you got 400,000 people that have been through the system. And Connecticut having what, 3 million, or I forgot how many million people in Connecticut. There's 100 and something thousand, 145,000 in Bridgeport, 115,000 in New Haven, 125,000 in Waterbury.
Right.
You look at that, you're talking about tens of thousands of people who have came through the system that are now being leaned on this cost of incarceration, in which them are the dense population that would help them and help their families continue their life.
Absolutely. So you've been home for how long, Mr. Hodges?
I've been home 15 and a half years now.
Okay, and have you had any altercations, any violations, like, have you kept a clean record? I know you own a home, I know you're doing well, I know the give back that you continue to do, especially with this population of people. I mean, is there any concern that people should have that, I think the point.
Robin, let me tell you something about me. I don't look at myself as a role model. I look at myself as a real model. When I tell somebody I don't do certain things, I don't do certain things. When I was in jail, I read a book one time. It was Soul Down Brothers by George Jackson. He said there's only 2 ways you come out of prison. You make a complete change, or you come out worse than what you was before you went in. And I worked ever since I read that book to change my ways. And since I've been home, I've helped countless individuals on a pre-release that I go into the prisons with Dye McKnight and Willard Cybulski, when Family Reintegration, when we had our contract, when we had a holistic approach with our contract here. So I've been hundreds of people that I ran a DOC house for them, where the 85% people went on to independent living called Enterprise House in Bridgeport, Connecticut. Right now, DOC took our contract. That the agency that I work for now, we still do it privately. So we're still working in the community. I'm still working in the community. And as of lately, I don't want to toot my horn, I just became Bridgeport 136 city councilman.
Oh, well, congratulations, Mr. Hodges, on that. I just really want to thank you for bringing your lived experience to this platform and to testifying today. Like you said, everybody's not intimately connected to this issue, but I think folks in the inner cities where a lot of incarcerated people come from totally understand this. And the one thing that you stated, and I think is crystal clear, or should be crystal clear to this committee, is that people with convictions are saddled with copious fees, fines, and debt. And at the same time, their economic opportunities are diminished. And a result of that is a lack of economic stability and mobility. So if we're really talking about giving people another chance, then we got to make sure that the majority of these folks, and I'm talking over 60%, of people that took a survey that I read up on, are actually still either unemployed or underemployed. And in order to be vibrant, in order to be contributing to the community the way that we expect you to, I don't think that it's fair. I absolutely agree with what you're petitioning here, and I do support this bill. And I just want to say thank you for all the work that you do as well, because you continue to make a difference. So thank you for your service. Thank you for your commitment. And thank you, Mr. Chair, for the opportunity.
Thank you, Representative Porter. Representative Staffstrom.
Thank you, Mr. Chair, and I'll be brief because I think Representative Porter hit most of the points I wanted to, but Fred, I would be remiss if I didn't first congratulate you on your new appointment to the Bridgeport City Council. I know you'll do great things for the city, continue to do great things for the city in your new role. And look, I know this is a bill you have been passionate about for a number of years, and it was always sort of wait for next year, but you wouldn't let us forget that this issue was hanging out there. I want to thank you for your tireless advocacy on this issue, and really for putting a face on it, certainly for those of us in Bridgeport. Look, I think it's been said already, and I'm sure it'll be said again today. $6 million is a drop in the bucket in the state budget, and that $6 million does not take into account the fact that this bill increases recidivism and therefore drives back up prison costs, and also increases the cost of social services in a place like Bridgeport, where that money is not being used to invest in job creation, invest in children, invest in families. And I think you, more so than anybody I've met on this issue, gets that. I just want to thank you for your tireless advocacy on it.
Thank you.
Thank you, Representatives. Comment or question from other members of the committee? Comment or question? Seeing none, Mr. Hodges.
Winfield, I just want to say that I also, in closing, I also support solitary confinement, SB 459 on the solitary confinement. I also support that. I was in SEG in prison, and I think there's a lot of other ways that we can go about when a person is in there, because if they were in there for an issue, whether it was a mental health or it was some type of violence, then I think that, violence is the lowest form of communication. When all communication ends, we resort to violence. So I think if we start looking at something different and how we handle it, I think we could do something better with that also.
Well, I was actually going to ask you that very question. I think I've known you almost since you got out, right? So, and the work that you've done, I was going to ask you if you had a perspective on that, having been inside. I just want to thank you for joining us to provide the perspective of somebody who actually knows what the impact of passing this bill would be. And thank you. Listen, like I said, I've known you a very long time at this point. And I know that you have come back into our communities, and you have been an asset not only to the community in which you live, but to the state, as you discussed the work that you've done. And I appreciate you joining us every time that you have the opportunity to, and all of the people in the state who do, because that's what informs us as to which direction we should be moving in. So thank you again, and I am sure we will be seeing you again. All right.
Thank you very much, Senator Whitefield.
Have a great day.
Likewise, you also.
Next, we have Anna Van Cleve, followed by Kathy Flaherty.
Thank you and good morning. My name is Anna Van Cleve, and I am Associate Professor and the Director of the Criminal Defense Clinic at the University of Connecticut School of Law. And I am grateful to have the opportunity to speak in favor of House Bill 5390. I come at this issue from two perspectives. First, as a career public defender and a clinical teacher who has witnessed the devastating impact of criminal justice debt on my clients, on their families, and on the poor communities of color who are disproportionately affected by laws like this. And I come at it second, as a person who has been researching and teaching about criminal justice debt for several years. In my years as a public defender in Louisiana, my colleagues and I often felt like we were screaming against the wind when we told judges and probation officers and debt collectors and policymakers that debts like these were crushing our clients and their families. Debts like these were preventing them from obtaining better housing, preventing them from putting their children's needs first, and preventing them from building an economic future. Increasingly, national groups began demanding attention to this issue. Change was slow at first, and then after the protests in Ferguson, Missouri put that city and its criminal justice debt collection practices under a spotlight, there was a national recognition of the harms that criminal justice debt cause. Research studies proliferated, confirming time and again that criminal justice debt exacerbates racial and socioeconomic inequality and harms communities. As a result, there has been a sea change in policy. States and local governments across the country in red and blue jurisdictions, and as a result of often bipartisan efforts, have been repealing laws that put criminal justice costs on poor defendants. The practice of forcing individuals to pay for their own incarceration is out of step with Connecticut's overall approach to criminal justice and with the strong national trend toward abolishing criminal justice fees. Connecticut has the highest incarceration lien in the country. Connecticut General Statute 1885A and 1885B together allow the state to act as debt collector for people just leaving prison, for many people at the most economically vulnerable time of their entire lives. And for 20 years after release, the state can act as debt collector to go after individuals who have recently suffered the death of a loved one and have received a sum of money, no matter how small. And the state can act as debt collector for individuals who receive a lawsuit settlement designed to compensate them for actual harm and actual losses that they have suffered. It's not hard to imagine how this law is carried out. People who are still grieving the death of a loved one can find themselves in crass negotiations with the state about a life insurance policy. People who suffer mistreatment while incarcerated can see their settlement award dwindle once the incarceration lien is calculated. States that have pay-to-stay laws on the books have been repealing them. In the last 2 years, California, Illinois, and New Hampshire have repealed pay-to-stay laws. Last year, a county in Michigan forgave $500,000 in pay-to-stay debt. In urging the repeal of the Illinois pay-to-stay law, the sponsor of the bill called it morally wrong and unconscionable. The same is true of Connecticut's pay-to-stay law, and it should be repealed. And thank you for this opportunity. I'm happy to answer any questions.
Thank you for testifying. Is a comment or question for members of the committee? Comment or question? Representative Gilchrist.
Thank you, Mr. Chair. Sorry, I'm on a different computer, so I'm confused. Thank you so much for your testimony. I want to be clear, I support this policy. My question is, as you were speaking, I thought you might know the history. Do you know the history of why these policies came about in the first place?
I know a little bit of it. So there's sort of the broad history of criminal justice fee charging overall, which goes back to the Civil War and post-Civil War policies. But then the more narrow history of the pay-to-stay laws is a little bit different. So there, I believe the history is well documented by researchers, and I am happy to pull the research of Brittany Friedman, Gabrielle Kirk, and April Fernandez, who have worked extensively on these issues. And on the history. There have been a couple of pay-to-stay laws that have been on the books across the country for a while. My understanding is that there was sort of a burst of activity in the 80s and 90s. I believe, and I can check my information, that the one in Illinois sort of jump-started a number of other pay-to-stay laws, and it started with an op-ed. And the op-ed framed pay-to-stay laws, I think it was written by a law clerk, framed pay-to-stay laws as like paying a light bill or paying a hotel bill. And a lot of the rhetoric that surrounded some of the passage of the laws in the 90s had to do with the idea that there might be somebody, some speculative millionaire who gets incarcerated and should be on the hook, or somebody who wins the lottery or has a windfall like that. And I think that that was a lot of the rhetoric around the passage of these laws. I think that there was also a lot of rhetoric around the idea of building fiscal accountability for people who are moving through the criminal justice system. And then what we've seen since these laws have been implemented, that it's exactly the opposite, that having laws like this don't improve post-incarceration and reentry efforts, and that they actually undermine them. So a lot of the thinking from the 90s when these laws were being passed has been undermined recently.
Thank you. Thank you for that. Thank you, Mr. Chair.
Thank you, Representative Gilchrist. And many of us have issues with both computers going at the same time, so it's okay. Representative Blumenthal.
Thank you, Mr. Chair. And nice to see you, Anna. I just wanted to say hello and thank you for your testimony and your work on this issue. It's good to see you again, and glad to see you at UConn as well. I was just wondering if you could talk a little bit about how the current policy affects both litigants and just the system in general from an access to justice point of view. If you could, please.
Yeah, so right now in my capacity at the University of Connecticut, so I represent individuals who are pretrial. So individuals that I see are moving through the criminal justice system and making important decisions about their case. And we represent them and work with them intensively. And as Professor Carroll noted earlier, there really is no information that is going to our clients about the consequences of an incarceration lien and the fact that this may loom over them and hinder their economic future going forward. So that's what I am seeing on the pre-trial end, that there's no sort of formal effort to make people aware of this or to prepare them as they think about incarceration and reentry for the possibility that they may actually have to do all of their financial planning around the possibility of having significant portions of their assets seized. So from an access to justice perspective, there's very little in terms of the information and provided and the process that is afforded.
Thank you for that testimony, and thanks for being with us. I really appreciate it. And thank you, Mr. Chair.
Thank you, Representative. Representative Quinn.
Thank you, Mr. Chairman. I may have missed it, but do you have any statistics as to how much the state of Connecticut collects each year in incarceration fees?
So I have known the figure of $6 million being stated, and I think that came from a few years. I believe that information has been put out by DAS. I'm not sure from year to year how much that fluctuates, but I think that it has been around that figure. But the other thing that I do want to note about the $6 million figure is that we can't really think of that as pure revenue. Because there is a cost for administering these systems, and the cost involves the work of DAS and tracking the lien, enforcing it. Sometimes there are courts involved, there are other lawyers involved. So I don't know that any of those costs have been accounted for, or whether anybody has really calculated what that adds up to. But I do know that there has been an effort on criminal justice fees across the country to do some of this work of documenting how does the ledger actually fall out? If we're pulling in a certain amount of money, how much is it actually costing us to administer these systems? And I do know that in at least some systems, it's proving either cost neutral to both administer and pull in the revenue, or it's actually costing more to administer the system than the revenue that's actually coming in. So I can't say for sure what's happening in Connecticut or how that balances out, but I do know that these systems can be very, very pricey to administer.
Yeah, and I've seen that myself. In my private law practice, I handle a lot of personal injury cases and workers' compensation cases. So the effect of this on settlement is a challenge for us, and it's also more likely than not that many people who have incarceration liens also have received other forms of state assistance in the past, and which may include Husky medical coverage. So we oftentimes are dealing with the triple whammy of a DAS support lien, a DAS medical lien, and then an incarceration lien. And it definitely makes our job more difficult to settle these cases, because the fact of these liens does not increase the value of the case, and the insurance carriers certainly don't factor that into their calculation as to what a case is actually worth.
Thank you for that comment. And the other thing that I would add on that, just because I know that there are the other liens out there, and I'm not sure exactly how the medical lien operates, but one sort of unique feature about the incarceration lien is that the actual cost is not something that can be sort of readily calculated or known by individuals until the point of enforcement, because it's all subject to the calculation schemes administered by DAS and looking through DOC data. I think that it's not a set amount that somebody can say, okay, I know I have, been given this much money under, public assistance or some other form, and therefore I'm going to owe this much money. There's really very little that an individual can do to foresee what the actual impact will be for the incarceration lien.
Yeah, and the other issue that we find with them is that sometimes they're not accurate. I had one case a number of years ago where a client had an incarceration lien, and unfortunately, to his detriment, he spent most of his deposition not remembering exactly why he was incarcerated. But when it came time to payment of the lien, he looked at the dates that were on it and knew that he hadn't been there that long, and he was correct. and the lien ended up getting reduced some. But we see that probably most often with the medical portion of the lien, that things that the health insurance has covered that aren't related to the accident get brought in. So it can be time consuming on my office's part to actually confirm that the numbers that were being given for all three of these liens are truly accurate.
Thank you, Representative Quinn. Comment or question from other members of the committee? Comment or question? If not, thank you very much for joining us this morning, and we appreciate your testimony. Next, we have Kathy Flaherty, followed by Chairman Giles, and I believe he has two staffers with him, Mr. Sparacco and Bothwell. Kathy Flaherty, are you in?
I am. Thank you, Senator Winfield and members of the Judiciary Committee. My name is Kathy Flaherty. I'm the Executive Director of Connecticut Legal Rights Project, and we represent people who are eligible for mental health services from the Department of Mental Health and Addiction Services. I submitted written testimony on 4 bills. I will give you a very short summary of that testimony, then I'm happy to answer any questions. In support of all 4 of them, especially glad to hear that DOC has worked with advocates to come up with substitute language for Senate Bill 459. Senate Bill 445 would create an affirmative right to the provision of emergency medical services. And while I am very much interested in helping to create more alternatives to law enforcement responding to people in mental health distress or other crisis, this really helps address situations in which officers who are out on routine patrol are being asked for help or encounter somebody who's in distress, not necessarily simply responding to 911. This puts the focus on providing that emergency medical services. Senate Bill 458, I believe, would help improve the provision of mental health and substance use disorder treatment for people who are incarcerated and facilitate their reentry to the community, which is so important. We've heard a lot of talk about the incarceration lien, which is 5390. We stand in support of that, but I would actually ask you to consider whether the liens that we put on poor people in this state are things that we should be doing, because there are liens placed against people who get services from the Department of Mental Health and Addiction Services, and not all of that treatment is treatment that somebody voluntarily sought out. We have people who are civilly committed to DEMIS facilities who spend literally years in our state hospitals and have liens placed against them for that. And I asked one of my colleagues how much those liens are. The liens for our folks are 10 times the daily cost of what is posed on people who are incarcerated. And obviously it's different because it's medical care, not simply custodial care and corrections. But it's one thing to have a lien placed when you have voluntarily sought out those services and you're given notice as you sign the paper saying that you want to be admitted, that you're going to be charged for these. It's quite another when you are civilly committed by a probate court or you're ordered by a superior court to have to stay in a hospital and you end up spending years there because the system isn't set up to move people back to their lives in the community as quickly as possible. So I just ask you to consider that, if not this year, at some point in the future. And thank you so much for your time.
Thank you for joining us again this morning, Kathy. Is there a comment or committee comment or question? I don't see any. I just want to thank you again for joining us and for always providing us with a perspective we need to pay attention to. Thank you. Next, we'll hear from Carlton Giles. He'll have Richard Sparacco and David Bothwell there to answer questions for the Board of Pardons and Parole. They'll be followed by Jerry Valdez.
Thank you, Mr. Chairman. Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and the honorable members of the Joint Committee on Judiciary. My name is Carlton Giles, and I am the chairperson of the Board of Pardons and Paroles. I'm here this morning to provide testimony regarding raised Senate Bill 460, and that concerning compassionate or medical parole and credits awarded for release during an emergency declaration. First, let me state that the board supports the majority of the provisions proposed in the bill. These are provisions composed of language jointly developed by the board and the Office of the Chief Public Defender, which one recognizes compassionate parole as a distinct release mechanism, providing the board with more leeway to parole individuals incapacitated, debilitated, or made infirm by illness or advanced age. And two, allows the board to compassionately parole otherwise ineligible individuals due to extraordinary circumstances such as a global pandemic or other national emergencies. In addition, the bill changes the existing and restrictive release standard for compassionate parole to one based on risk. However, the board does believe that certain changes to and clarification of the language in the bill is necessary for it to gain our complete and full support. Specifically, in section 7B1, the only factor the board may consider before granting compassionate release during an emergency, declaration, or major disaster is whether circumstances exist which pose a high risk of harm to such inmate should he or she remain confined. The board has previously proposed and still maintains that it is imperative to include language which allows the board to also assess whether such inmate presents a reduced risk of presenting any danger to society. The board members are trained in structured decision-making and risk assessment and have the great responsibility of making decisions that are in the best interest of public safety. Including this proposed language would better align the bill with that goal. Additionally, section 1F5 authorizes the board to discharge any person on parole, medical parole, or compassionate parole pursuant to section 54-129 of the Connecticut General Statutes. However, section 54-129 lacks language authorizing such discharges pursuant to medical parole and compassionate parole. The board therefore believes that for the purposes of uniformity and to avoid any conflict of laws, section 54-129 should be updated to include discharge under medical and compassionate parole. Thank you for your time this morning and allowing me to testify. I appreciate your time and consideration and happy to try to answer any questions you may have.
Thank you, Chairman Giles. Senator Kissel.
Thank you very much, Chairman Winfield. Chairman Giles, it's great to see you again. I hold your recommendations to heart. The Board of Pardons and Paroles usually doesn't get paid attention to unless you make a mistake. And you're all about assessing risk. And when you do your job to your utmost and there's no incidents, no one's really paying attention to you guys. So it's, and I'm happy because you guys haven't been in the news. There hasn't been anybody under your consideration that went off and did something horrible. But, life is life and you can only do the best you can do regarding predictors. That being said, you guys are the experts. You've done a great job. And so your recommendations to change and align these proposals, I take to heart. I hope my fellow leadership on this committee do as well, because you're doing a very difficult job. And I've been around long enough to see, and Senator Winfield has as well, when it blows up in our face and the whole system grinds to a halt and we have to take a step back and assess, and then the pileup happens and that takes years to unravel. So your thoughts are well taken. And again, I want to thank you and all the people on the boards of paroles. Say hi to former Representative Dargan and others, but I know it's a tough job and it's a thankless job. But I've been around long enough to want to say thank you for your efforts. They are not completely unnoticed. And thank you for that, Mr. Chair.
Thank you, Senator.
Thank you. Thank you, Senator Kissel. That's a much more gentle way of reminding me I'm getting older than my kids do. Representative Fishbein.
Thank you, Mr. Chairman. And good morning, Chairman Giles. Nice to see you again. Miss sitting next to you at those at the task force meeting. I agree with you on your proposed revisions. Were you here this morning when Commissioner Quiros had testified with regard to this bill?
Yes.
Okay. And it appears that he would like to have some input with regard to this process. And I don't see in this bill where it would require the board to get a report. Am I reading that incorrectly, or it appears they would have no input?
So I believe that's what Commissioner Quiros was talking about, and we didn't take issue with his portion, although we support his wanting to have input where his authority lies.
And would you go so far as to be agreeable that he and or his designee would have part of the decision-making process?
So where his authority is, we think that if he should have input where his authority is, as we do, as we're referring to in our portion. We were concerned in our portion and trying to align this idea about taking the risk piece out, which sort of removed us from it. And I think that's the commissioner sort of had the same idea in his portion.
Yeah, understood. But as contemplated, 460 would be a determination by the board with arguably consideration by the thoughts of DOC, but not a vote per se.
So Representative Fishbein, if you allow me to ask Mrs. Bracco, who has dug into the weeds on this thing, if he can maybe help us to get some clarity on what you're asking. Rich, are you close by?
Yeah, good morning, sir. I'm right here. Good morning, Representative Fishbein. If I can, I think there's a couple different sections of this bill that may be conflated. The section that the chair is specifically speaking towards is where the board acts in their authority to grant compassionate. Now, in that, in as much as when we're reviewing cases for the first section, under the first section for regular compassionate parole, the Department of Correction does provide information. DOC Health Services usually sends us information specific to somebody's overall medical or mental health condition. We utilize that currently for compassionate parole reviews and medical parole reviews. The chair was referring to the second part of this, which is during the pandemic, where there is no concern given for risk. It is just based on solely if an inmate is at risk due to the circumstances of the pandemic, we have to let them go, or we may let them go. I think the commissioner's testimony, not to speak for him, I think he was specifically speaking to the portion of credits that he must allocate to an inmate during such pandemic. The two are mutually exclusive, and that's the best I can explain it.
No, I got it. No, I thank you very much for that. And Mr. Chairman, a little bit outside of the scope of this, I just wanted to take the time to ask the chairman about the backlog, if that's okay.
Sure.
Go ahead.
Sure, Representative. Of course, like every agency and entity, we were impacted by the pandemic, and we are making some moves to deal with that. We'll be happy to get into more detail on that with you offline, but we are addressing it. I'm moving some personnel as we speak, in fact. But, we should note that this is a real interconnected process. So, we often have to work with all segments or many segments of the criminal justice system, the courts, which were closed, the public safety, which put people on different schedules, as did we. So that's really how that all came to be.
So specifically, though, last legislative session, we passed clean slate. And I would think that impacted some petitions that were before your board. So the question is, have you been able to go back through the petitions that were pending at that time that clean slate would take your job away, to take those out to therefore reduce the backlog?
Right. So no, we haven't dealt with that with that specificity. We're dealing with judicial and others to see how that's going to impact us. As you know, that's yet to come. We are dealing with our expedited petitions, which you all granted us, I think, in 2015 or 16. And we're dealing with our process normally. So a lot of the work we're doing is still being granted through the administrative process where no hearing is required. And then those that have to come based on the convictions still are coming before us.
Okay. And if I was to file a petition today, on average, how long would it take to get a hearing before the board?
We're about 6 months out, sir.
Okay. All right, thank you. That's all I had. Thank you, Mr.
Thank you, sir.
Thank you, Representative Fishbon, and maybe at some point we'll set up a meeting for the leadership and the leadership over at Board of Partisan Parole to dig a little deeper. Comment or question from other members of the committee? Comment or question? Seeing none, Chairman Giles and all, thank you for joining us today and offering your perspective. As I said to you earlier today, I am happy to engage with you on your testimony and see what we can come up with. Thank you.
Thank you, Senator. Appreciate it.
Next, we have Jerry Valdez, followed by Philip Brown. Mr. Valdez, are you in? Jerry Valdez. Philip Brown.
Yes, sir. I am here. How you doing today?
Very well. You may testify.
Thank you, sir. Good morning, Chairman Winfield, Chairman Statstrom, and members of the Judiciary Committee. My name is Philip Brown. I'm here to say that I oppose Senate Bill 459 as written. I am a correctional officer for 19 and a half years, to where I'm able to retire as of this year. When I read this bill, I was actually shocked because when I first started inside Department of Corrections, the tools that we have now, we did not have when I first started, in which a lot of staff members were getting assaulted, staff members were going out on comp, and a lot of staff officers were actually medically retired based on different incidences within the facilities. The executive order takes away important tools to keep the assaultive behavior from happening. Administrative segregation was a 90-day program. Now, because of the order, it is only 15 days with a buffer of 45 days. This has made the program fairly ineffective. I would like to ask this committee, would they send a police officer without their equipment and request them to report to a volatile situation? If they have a combative individual, after multiple people have tried to reason with this individual, who, as law enforcement, we try and help, we should. Now this individual has a weapon. What does this committee request for correctional officers to do? We as correctional officers, not guards, help to protect and serve the population incarcerated and the public. Connecticut does not have a solitary confinement. Offenders in administrative segregation are visited several times a day by staff. They are given at least 2 hours a day of recreation. They have access to TVs. It is important for this committee to take a tour during regular operations instead of hearing false information. When I first started inside corrections, I remember Senate leaders would come take a tour. And when a volatile situation jumped off, we protected everyone. With this bill, you're asking of taking away strip searches, which allow us to take away drugs and weapons out of the facility. If we are not allowed to use this technique to conduct strip searches based
Mr.
on,
Brown,
yes, sir.
Your testimony, your time is elapsed. If you can summarize, I'd appreciate it.
Absolutely, sir. Basically, I would like to say, please do not pass Bill 459. It will hinder us. It will get a lot of people hurt, and the state of Connecticut ultimately is held responsible.
Thank you. I see a question or comment from Representative Fishbon.
Yes, thank you. And thank you, Mr. Brown, for appearing here today. Mr. Brown, I don't know if you were here at the beginning of the hearing, but there was testimony from the Commissioner of the Department of Corrections that The language that you have evidently there's going to be some significant changes to it, which, you know, that language is probably going to come out sometime next week. So I see that you're watching the process. That's a great thing to do, and thank you for doing that. And thank you for your service as a corrections officer. You know, take a look at that language when it comes out next week. You know, you may see that SB 459 gets passed, but the language will be different. And I believe that the commissioner testified that the issue with consent, with the strip searches has been removed from the bill, and you may be more satisfied with the language. So I just want to bring that to your attention, because you might see that, you know, that bill advances in some way, shape, or form. And I don't want you to be disappointed thinking that the language that you're here testifying on today is that language. So thank you, Mr. Chairman.
Thank you for that, Representative Fishbein. Comment or question from other members of the committee? Comment or question? If not, Mr. Brown, I want to thank Representative Fishbein for pointing out how the process here works. I think sometimes people see a bill number, have read the bill or heard about the bill, and don't know that as we go through this process where things change, you have different iterations on a bill that may be very similar to the original or completely different than what the original bill was. I want to thank you for taking the opportunity to come and participate in this process, and hope you continue to watch as the bill moves forward, and feel free to write us and give us your opinion on what we're doing. But certainly, as this moves forward, it will not be the bill that is currently in front of you. And I hope you take the opportunity to make sure that others who you know who are concerned, who don't have the opportunity to participate, know that as well. Thank you for joining us this morning. I hope you have a very good day.
You too, sir. Thank you.
Thank you. Next, we have Deborah Del Pret Sullivan, followed by Meriden Monthly.
Yes, and good morning, and thank you very much for allowing me to speak. Thank you so much, Senator Winfield, Representative Stastrom, Senator Flexer, Representative Blumenthal, Senator Kissel, and Representative Fishbein. My name is Deborah Del Pret Sullivan. I am legal counsel to the Office of Chief Public Defender. We have submitted testimony on 9 bills today, and I'd like to concentrate first on Senate Bill 425, and that concerning sentence modification. This is an agency proposal to make sure that what had passed last year in the legislature, Public Act 21-104, Section 63, which amended Public Act 21-102, Section 25 on sentence modification, to ensure that that will be applied retroactively. We have a number of people who have applied for sentence modification. This was a collaborated piece of legislation that was worked on by the Division of Criminal Justice and other members of the Sentencing Commission. The intent always was that it would be retroactively applied, and we ask that this fix be adopted this year by the legislature to allow for that. I'd like to just touch upon a couple of other bills that I've heard testimony on this morning. And first of all, Raise Bill 459. We are in support of that, and we are looking forward to seeing the JFS language that the commissioner had spoken about earlier, and working with Barbara Fair, who we know very well as other people from the communities as to that JFS language. And also looking at Senate Bill 460, compassionate parole. This is something, again, that a number of agencies had collaborated on, tried to come to some agreed upon language. And I was very excited this morning to hear Commissioner Giles talk about supporting that, working with us. And I do believe that we can work together on his suggested tweak to this language as to the criteria for someone to be released on a compassionate parole. I was looking back on some of my notes that went back and forth between our agencies. And once I'm done testifying, I would like to reach out to them and see if we could come to an agreement on the language he suggested. And I do believe we could. And also 5390, again, we are in support of that language that would repeal those collection cost types of situations. A number of years ago, I did have a client who had a $15,000 inheritance, and a large amount of that was taken. There was really nothing that I could do to help him or he could do on his own to stop that process. He is currently out in the community doing very well, and it's something that really would have helped him had he been able to have that upon his release. There are a number of other bills. If there are any questions, I would take those questions at this time.
All right. I see Representative Fishbone has his hand up. Maybe Representative Fishbone? Okay. Comment or question from other members of the committee? Comment or question? Representative O'Donnell.
Thank you very much, Mr. Chair. And thank you, Deb, for coming in. I know you have limited time, but if there's anything else you wanted to add of particular interest that you didn't get a chance, I'm just going through your testimony now. I apologize. But if there's anything else you didn't get a chance to bring to our attention, speak now or forever hold your peace, so to speak.
Well, I will. Thank you so much. There are a couple of bills that talk about studying, criminal law process, and civil law process. And we just asked that if there's any discussions about those areas, that the chief public defender be included, and also the chief state's attorney or, one of their designees, because especially in the area of criminal, we're both involved. And in the area of the civil process, as you know, the legislature had put the Commission on Child Protection into our agency many years ago. And so I believe that we have experts here at this agency that would be really helpful if there's an analysis and a review of those types of statutes going through that are being discussed. And the only other one that I would talk about is Senate Bill 461. This is one that we asked that the committee take no action on this. This is to extend the statute of limitations for crimes committed against the elderly, only because we were concerned about the way it was from the discovery of the type of offense, instead of the way we have typically in our statutes is from the date of the offense. This is in the criminal arena. I know that there's a discovery exception in civil cases, but we're still researching to see if such a statute of limitations is something that is utilized in other states as well in the criminal process. So we did put testimony into that one as well. Thank you.
All right. No, thank you. And thank you, Mr. Chair. That's all I had. Thank you.
Thank you, Representative O'Day. Comment or question from other members of the committee? Comment or question? Seeing none. Deb, thank you for joining us again.
Thank you so much.
We will see you in the future. Before I call the next people, I just wanted to do a public service announcement. When the administrator sends to the registered potential testifiers to join as a panelist, that's your opportunity to hit the button to join. Please do so. We are trying to get everybody their opportunity to testify. But if you don't do that, it is difficult to do so. And we have a lot of folks signed up, 121. We can get to all of them. We just ask that you pay attention and do that. Next, we have Meriden Monthly, followed by Luke Reynolds and then Senator Kathy Austin. Meriden Monthly.
Thank you, Chairman Renfield and members of the Judiciary Committee. My name is Meridian Alti, and I'm a resident of New Haven. I'm testifying to communicate my support for SB 460, an act concerning compassionate medical parole. This bill would provide necessary opportunities for incarcerated individuals seeking compassionate release by broadening the qualifying characteristics for relief and establishing protocol in times of emergency. Medical parole, especially during times of crisis, is required to ensure that inmates are not placed at a higher risk when they themselves pose little risk to society. Compassionate release is meant to shorten a prisoner's sentence in circumstances lessen the need for continued imprisonment. Other states have adopted broader medical release laws to address growing numbers of older prisoners, overcrowding, high in-prison deaths, and high cost of medical treatment. Providing medical care for aging and ill prisoners presents challenges to the Connecticut prison system that is under-equipped to provide these services. Connecticut spends nearly $100,000 on admitted healthcare a year, and as prisoners age and experience declining health, their threat to public safety decreases while their costs to provide for increases. Inmates do not have physical capacity to reoffend in some cases. SB 460 addresses this issue by shifting previous language saying release would be awarded once prisoner posed no danger to society to significantly reduced risk to society. Vermont allows release if a medical condition renders the inmate unlikely to physically capable to present a danger to society. Utah directly applies this significantly reduced risk standard by mentioning a lowering of recidivism rates. A Department of Justice review found that prisoners released for compassionate pardons have a recidivism rate of 3.1% compared to the 30% of prisoners released on term. It must be noted that the standards in this bill are still high. Prisoners would not be released without exhibiting extreme necessity or progress. And this is not a move to be more lenient on crime, but rather to ethically cut costs without putting patients or civilians at risk. For me, it is morally required of the legislature as representatives of the people to respect a person's right to life in this circumstance. In Connecticut, 19 people died of COVID-19 while in prison. Dying prisoners are shackled and frequently denied family bedside visits. Michael Farragut died a few months before completing a 2-year sentence of burglary and violating probation. In these cases of the lack of nuance in the legal code, condemned those without death sentences to death. Withholding emotional and physical support denies dignity to inmates. And SB 460 directly addresses this issue by providing specific provisions in times of emergency, by systematizing the legal reactions to such an event. This bill helps prevent future needless deaths at the hands of government. So in conclusion, SB 460 makes the vital process of compassionate release more accessible, specifically regarding the pandemic. And we must protect the right to live of those in the carceral system that are silenced by restrictions. More than anything, I just wanted to reestablish the multifaceted nature of the argument in favor of compassionate release. And I urge you to favorably vote on this bill in the Judiciary Committee so that the individuals may have access to health care that they cannot be provided to in jail. So thank you so much for your time and consideration, and I'm happy to answer any questions.
Thank you. Extremely amazing use of your 3 minutes. Is there a comment or question from members of the committee? Comment or question from members of the committee? If not, thank you for joining us this morning to provide us with your testimony. Appreciate it. Have a great day. We will have Luke Reynolds followed by Senator Kathy Austin.
Hello, members of the Judiciary Committee. My name is Luke Reynolds, and I am from West Hartford. Thank you today for listening to my testimony. I am here today to support HB 5390 and express my strong support for its passage. I'm a third-year law student at the University of Connecticut. I am a certified legal intern in the state, working to represent criminal defendants who cannot afford attorneys through the UConn Criminal Defense Clinic. I've submitted written testimony as well, but I will briefly recap and try not to mention what many other great speakers have already articulated in support of this bill. But I became aware of the incarceration lien not that long ago. I was frankly appalled that such a law is already on the books in our state and has been for quite some time. I've been working with Family Reentry Services, the Lyman Center at Yale, the Civil Justice Clinic at Quinnipiac, and professors at UConn to research and learn more about this incarceration lien. I've had the great pleasure to work with many members, including Fred Hodges, who already gave an eloquent testimony today in support of the bill, about the impacts that this law has. Not only is this law manifestly unjust, but the incarceration lien also perpetuates intergenerational poverty. The lien makes building and distributing wealth to children incredibly challenging, as many formerly incarcerated individuals are unable to pass along the compensation from either lawsuits, from inheritances, or even their estates, which may have been in the family for generations, thus stagnating economic mobility for not just the formerly incarcerated individual, but also for their family. While the state should enact legislation that lifts up the economically vulnerable, the current legislation does the opposite. The law also has a disproportionate impact on Black and Latino residents of Connecticut. While the non-Hispanic residents in Connecticut represents approximately 2/3 of the state's population, it's only 28% of the incarcerated population. Meanwhile, Black and Latino individuals make up more than 71% of Connecticut's prison population. Lastly, I'll just say this law no longer comports with its legislative history. It was enacted originally, I believe, in 1995 and subsequently in 2001. The goal was to reduce the state's financial cost of incarceration. outside the fact that it is notably bad policy to have the prison system financed by state criminal defendants and incarcerees, Connecticut has seen a substantial decrease in its prison population, down to 9,500 individuals from almost 20,000 in 2008 when it was at its high. With this lower population and the cost of prisons run down and the increase that the state should be placing on diversionary programs, this law doesn't comport with its legislative history any longer. And it does little for the state. It accounts for approximately only 0.0003% of the state budget. Formerly incarcerated individuals already face the daunting task of reentry. This makes reentry all the more difficult. Other states have been repealing pay-to-stay laws like this one for decades, and I believe it's time for the land of steady habits to do the same. Thank you.
Thank you. Right at the timer. Comment or question from members of the committee. Comment or question, Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon. Well, no, it's still morning, Luke. Nice to see you. Look, I'm trying to get my arms around this reentry aspect, because my understanding of these liens is that it isn't like a wage execution, let's say, where there's a judgment and somebody applies to have money taken out of a weekly paycheck. It only comes into play when somebody has, so to speak, a windfall. Am I inaccurate in that?
That is correct.
Okay. So as far as reentry, certainly I'm certainly very favorable of individuals that were formerly incarcerated being able to get a job, be a productive member of society. And I'm trying to just, the reentry aspect, how specifically does one of these liens prevent reentry?
Absolutely. And I hope it's okay that I do this, but I will refer back to Mr. Hodges' testimony earlier when he talked about how he was in a car accident and he settled for $21,000 and he received less than $3,000 because of the incarceration lien. This was shortly after he was released from prison. He was working. He had to take time off of work because of it. He had to purchase a new car, and because the lien impacted his ability to recover what was just compensation for his injury, he then had to go back into the rest of his financial pool to recover what he lost and the time that he was out of work and what he had to do to pay for a new car, because the state imposed this lien on him without notice. And it does this for more people too. And a lot of times formerly incarcerated individuals don't know that this lien exists, and this lien, impacts their inheritances and their estates and windfalls that they are entitled to.
So just to deal with the notice issue, if one was not being incarcerated anymore than released, if DOC gave them a letter saying this is the lien that you owe the state, then they would have notice. That would cure that situation. Would that be a solace to you?
I don't think it would. I mean, I think the underlying issue here is not the notice, which is an additional problem for many individuals, but it's also the fact that, if a formerly incarcerated person's in a car accident, they're less likely, even if they have notice, they're less likely to bring this lawsuit forward and to be entitled to the just compensation that they deserve if they know that the state is going to take it away. Same thing happens with inheritances. If I wanted to pass along inheritances to one of my children, but they were formerly incarcerated, it would impact my ability to pass along that inheritance, knowing that it might be taken away from my child. All the more making their reentry and their ability to economically stabilize themselves all the more difficult.
So under the analysis that Mr. Hodges had given us, I believe the gross amount was $21,000. That the lien was approximately $4,000 to $5,000, that he ended up with $3,000. Is that what you heard as well?
That is.
Okay. So that would leave approximately $12,000 that went elsewhere. So I think under that calculation, the lawyer probably got more than anybody else out of that situation, which is a different question. But let's say to use that analysis, if the lien is $4,000 to $5,000 and the case or the whatever, the windfall was, let's say, $1 million, would you apply the same analysis to that?
I'm having difficulty following what you're asking, Representative.
Okay, so I would agree with you that the Hodges calculation leads to a level of disparity. But if let's say the Hodges car accident case, that the gross settlement was $300,000, lien was, everything else remains the same. Lawyer's going to get about $100,000 out of that, and state's going to get $45,000, and Mr. Hodges is going to get about $200,000. Do you find that to be acceptable, or is it just the concept of the lien in general?
Well, yeah, I find that the concept of the lien in general is not acceptable, but neither is that scenario that you outlined. I mean, if the award was $300,000, and if that was either a settlement or decided by a jury or a judge, I would assume that Mr. Hodges is entitled that money, or that money is supposed to cover some of the costs of incarceration. Whether what the attorney receives is a different question. And I believe that under the state law, the state can recover $150,000 of that, not just $45,000 of that. So
well,
yeah,
they can't recover $150,000 if they aren't entitled to $150,000.
So where did you come up with the $45,000, Representative?
No, $4,000 to $5,000 was the representation of what the lien was.
Out of 300,000?
That was what was owed to the state of Connecticut, was my understanding in the Hodges case. The lien was approximately $4,000 to $5,000. So it isn't the way these liens work. It's a per diem calculation based upon the number of days that the individual is incarcerated. It is not a percentage of what your windfall is. So that's basically how this is calculated. So I inflated the windfall, therefore increasing the amount that the individual, the previously incarcerated, would get. And I'm just looking at the public policy, your position, should that be the case? Because that happens too, right?
Yeah, I mean, I just find it hard to reconcile studies that are like, it's hard to say because the lien is supposed to cover the cost of incarceration, right? So just because it was $45,000 in one scenario doesn't mean it was $4,000 to $5,000 in another scenario. It depends on the amount of time that somebody was served. So theoretically, in an extreme scenario, the state could recover 50% of that $300,000. I know that they won't always do that because it's to cover the lien, but I'm just saying it theoretically could happen.
No, I agree, but you brought us to the Hodge, that's the example you wanted to use. So, I mean, I can move those numbers anywhere, but moving that a step further, there are similar liens by statute with regard to health benefits, Husky and those kinds of things. And, you get two people who have a child, the mom goes on Husky, with the child, and dad has insurance with his employment. The state has a lien in those cases also. Would you apply the same analysis to those liens?
Yeah, Representative, I don't feel comfortable commenting on the statutory structure of healthcare liens because I have not looked into them. I will say, though, I think that the state should be working towards not imposing liens in general against members of our society who are already burdened by reentry and also struggling with economic costs of living.
Understood. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question from other members of the committee? Comment or question? If not, Mr. Reynolds, thank you very much for joining us this morning. Enjoy the rest of your day.
Thanks.
Next, we'll hear from Senator Kathy Austin, followed by Ryan Bamia. Senator Austin.
Thank you very much, Mr. Chair. Today, And I really appreciate the committee bringing up Senate Bill number 454, an act concerning the provision of substance use disorder service and mental health services to individuals who are incarcerated. I've been proffering this piece of legislation for a number of years now, and I would like to make some recommended changes. While I appreciate that substance use disorder is also being discussed in this bill, what my intent would be is to look at the number of people that are incarcerated that are chronically mentally ill. Most recently, I went down to New Haven to visit a group home where 15 men who were schizophrenic were living. And at that group home, it became apparent that many people were there far longer than they needed to be because there was no supportive housing set up relative to these men. Many of them had, if they had left the group home, had been reincarcerated and then followed the cycle again. So the group home was trying to make sure that these men had the correct services.
1 second.
Mr. Chairman, if I may, the introductory comments said SB 454, and I do not see
458.
Okay.
458, I'm sorry.
Thank you.
Sorry about that. Senator Austin, please proceed.
So my goal here is to actually do an assessment of people when they're incarcerated to find out if they have chronic mental illness. Often people who are not properly diagnosed when they are on the street, when they are suffering from a variety of things, whether they're a chronic schizophrenic or they have other diagnoses. Some often have never been diagnosed with their mental illness. So one, I would like to see us do a real health screening. The Sentencing Commission did a report which indicated that 80% of female inmates are chronically mentally ill and 28% of male inmates are chronically mentally ill, having suffered trauma during their lives or for a variety of reasons. I think we have to figure out what we're actually dealing with. It's very clear to me as someone who worked in the Department of Corrections for 21 years that the number of chronic people that are chronically mentally ill have increased dramatically since I was there. When I first started working there in the late 1989, the number of chronically mentally ill patients or inmates were about 4 or 5%, and the numbers have only increased. I do believe we're using our prison system as a quasi mental health facility because there just is not enough supportive housing around the state. I think that this is an extremely important issue. And if we truly want to decrease the population within our prison system, this is something that we can do just by seeing who is chronically mentally ill. So I do appreciate you bringing this bill up. I stand ready to answer any questions.
Thank you, Senator Austin. Comment, question from members of the committee. Comment, question. Representative Fishbach.
Thank you, Mr. Chairman. Good afternoon, Senator. Thank you for coming and giving your testimony here today. I do agree, I think, with everything you just said. It's very important, mental health screening, the incarcerated. The language before us inserts OPM, though, in this process, this review. Did you have any position on whether or not adding that additional administrative agency would perhaps hamper the reporting that's required under this?
I don't think OPM should be a part of this at all. From my perspective, they are people that look at the dollars and cents, not at the policy itself. I think that DEMIS, the Sentencing Commission, and the Department of Corrections itself should be involved in figuring out exactly what we can do to increase the number of screenings are being done, and that they're being done they're being done with actual training in how we assess mental health screenings.
Yeah, I agree, because it's not about the dollars and cents here.
No.
And I also noticed that the reporting is going to Judiciary, this committee, Public Health and Appropriations, And I believe you're the chair of the Public Safety Committee.
I am.
Do you, I mean, I know that through public safety and all of that, you know, may have knowledge or a need to know what's going on here. Would you find that to be an appropriate reporting committee as well?
Public safety doesn't really deal with the Department of Corrections. The committee that has cognizance of the Department of Correction is Judiciary. I have no problem if you want to include public safety, but it's not been within our bailiwick over in public safety, at least in the last number of years that I have been either on the committee or a chair of the committee.
Okay, I know there is sometimes overlap in that, you know, in various areas between this committee and public safety, and I just wanted to be able to ask about that. So I thank you for your comments, and as I said, I agree with just about everything you said today. Thank you, Mr. Chairman.
Thank you.
Representative Howard.
Thank you, Mr. Chairman. Senator, I just want to welcome you to the judiciary. Thanks for testifying today. You know, one thing that we've seen down in southeastern Connecticut, I just want to give you an opportunity here because it's relevant to comment on it, is, and I think you sort of touched
He froze or I did.
on it, is an influx once Norwich Hospital was shut down.
So I'm not certain if did he freeze or did I?
I think a lot of freezing happened because I froze too. Or Rep Howard, I
think I know. Yeah, I think I know what he's asking. I can make an assessment, I do believe. So the Norwich State Hospital, when the Norwich State Hospital closed and Fairfield Hills closed, there were no, what was supposed to happen is those dollars under then Governor Rowland were supposed to be put into supportive housing environments and start the reintegration of people with chronic mental illness into the communities. In Norwich in particular, because there were downtown areas in both New London and Norwich, the people landed in those communities, but they had no services available for them. Now we do have Reliance Health, but that is not that does not necessarily provide all the supportive housing that people require. And instead, what we have ultimately done is require our law enforcement to become people who understand anybody who has chronic mental illness. We flood our judicial systems with people who have chronic mental illness. And we ignore this whole system of people who, instead of recognizing that chronic mental illness, just like diabetes, just like cardiac issues, is a true condition, we are essentially avoiding the issue and putting people in great jeopardy, in my opinion.
Yeah, thank you, Senator. Hopefully you can hear me better now. And I don't disagree with what you said. I agree with you know everything you had to say today. And I think that, you know, when you look at that holistically, and it involves a lot of things. It involves, you know, the law enforcement, cable, which we do speak about in public safety often. But to get this sort of reporting so that the legislature can get a real good vision of what's going on and how, you know, our judiciary system is flooded with people who are actually mentally ill, I think is really a step in the right direction. I hope it moves swiftly. So thank you for being here. Thank you for advocating for the bill. And thank you, Mr. Chairman. I apologize for the technical issue.
Wasn't your fault. Comment or question from members of the committee? Comment or question? If not, Senator Austin, I think you already know where I stand on this bill. Been trying to have this conversation for a long time. I think also the leadership of this committee has engaged the DOC on this issue. So I think this bill is important. It's timely. What we say we know is only a very small and not as clear as we believe picture of the mental health issues within our prisons. So thank you for your advocacy. Thank you for providing your testimony today, and enjoy the rest of your day.
I will. I'm going to go back to appropriations now. Talk to you soon.
Where you were going. All right. Next, we'll hear from Ryan Bamia, followed by Sarah Egan.
Thank you, Mr. Chairman and members of the committee. I'd also like to thank Chairs Winfield and Staffstrom for your leadership on HB 5390, which I'll be talking about today. My name is Ryan Bamier, and I'm a second-year law student and member of the Lyman Center at Yale Law School. I'm also a co-author on written testimony filed in conjunction with this hearing. I'm happy to answer questions about any aspect of that testimony, but today I'm going to be speaking specifically about the inefficiencies of the incarceration lien, also known as pay to stay. First, I'll talk about the lack of transparency issues with how the money is collected. Next, I'll discuss how this bill does not help victims or the Department of Corrections, DOC. And finally, I'll address why repealing this bill will not affect the state budget, but poses a disproportionate burden to those who the funds are collected from. So turning to the transparency issue, there is no evidence the DOC is charging for the actual costs of incarceration, such as the cost of food, beds, or programming at prisons. Our research has not yet yielded a definitive method by which costs are calculated for an individual. However, we do know that the prices have changed and risen dramatically over the last 30 years. Documents received from the Department of Administrative Services, also known as DAS, demonstrated that in 2002, rates for per day per diem were around $96. In 2019, that rate was up to $224. When DOC informs DAS of these rates and the cost of incarceration, they do not provide an itemized list or any equation for their overall assessed cost. Given that the incarceration lien appears to have no connection between the actual cost of incarceration or the economic realities of those who are incarcerated, the pay to stay practice serves little purpose other than to punish individuals who are already serving their sentences. Next, this bill does not help victims or the DOC. The money from the pay to stay lien has no connection to the budget for DOC. Sources at the DAS have explained that none of the money collected on the incarceration lien goes back to the DOC. Moreover, the money doesn't go to the Connecticut Victims Funds either. So repealing this lien would not hurt victims in any way. Instead, the money goes to the state's general funds. And that brings me to my third point. Repealing this bill would not affect the state budget, but it does pose a disproportionate burden on those whose it's collected from. Pay to stay is cost inefficient, as it only raises minimal revenue for the state. In 2019, the funds the state of Connecticut collected for the incarceration lien was around $6 million. That $6 million is an extremely small fraction of the overall state budget, representing less than 1%. However, our research and interviews have demonstrated the extreme impacts that $6 million has on those returning home from prison. With such a small benefit to the state and such a high negative impact on individuals, it is clear that the pursuit of these liens is inefficient.
Thank you very much for your testimony. Comment or question from members of the committee? Comment or question? Seeing none, thank you very much for joining us this afternoon. Enjoy the rest of your day. At this point, I will be turning over to Representative Staffstrom. Representative Staffstrom.
Thank you, Mr. Chair. Sarah Egan.
Yes, good morning. Good afternoon. Senator Winfield, Representative Fishbein, Senator Kissel, Representative Staffstrom, all distinguished members of the Judiciary Committee. This testimony is submitted on behalf of the Office of the Child Advocate, the obligations of which are to review, investigate, and make recommendations regarding how publicly funded state and local systems meet the needs of vulnerable children, and to specifically investigate conditions of confinement for incarcerated youth age 15 to 20. The OCA strongly supports Senate Bill 459, which is a comprehensive approach to increasing transparency and accountability for the correctional system. Though I did hear Commissioner Quiros' testimony this morning indicating that there is proposed substitute language, and we look forward to reviewing that. That's excellent news. Transparency is a necessary foundation for change and is imperative for making progress in addressing conditions of confinement for incarcerated people. As many of you know, since 2016, the Office of the Child Advocate has been directed by state law to regularly review and report to the legislature regarding conditions of confinement for incarcerated children and youth across the state. The OCA published its baseline audit in January 2019, a follow-up report in November 2020, which reports found significant concerns for incarcerated youth, including reliance on solitary confinement for children with psychiatric treatment needs, inadequate education for children with disabilities, and significant deficits in mental health programming. After the OCA's initial report, the U.S. Department of Justice Civil Rights Division launched a 2-year investigation of possible civil rights violations at Manson Youth Institution. The DOJ completed that investigation and released a report a few months ago in December, finding that there is reasonable cause to believe that conditions for children at MYI violate the 8th and 14th Amendments of the United States Constitution and the IDEA, specifically finding that isolation practices and inadequate mental health services seriously harm children and place them at substantial risk of harm. Our written testimony outlines the DOJ's specific findings, which are also available online. OCA has also found as recently as November 2020 that conditions for 18 to 21-year-olds at MYI were substantially worse than conditions for minors, with even more limited access to mental health treatment and even greater use of isolation. OCA continues to review these conditions for all youth aged 15 to 21, and we note that despite their extensive needs and some improvements to date, minor youth do not regularly participate in clinical group programming, including substance abuse treatment, and many continue to lack adequate educational services. OCA does note efforts to increase out-of-cell time for youth aged 15 to 21. However, we still see that some older youth still spend significant days in disciplinary confinement, including youth with significant mental health treatment needs. There's no question there's an urgent need for this comprehensive legislation, and to the extent that legislation is trying to achieve meaningful reform, these aims can only be realized through concurrent establishment of robust external oversight. OCA also strongly supports the goals of 458. We wanted to highlight that at any given time, there are between 40 and 50 incarcerated minor youth in the Department of Correction, where extensive research statewide and nationally shows that these children have significant histories of trauma and substance misuse.
Thank you, Ms. Egan. Your time has elapsed.
Thank you.
Questions or comments from the committee? Questions or comments from the committee? If not, I know we have your written testimony as well. So thanks for being with us this morning. Or afternoon now, I guess. All right, next up will be Melinda Tuhus.
Thank you. To the co-chairs, ranking members, and all members of the Judiciary Committee. My name is Melinda Tuhus. I live in Hamden, and I'm a member of Stop Solitary, Connecticut. I was a journalist for 40 years, where I focused mainly on two issues, the environment and criminal justice. I'm speaking in strong support of the 2022 PROTECT Act, SB 459, which would treat incarcerated persons in Connecticut like human beings and also support correction officers who have a very stressful job. Thanks to the General Assembly for passing the PROTECT Act last year, which was unfortunately vetoed by Governor Lamont. I'm delighted that with the conversation between Commissioner Quiros and Barbara Fair, we are much closer to getting a bill that is acceptable to all or most. 10 years ago, I had a minor experience of being detained, handcuffed behind my back, and held alone in a police van for a mere 10 minutes. Yet that was enough to create panic and distress. That drove home how the situation of incarcerated men and women is horrendously worse. It's scary having no control over your person and being at the mercy of individuals who maybe don't care very much about your well-being. I can't imagine how much worse my short jail stint would have been had I been alone in a cell instead of with friends. And I can only imagine how much worse it would have been if I were someone who had no financial resources or social and emotional support system, especially if I were Black or brown and basically someone whom society has already dealt a bad hand. According to the United Nations, solitary confinement of more than 15 days constitutes torture, and lifelong harm can result when someone is held even half that time. We should not be torturing people in our custody, yet Connecticut is doing just that. SB 459 creates an Ombudsman and Advisory Commission for Correctional Oversight, as you heard from the Commissioner earlier, to evaluate the operations of prisons, jails, and halfway houses throughout the state. It would provide transparency and accountability, which is mostly lacking now. Connecticut is one of just a few states without an oversight body, and we need it. The bill brings Connecticut into compliance with the internationally accepted Mandela rules that isolated confinement be used only as a last resort for the shortest possible term and never for more than 15 consecutive days. Even those in solitary must be allowed at least 5 hours out of cell daily to maintain their mental health. And the bill promotes correctional officer wellness by requiring that the DOC implement training and other strategies to support staff in mitigating trauma and its effects, such as burnout, substance abuse, aggression, and suicide. Our entire criminal, what I call injustice system, needs to be overhauled and humanized. Passing this bill is an important step toward that goal. And if I have a few seconds left, I would just like to point out that when Stop Solitary brought a solitary confinement cell into Connecticut for people to spend some time in, most people could not spend more than 1 or 2 minutes in there before they felt like they were going crazy. So thank you.
Questions or comments from the committee? If not, appreciate being with us. Next up will be Randall States.
Good afternoon. My name is Randall States, and I thank the distinguished members of the Judiciary Committee for the opportunity to speak in support of passage of PROTECT Act, SB 459. I'm a resident of New Haven and a retired civil engineer. I sincerely thank this body for passing the PROTECT Act last year. Governor Lamont vetoed the act last year and issued an executive order addressing some of the issues raised. I am here again to submit a statement urging this legislature to pass the revised PROTECT Act. Importantly, revised through discussions with Department of Corrections. And please follow through to see that this bill becomes law. The fact that the state of Connecticut continues to rely on solitary confinement is offensive and wrong. It is harmful to the incarcerated and their families, and it's ineffective for the greater good. The depth and long-lasting harms caused by solitary confinement haunts all of our lives. Solitary confinement does not create better citizens. It does not reduce recidivism, does not address mental health issues, does not teach job skills. It does not teach people to read, write, or communicate better. Solitary confinement serves no corrective function. The bill you're considering eliminates punitive, extreme isolation. After solitary confinement was banned in Colorado, the Colorado Department of Corrections saw a dramatic decrease in violence within the facilities. Dropping solitary confinement does more to reduce violence than imposing it. The PROTECT Act affirms the importance of maintaining social ties for an individual's rehabilitation. This bill supplements correctional officer wellness programs and training. It supports our correctional officers to mitigate the effects of job stress. This bill promotes transparency. Through discussions with the Department of Corrections, it presents a mutually agreed means to evaluate current practices and operations. This bill provides a means to address priorities in mental health programs, education programs, and supporting Department of Corrections personnel. These sentences are meant to be corrective, not simply punitive. I urge you to pass SB 459, the PROTECT Act. Thank you.
Thank you. Questions or comments? Seeing none, appreciate you being with us this afternoon. Next up will be Barbara Fair. Good afternoon.
Hello. Let me see, was it afternoon? Good afternoon, distinguished members of Judiciary Committee. My name is Barbara Fair, and I'm a licensed clinical social worker, a lead organizer for Stop Solitary, and a staunch supporter of human rights and racial justice. I'm here to provide unwavering support for SB 459, an act concerning correctional oversight and transformative change within Connecticut Department of Corrections. Let me first say that I commend the leadership of Commissioner Quiros, and I have been so rewarded having these conversations with him and his administrative staff, and that we were able to come to some agreement about what needs to at least be a first step in changing Department of Corrections. I cried a river after my youngest son was tortured inside a Northern Supermax prison. He entered Manson Youth, a 16-year-old promising hip hop artist and songwriter. He was a pretrial detainee facing misdemeanor charges, but he protested degrading treatment that was norm in the facility at that time. And so he was transferred to Northern once he turned 17. Northern, a place built to break people's sanctioned sadistic behavior. My son left Northern with a shattered mind, a broken spirit, and an inability to function in a normal manner. He was sent to Gardner, where DOC houses is seriously mentally ill. He was misdiagnosed as schizophrenic and heavily medicated for that disorder. Yet I knew his mental decline was the direct result of the traumatic experience he endured. As a clinician, I know the kind of brain trauma at his age could be irreversible, yet I continue to hope. Back then, I suffered panic attacks because I couldn't do anything to protect my son. Each day I had to manage my agony so I could make it through the workday while worrying about my son's well-being. I witnessed firsthand the irreparable harms isolation causes, and so I cannot rest until state-sanctioned abuse of incarcerated people is no longer an acceptable practice. No one should be allowed to degrade, humiliate, and abuse another with impunity. The executive order, no matter how well-meaning, does not incorporate what's most important, and that is independent oversight. Connecticut DOC is one of the few states with no independent oversight, and you have to ask yourself why none of the facilities are accredited. DOC asks for more professional staff to provide the community standard of care, and I believe that's very necessary. But to recruit and retain staff, DOC must first make a budgetary adjustment to provide competitive wages and benefits to align with the private sector, and they must change the environment because many people say that their policies conflict with their code of ethics, do no harm. Change comes with resistance. Expect that. Expect sensational stories to justify continued isolation. Know that many other states have already implemented policy addressing people being caged all day, and violence has actually decreased with more time out of cell. I'm asking legislators to vote to pass SB 459, the PROTECT Act. Vote with your moral integrity and not with a political party, because humanity is not a political issue. At the same time, I'm asking that you pass HB 5390, repealing the State of Pay Act, because it puts a pressure on the Connecticut's poor to pay for their own oppression. It's time Connecticut legislators do what's right for all of Connecticut. Thank you for your time and the opportunity to be heard.
Thank you, Barbara. Questions from the committee? If not, Barbara, I just want to obviously thank you for your unwavering, obviously, advocacy on this issue and advocacy for some of the most marginalized in our society. I know this has been, not just an advocacy mission, but a personal one as well, given the story you just told about your son and his experiences. And, I think what it sounds like the deal that was struck last night is a win for everyone. And certainly I know I look forward to supporting it out of this committee next week. But it's a true testament to you that you were willing to compromise and to spend as much time as you were with the Department of Corrections folks and seek input and along the way. That's how the best legislation gets passed, frankly. Yes. You are no professional lobbyist by any stretch of the imagination, but you certainly know this system and have learned this system as well as anybody in a short period of time. So congratulations to you.
Thank you.
Representative Palm.
Thank you, Mr. Chair. Hi, Ms. Barbara. I just wanted to thank you also for coming before us. I echo what the chair said, and your fortitude and your strength and your commitment do every parent proud. And I'm sorry for what you've gone through, and I hope we can make real lasting change out of your pain. So just thank you, and my hat is off to you deeply.
And can I say something to Senator Austin's comment about the chronically mentally ill? Because my son is one of those people. And see, that's the problem with this situation, is that decades later, he's still suffering. He's actually in the hospital now. And the state doesn't remedy that for me. This may be a lifelong suffering for him. And so we must stop doing what we're doing to people, because my son is not the only one that's walking around the Haven who's been destroyed by this system.
Representative Porter.
Thank you, Mr. Chair, and good afternoon, Ms. Barber. I'm glad to see you. Sorry to see you under these circumstances, but just want to thank you for continuing to fight the good fight, you know, for a good cause. I had to take a call, so I missed your testimony, but I do know your story, and I did hear you just talk about the impact that this has had on your son, which is something I wanted to ask you about because I knew you'd be coming up to testify. I know it has been decades. I know your son, and I know the challenges that he faces, but can you just briefly talk about not just the impact that this has on you as the mother, but on the family and on the community when they come back damaged to the degree that your son has been damaged by the system?
You're right. It doesn't just impact him and me. It impacts our entire family because we are in so much pain because we're such a close family. So we are in a lot of pain when he's going through these things and we can't do anything to help him. And so I decided instead of being angry that I was going to channel my energy into trying to help other people who don't have an advocate out there fighting for them because there's so many of our people being destroyed little by little through this carceral system.
Thank you. I was trying to find my mute button. I do appreciate, you know, the courage and the strength that it takes. I am too a mother of a son that has been incarcerated, and I know that pain, and it lives with you forever. It never goes away. They do come back different. And my prayers and my thoughts will always be with you, but I have such tremendous respect for you and admiration for the work that you do and the way that you're able to keep going despite the pain and the anguish.
Yes.
So thank you. And I look forward to speaking to you offline. Thank you, Mr. Chair.
Thank you.
Representative Walker.
Thank you, Mr. Chair, and good afternoon, Barbara.
Hi.
It's wonderful to see you. I mean, I want to align myself with the comments that my sister just made about how dedicated you are to trying to change the wrong in the system that we've all struggled with for so long. The one thing I know, because Senator Austin, she talks about you with incredible admiration for how hard you have tried to champion these issues. And we talk about the importance of mental health, especially with our returning citizens, but those that are in the system. One of the things that I learned, which was so dramatic to me, was when doing juvenile justice advocacy, that many of our kids in the system that have been arrested have severe learning disabilities and behavioral issues that come well beyond what we even understand. IQ levels lower than 70, and we're expecting these children to understand all of their behaviors. And so therefore, I thank you for all of what you do to make sure that people hear those voices. And God bless you for your fortitude, and take care of your family. Your family is wonderful and you love them madly. So thank you for your advocacy.
Thank you. Thank you.
Representative Sims.
Thank you, Mr. Chair. And I want to echo a lot of the comments made by my colleagues here. And it certainly is heartfelt knowing and hearing your story, but knowing that you come forward with your bravery and really sharing that testimony with us. These type of issues are too far familiar with individuals around this state and in our various communities. So I really want to just thank you for your bravery and for your commitment to the state and to the judicial system and to your son. We really do appreciate your advocacy, and I just want to thank you for that. Although I'm not familiar with your story, but I do share some of the same concerns of what's going on with our judicial system and our correctional facilities around the state. So again, thank you so much for your testimony. Thank you, Mr. Chair.
Can I add one thing you made me think about? When I met with the union, one of the first things the union president said is that 90% of the people in prison are no threat. They cause no harm. They just want to do their time. And so I said to him, that's a good place for us to start our conversation, because if 90% are no problem, Why are we doing what we're doing to so many people when we should be learning how to maintain that 10%?
I couldn't agree more with you on that. And I will say, I have a nephew who's been incarcerated for some time now, and it's a shame, how how the system actually abused their authority in these situations where, for instance, my nephew didn't clean up a rec room that he wasn't supposed to clean up, and they put him in isolation for 90 days. So those are the type of mistreatments that we have to fix. And I do again just thank you for your advocacy and bringing a lot of that testimony to us, so that way it gives us more clarity on how we should legislate and approach these issues. So again, Thank you so much.
Thank you.
Further questions or comments? If not, Ms. Fair, thanks again for being
Thank
with
you.
us. All your work.
Have a good day, everyone.
Colleen Lord will be next.
Chairs Winfield and Staffstrom and distinguished members of the Judiciary Committee. My name is Colleen Lord of West Haven, and as a NAMI Shoreline Board member and a Stop Solitary Connecticut volunteer, I support Senate Bill 459, also known as the PROTECT Act, for correctional oversight. I'm also mom to Robbie Talbot, the gentleman in red, homicide victim in New Haven jail at the hands of corrections staff. My support of this bill is in hopes of ending torture and seeing humane treatment for those who are currently experiencing incarceration, whether for serious crimes, mistakenly convicted, or like my son, solely because of the lack of available mental health treatment programs in Connecticut, even for those federally recognized as disabled, such as Robbie was. Robbie was completely nonviolent and never hurt anyone in his life, brought to jail for a nonviolent breach of peace only 33 hours before he was killed. It's important to recognize that for those with mental illness, diversionary programs are often impossible to complete due to lack of services in Connecticut. Robbie's diversionary program was to get into a hospital for 3 months. Impossible in Connecticut. The DOC needs transparency. It's very rare that the public or even this distinguished committee can see what goes on behind locked doors of jails and prisons. However, in the case of my son's homicide, it is all on video. The 19-minute video is horrifying to watch, especially for me. Yet the truth must be conveyed to you all, and I would like you to watch it. I've since learned that people of color and those with mental illness are abused in custody much more than those who are healthy and white. I'm ashamed to say that I didn't know this until it happened to my Robbie. Most people don't know this, but it's very clear what was done to Robbie while he was sick and harmless on a shower floor. Excessive weapons-grade chemical agent directly in his face and mouth, 6 times what is allowed, abusive restraints, unwarranted and unmonitored solitary confinement, in a box filled with the weapons-grade chemical agent, so strong that 90 minutes later, when he was found dead and in early rigor mortis, EMT workers who came for his body were still coughing from the toxic fumes. The creator of this weapons-grade pepper spray agrees that it can and will kill when used in the manner that Connecticut uses it. Lieutenant Carlos Padro was sentenced to 1 year in jail, suspended, for stomping on Robbie's face in the shower, not for homicide. But I want to be clear that it is a myth that victims like my family want the killers inhumanely tortured. And it's a myth that solitary and chemical agent is only used on the most dangerous and threatening murderers. Abusive restraints, chemical agent torture, and solitary confinement is imposed on non-threatening, non-violent, vulnerable, and compliant individuals, simply for punitive reasons or convenience. Connecticut correctional officers spray weapons-grade chemical agent routinely as if it was a toy water squirt gun in your face. In closing, Connecticut needs SB 459 to codify the restriction of solitary confinement according to the Mandela rules. DOC staff need CIT-type training in the many aspects of mental illness as provided in SB 459. DOC staff need mental health evaluations for themselves. And above all, Connecticut needs the Ombudsman and Commission for Correctional Oversight to begin to fix this racist and discriminatory system in my dear Robbie's memory, and as a voice for all victims who seek ethical corrections. I support SB 459, and I thank
this committee, Ms. Fair, Commissioner Quiros, and all who worked so hard on this bill.
Thank you, Ms. Lord, and we appreciate you being with us. We appreciate your advocacy, and thank you for sharing your son's story with us. Next, we will hear from Deborah Pauls.
Hello, dear distinguished members of the Legislative Committee. I am Deborah Pauls. I have lived and worked in Stanford for 44 years, and I'm a social worker and a psychotherapist. As I approach retirement, I am choosing to put more of my time into supporting changes in our community that will make a difference for an individual's mental health. I testified for the PROTECT Act last year, and I want to thank you for its success in our legislature. I was quite disheartened, however, when the governor vetoed it and used his executive powers to attempt to address some of the abuses. Stop Solitary, of which I'm a member, has worked hard to listen to the concerns of legislatures, those of the governor and the DOC. From this in-depth listening, changes have been put forth that strengthen the bill and address the larger concerns. These changes are succinctly covered in an attachment. Solitary confinement as they currently practice in Connecticut does not rehabilitate a prisoner. It produces a frightened, anxious, angry, depressed person who possibly dissociates or swings from depression to mania. He or she returns to the general population in a mental state that is likely to result in a worsening of the very behavior for which they were sent into isolation. Staff is expected to maintain a safe and calm and traumatized people. When they are released, we expect them to return to the community with little to no support and lead productive lives. That expectation is seldom met under the practices of solitary confinement. This is not the formula for a mentally healthy person. It's not the formula for the well-being of the staff. It is not the formula for a safe community. An exception in Connecticut has been the TRUE program for young adults. And I hope that this will, once COVID is finished, that will be truly expanded and reestablished. Senate Bill 459 is a reimagined bill, one that provides changes in the practice of solitary confinement, changes that have proven successful in other states and other countries. For many years, I have lived in Connecticut. I have been proud that our state ended the death penalty. I am proud that our state was one of the first to end discrimination against the LGBTQ community. And I am proud that our state has a robust Medicaid program and other social services for the most vulnerable people among us. I am proud that we have a very strong public school system. But I am ashamed that we treat incarcerated people in our care with such cruelty and abusiveness that in reality we are torturing these people.
Ms. Paul.
Okay, thank you.
Thank you very much for your testimony. And I know 3 minutes does come quick, so just a public service announcement for folks. We still do have a lengthy list. Those who have submitted written testimony, we have that. So there's no need to try to jam it all into the 3 minutes. If you could hit your highlights for us, that would be appreciated. But thank you, Ms. Paul, for
welcome. Thank you.
All right, next up is David Akua-Mensah.
Thank you, Representative Strastrom and distinguished members of the Judiciary Committee. My name is David Akua-Mensah. I'm a student at Yale University, and I'm speaking today to voice my support for Senate Bill number 459. It would limit the use of solitary confinement, create a 12-member Commission of Correctional Oversight, develop residential rehabilitation units for vulnerable persons, place strict limitations on the use of in-cell restraints, provide mental health resources for DOC staff, and forbid disciplinary restrictions on social contact. Last spring, this bill passed both houses of the CGA with bipartisan support before it was met with the governor's veto. Governor Lamont replaced the bill with an inadequate executive order that has failed to provide incarcerated persons with a basic level of human dignity and failed to codify its directives into law. Governor Lamont claimed to support the goals of the 2021 version of this legislation in his veto announcement. He claimed that his executive order was stronger than the Mandela Rules, the UN guidelines for the treatment of incarcerated persons, and he's wrong. According to Rule 45, solitary confinement must be subject to independent review. His executive order fails to provide independent oversight of the Department of Corrections. Senate Bill number 459 would create an independent commission of correctional oversight that can visit DOC facilities, confidentially communicate with incarcerated persons and staff, issue reports and recommendations, and hold public hearings. According to that same rule, solitary confinement cannot be used on persons with mental disabilities, physical disabilities, and children. The governor's executive order fails to protect mentally ill, physically disabled, young, elderly, and pregnant people from traditional confinement. Senate Bill number 459 would instead refer them to residential rehabilitation units. According to Rule 47, the use of restraints is only legitimate when there is no lesser form of control that is effective in controlling an actual risk. The governor's executive order fails to limit the use of in-cell restraints. Instead, it required the DOC to outline a report about their efforts to decrease the use of in-cell restraints. Senate Bill number 459 would instead limit the use of in-cell restraints to serious emergencies only. These are only a few of the discrepancies that this bill seeks to address. And in conclusion, I urge you to favorably vote this bill out of committee. Governor Lamont and, as we heard earlier, Commissioner Quiros understand the responsibility Connecticut has to ensure the dignity and health of incarcerated persons and correctional staff. To make certain that solitary confinement is not abused in any correctional facility in Connecticut, this bill must return to the governor's desk in full form. Thank you for your time.
Thank you, sir. Questions or comments from the committee? Seeing none, appreciate you being with us this afternoon. Next up will be Apurjita Kafal.
Good afternoon, distinguished members of the Judiciary Committee. I'd first like to thank you for allowing me to testify today. My name is Apurjita Kafle, and I'm a student at Yale University, and today I wish to express my strong support for HB 5390. Under the current status quo, prisoners are responsible and charged to pay for their incarceration. If the inmate cannot pay, the state also has a claim against the inmate's property. To put it simply, the current system places a financial burden on inmates for seeking resources that fulfill their basic needs. This is largely unjust and must be removed immediately. If passed, HB 5390 would encourage the state to more efficiently and effectively repay incarcerated individuals for costs incurred when they were incarcerated, moving away from our stringent pay-to-stay system. Moreover, it establishes that if the inmate passes away, the state has to take proactive steps to alert the next of kin of estate ownership before claiming as theirs. Our current structure punishes prisoners for seeking out basic resources and unfairly exploits their right to property. This procedure is unacceptable. In 2020, Connecticut became the first state in the country to make prison phone calls free. This was a monumental step in equity and advancing the rights of prisoners and was met with national praise. Connecticut must then build upon this momentum of further criminal justice reform and work towards alleviating the financial burden that is placed on incarcerated individuals after release. The persistence of the current system disproportionately affects lower income and minority populations. Connecticut is one of 7 states that maintain a Black-white disparity larger than 9-to-1 in prisons. In choosing to keep the status quo, Connecticut is choosing to disproportionately punish Black and minority populations. The current system of imposing fees on incarcerated individuals does more harm than good. In fact, when incarcerated individuals leave prison, they often leave with immense prison debt. Connecticut's prison debt system charges people $224 per day, accumulating to $81,000 per year for the cost of their incarceration. This is an abhorrent amount and acts as a financial prison for those who have just been released. According to Harvard Public Policy Institute, by disproportionately burdening poor people with financial sanctions, by jailing people who lack the means to pay, many jurisdictions have created a 2-tiered system of criminal justice. Unchecked, these policies drive mass incarceration. Excessive fees and fines needlessly enmesh poor people in the criminal justice system by spawning arrests, court proceedings, periods of incarceration, and other modes of supervision for those who lack the ability to pay. The passing of HB 5390 is an important step to prevent this continuation of mass incarceration in Connecticut. I implore Connecticut to make history again by passing this law. Thank you.
Thank you. Seeing no questions, appreciate you being with us this afternoon. Next up will be Robert Gillis. Robert Gillis with us?
Yes, excuse me. I had to find out how to unmute myself. I'm going to advocate in favor of the passage.
So your video is also off. I don't know if you.
Oh, the video is off?
Should be down next to the mute button. Okay, now we got video, but we have not even muted. There we go. We're good.
Okay, fine. My 3 minutes starts now. I was a career employee of the Department of Correction from 1970 until 2006. And during that time, the incarcerated population rose from about 3,000 offenders to somewhere below 20,000. You can safely say that I've probably seen almost everything during that time. I'm also presently a member of the steering committee of Stop Solitary. The principal value of the bill is that it's a significant first step in reversing the punitive and oppressive culture encountered by incarcerated people that's manifest in some of our facilities. The bill lays out a number of strategies to reduce in-cell time and to introduce an ombudsman to provide much needed assistance in resolving claims of reported harmful situations encountered by individual offenders. It also provides for a commission composed of representative stakeholders of diverse backgrounds and experience statewide. Connecticut is one of the few states which lack any formally constituted body to oversee or evaluate the operations of its correctional agency. I would stress that the commission does not have the power or the mandate to sanction, approve, or in other ways interfere with DOC's activities. In addition, I would point out that this bill, unlike last year's iteration of the PROTECT Act, was composed in consultation with the commissioner, as you've already heard today from Commissioner Quiros, and with officers of the correctional employee unions. No one will be blindsided by it. The current use of isolated confinement is relatively new, and it stems from the necessity posed by events of the 80s and 90s. And believe me, that was a bad time for corrections. My own experience as ward at New Haven Correctional Center from 1991 to 1993 bears this out, and it stands as an indelible example of the dysfunction of the time. As a result of several factors, extremely punitive measures were established and introduced in many quarters. That's when the SRG management plan was perfected, and the legislature got involved, suspended the use of good time, and also another punitive action was the passage of the cost of incarceration bill, which fortunately is up for review this very day. Most of these measures were appropriate and perhaps warranted at the time. Punitive practices and the environments in which they have been encouraged have a very long half-life. It's now time to reassess the use of excessive in-cell confinement and the associated damage which incarcerated people endure. There's an entire generation of correctional employees who've come to believe that the controls and tools of the 1990s are essential for the day-to-day performance of their duties. We at Stop Solitary believe that the effective and focused direction by DOC leaders can ensure the successful implementation of SB 459.
Thank you, sir.
Our legislature, excuse me?
Your time has elapsed, sir.
Okay.
We
Pass the bill. The time has come.
Got it. All right. Thank you for being with us this afternoon.
Good.
We appreciate it. All right. Darnell Crossland. Stephen Mascaro. I think he's, there we go.
Good afternoon.
How'd I do on the name?
Committee. Can you hear me?
Yep, you're good.
Thank you for allowing me to speak on behalf of the 459 bill. Let me start this up. My name is Officer Mascaro, and I worked in multiple facilities over a period of 10 years. I currently work at a level 4 facility in Cheshire, Connecticut. I have a bachelor's degree in criminal justice and extensive training on correctional procedures. One of the main objectives of Bill 459 is increasing the amount of out-of-cell time for all offenders. One of the proposals of increasing recreation time is to ignore safety guidelines, specifically facility lockdowns. When a facility is placed on lockdown status, the offenders are confined to their quarters for that shift. If the lockdown lasts for more than 24 hours, they are allowed to utilize the telephone to communicate with loved ones and utilize showers for personal hygiene in a controlled manner. Facility lockdowns are only utilized in emergency situations to keep the offenders and the officers safe. Staffing levels within the facility have become the most prevalent reason for initiating lockdowns. It has to be determined that the facility cannot safely operate or properly protect the offender population for a staffing insufficiency to cause a lockdown. To increase the amount of recreation of an offender, which would improve their overall mental well-being, would be to focus on staffing facilities correctly and keeping them safe instead of jeopardizing the safety of everyone and removing the use of lockdowns. This bill also calls for canceling current training schedules that would keep offenders in their cells for hours. The proposed increase of recreation from 4 hours a day to 7 hours a day may seem like positive towards the general population, but it will have the opposite effect. There is insufficient time within the day to conduct this due to operations at the facilities. Facilities conduct, on average, 2 population counts on day shift and 2 counts on second shift. Population counts are conducted to verify the location, health, and well-being of the offender population. Facility counts take, on average, 1 hour to complete after the offenders are recalled to their housing assignments. Other programs such as meals, commissary distribution, cell cleanup, religious programs, medication distribution, laundry collection and distribution, educational program, razor distribution, to name a few, all take place within the housing units themselves and cannot be conducted during unit recreation. The only way to conduct this amount of out-of-cell time is to increase the number of offenders out at one time. This would mean that there would be over 100 inmates out at once, which would raise the ratio of over 50 offenders per 1 officer. The Department of Corrections currently has a hybrid program, which does run in this fashion with a curated group of respectful, hand-picked offenders, which specializes in reintegration into society. This unit, which has the best behaved offenders, has a minimal staffing levels of 6 officers with 1 supervisor and 3 counselors per shift. To run in this fashion, the average housing unit would need to mimic the same staffing levels compared to our current staffing levels, which only contain 2 officers per housing unit. I urge this committee to get the financial plan of additional costs to run facilities in this fashion before making your final decision. I would rather see more money going to improving the quality of life of offenders, which would include improving mental health, rehabilitation programming, training for officers, and improving the physical structures of outdated and unsafe buildings. Thank you very much for your time.
Thank you, sir. Questions or comments from the committee? Seeing none, appreciate you being with us. Ed Hawthorne. Ed Hawthorne. Amanda Tower.
I am here. Thank you. Chairman Winfield, Chairman Staffstrom, and members of the Judiciary Committee. My name is Amanda Tower. I've been a correction officer with the Connecticut Department of Correction for 8 years. I'm also a steward for AFSCME Local 391 and a student of criminal justice. I see myself as someone directed by compassion and empathy, but also informed by reason. Therefore, while I believe in reform and oversight for correcting systemic problems, I have to oppose Senate Bill 459 as written. Unfortunately, this bill is short-sighted and lacks the careful analysis of our organizational memory, which has served to inform the administrative directives governing our operations. The department's mission includes being a leader in progressive correctional practices. So to assume our current practices are anything less than evidence-based is unhelpful at best. While I agree that more rehabilitative processes would greatly benefit the incarcerated population, state government consistently fails to provide the resources, staff, and funding necessary. Passing this bill will not change the inadequate budget, and the so-called reforms we have seen pushed through already have simply consolidated the small percentage of offenders who are dangerous and disruptive. The closure of facilities has left us with less space to provide rehabilitative programming and separate the population according to their needs. Many necessary resources should have been in place in the community to prevent incarceration in the first place, particularly for those with mental health concerns. Identification and de-escalation of mental health crises, assistance with substance abuse, transitional services, these will help the majority, but only if we have the space and funding to manage them. Increasing the volume and variety of staff in our prisons and providing them with more frequent specialized training off-site should be mandatory. But all the treatment and training will be useless if we have the tools used to manage emergencies and further penological interests taken away from us. I'm sorry. All the out-of-cell time we can possibly facilitate will not magically create more resources for the affected population to share. It will likely create more disruptions due to the lack of things like phones, televisions, and seating in celled housing units. We are already at a point where we feel our hands are tied. Many of our past practices seem meaningless, and the incarcerated population has only grown more emboldened. Our prisons have already become more dangerous following executive orders and political pressure being put on our administrations during a global pandemic and unprecedented staffing crisis statewide. I'm urging you, alongside thousands of my peers and other corrections employees, to be a part of the solution which allows us to do our jobs while protecting the public and the incarcerated population. We can work towards a better future, but we cannot simply strip away the management practices that have made our prisons as effective as they are. We cannot pass dangerous bills like Senate Bill 459 without proper input and revisions. Thank you.
Thank you. So I'm going to turn this over to Senator Winfield in a second, but I know we still have a number of folks to testify, including corrections officers. So, Ms. Tower, this is not necessarily directed at you, but I want those listening to know your concerns have been heard. We do have the written testimony on the bill as previously written. I think, as was said at the outset, the bill as presently written is not the bill that is going to move forward out of this committee. So we hear you. All right.
I can definitely appreciate that. I'm looking forward to reading the bill as revised and sharing that with my peers as well.
Absolutely. Yep. Senator Winfield. Senator Kissel.
Thank you very much, Mr. Chair. Corrections officers, Tower, appreciate you coming here. I think you indicated you're a union steward at 391. Those are my folks up here in North Central Connecticut. We did have testimony from Commissioner Quiros. As Chairman Staffstrom indicated, this bill is being modified and changed. And I'm wondering, the thing that you could answer for me is, do you feel confident that the work being done by the administration and especially Commissioner Quiros, who I complimented because I've universally heard positive things about his leadership of the Department of Corrections. He worked his way up through the ranks here in Connecticut. So it wasn't one of these global searches where someone just sort of parachutes in and doesn't really know how we do things. But are your concerns going to be reflected in the end product? Do you feel confident about that? Obviously, you're going to want to review it and read it. But by the way, I'm reaching out to you. I don't know if you live in my district, but it doesn't matter. I'm sure if you have 391, you work in my district. And I want you to know that I want my COs to be confident that when they go to the work, it's the safest environment that they can be in, all the circumstances put together. So I just would like your feedback regarding that.
As I said, I will take the rest of the day probably to read through this and then some. It was handed to me earlier this morning after I heard Commissioner Quiros mention that there were revisions. So I'm looking forward to finding out what those revisions are. I've heard him speak. He's very, well educated on this. And if Stop Solitary and the legislature is listening to his input, we value that. But we would also like to be heard. And there are many concerns with many staff members throughout the state about the safe conditions currently without putting anything else in place. I can't speak to anything specifically, without going into too much safety and security detail. But people are generally worried when things start to change. But as I said, I'm definitely pro-reform. I just think that there's a lot of questions still up in the air, I guess, as far as rehabilitation goes. We definitely need to start doing more for the incarcerated population. That is true.
Okay, well, we've got about 6 more weeks to go in this very, very short session. And Mr. Chair, I do acknowledge that we have a ton of people and there's no reason for everybody to sort of double down 15 million times on the same issue. We are listening. I certainly don't want to vote in support of something that's going to endanger anymore the COs, the boots on the ground. I have been monitoring what's going on. I am concerned about the increase in workers' compensation claims and other things that may be a reflection as to what's going on within the facilities. Let's keep an open line of communication. I'm reaching out to 391. You're the steward. I'm reaching out to you. I work for you guys, whether you live in North Central Connecticut or not. Let's do this together, and hopefully it'll be a kumbaya moment before the end of session. Okay?
Looking forward to it.
Great. Thank you, Mr. Chair.
Yep, thank you, Senator, and certainly I concur. Testimony on a dead bill is testimony on a dead bill. Representative Porter.
Thank you, Mr. Chair, and thank you, Officer Tower, for being with us today. Just a quick question, because you did reference rehabilitation. Do you believe that, solitary confinement is a rehabilitative tool, or is there something that we could be doing better in the form of rehabilitation that would ensure the safety of everyone, not just the officers, the inmates, the nurses, everybody?
My personal view would be that penological interests are furthered in specific safety and security situations to use things like isolated confinement. I do have concerns as someone who is very active and well known amongst the incarcerated population at my facility with the way that we approach mental health, particularly mental health crises. I'm sure that many of you have heard from attorneys representing some of these men that do wind up on some kind of status, and they are not necessarily getting the treatment that they need. But it's for the safety of themselves, others, and the institution. There's more that could be done as far as the programming and treatment that could be offered, in my opinion.
Thank you so much for that. And I do appreciate your input, being boots on the ground and closest to this problem. And I believe that if we're talking rehabilitation, there's certainly other means to get to that outcome, especially when solitary confinement has been proven to be something that exacerbates mental health, along with any other problems you may have. So thank you again for making the time to be here. And thank you, Mr. Chair, for the opportunity.
Sure. All right, Ms. Tower, thank you for being with us today.
Thank you all.
Next up is Donna Hirschko. Donna Hirschko. How about Janali Cobb? Janali Cobb. Vamsi Cornero.
Yes, that's me. Yeah,
Go
thank
ahead,
you
sir.
for the invitation. So to the distinguished members of the Judiciary Committee, thank you for the opportunity to speak today. My name is Dr. Wamsi Kineru. I'm a resident of West Hartford, Connecticut, and a faculty member at the University of Connecticut School of Medicine, and a clinical psychologist with a specialization in working with survivors of trauma. As a member of Stop Solitary Connecticut, I'm writing to express my views on solitary confinement and my strong support for Senate Bill 459, also known as the PROTECT Act. The PROTECT Act codifies into law Governor Lamont's executive order to ensure that no one is in solitary confinement beyond 15 days, increases the minimal time out of one's cell to 5 hours per day, and provides a powerful structure for oversight. It's been said that justice is what love looks like in public. I know that each of you is here today because of a love for your community and a deep commitment to service, compassion, and justice. I ask you today to let compassion guide your action. Join me in standing up for the rights of all human beings by voting to support the PROTECT Act. In my practice, I work with survivors of trauma, many of whom are also involved in our criminal justice system. Trauma and incarceration have tremendous overlap, as approximately 90% of individuals who are incarcerated also have a significant history of adversity and trauma. While there are many treatments that can benefit trauma survivors, a common thread is the presence of safe, stable, nurturing relationships, as well as the opportunity to experience patterned, regulating, and rhythmic activity. Both of these help to regulate our nervous systems. Solitary confinement could not be further from this treatment standard and disregards the basic concepts of human rights and dignity. It undoubtedly re-traumatizes the 90% of people who entered into our incarceration system with histories of trauma. The practice is torturous, oppressive, and inhumane. And in addition to these serious ethical concerns, the deprivation and dehumanization embedded in this practice undoubtedly worsens the health of an already highly vulnerable population. How might this practice contribute to worsening someone's health? In other words, what happens in the brain and body of someone in solitary confinement? The stress and isolation of solitary confinement is constant and unrelenting, which causes individuals in such confinement to have a chronic overactive stress response, also known as the toxic stress response. The toxic stress response can lead to lasting changes in brain structure and functioning, including significant overactivity in the amygdala, or the brain's fear and reactivity center, and an inhibition of the prefrontal cortex, or the seat of language, thought, and judgment. Additionally, this response is associated with many severe health consequences, including doubling the risk for heart disease, respiratory illness, behavioral health issues, and can reduce a person's life expectancy by up to 20 years. More than 90% of incarcerated people will return to our communities. Do we want them to be broken, unable to connect with others, and to struggle to be of service or able to live a life that is marked by contribution and meaning? How can we support individuals so that they're not re-traumatized by their incarceration? How can we become more curious about humane solutions as opposed to modeling cruelty and vengeance? Supporting Senate Bill 459 is an important step in this direction. Thank you very much for your kind attention and the opportunity to speak in support of Senate Bill 459.
Thank you, sir. Appreciate you being with us this afternoon. Next up will be John Cipoli.
Hi, my name is John Cipoli. I'm a corrections officer at Cheshire Correctional, and I'm testifying on behalf of Corrections Local 387, Council 4. As a collective, we have significant concerns with Senate Bill 459, as you've already heard. It is safe to say that this bill would put staff and inmate safety at risk. Even though Bill 459 was put together with good intent, it does not reflect what the correctional employees and inmate population face on a daily basis. This bill is attempting to strip staff of their already limited tools utilized to deter negative inmate behaviors. The state of Connecticut currently has fewer than 10,000 inmates statewide in custody, a number that is nearly 5,000 fewer than 5 years ago in 2017. The state has been working diligently to reduce recidivism and to correct past practices when it comes to sentencing offenders. Now, those who are incarcerated are more serious and dangerous offenders, not just to correctional staff, but also to the inmate population. Bill 459 offers difficult changes in policies that are in place for a good reason. Having our current policies for handling inmates with the tools we currently have, such as handcuffs and OC spray, work as deterrent to prevent staff and inmate attacks. In the past year, there have been over 140 assaults on correctional staff, and that number continues to rise. If the little amount of tools we have available are stripped from us, how will we defend ourselves and others? How will we stop vicious attacks as they are happening to our partners and to the inmate population? How do you suggest we stop a convicted murderer from repeatedly going after another inmate? It is in poor judgment to make even more changes considering the difficulties and strains on the correctional system. Our facilities are understaffed, our officers are becoming burned out from the constant mandated overtime and stress of working in this environment. Having decisions made about the operations of correctional facilities by officials who've never had to walk in our shoes and see the daily routine of a prison is irresponsible. Rather than forcing new policy on the department, perhaps sitting down with individuals such as officers and collaborating would be a better alternative to find a happy medium. Corrections staff have and still continue to cooperate with new changes in policy. The union and correctional supervisors have urged members to follow the new rules and standards, even when they don't agree with them. They also stress the responsibility that we have, integrity and duty that we have as correctional officers. The Department of Corrections has always been jokingly called the Department of Change by correctional staff, but change is inevitable. It is particularly difficult in correctional environment when the changes are reckless and potentially dangerous to staff and inmates. Bill 459 requires an increase in staff on duty. That would be all staff, from officers and lieutenants to treatment staff such as counselors and mental health professionals, and a requirement that these staff are available in the facility 24/7.
Thank you, sir. So let me ask again, as we've asked others, have you received a copy of the proposed new language on this bill?
I have not, seeing as how it was just finished last night.
All right.
I wish I had time to go over it prior to writing this.
Yeah, I mean, look, my understanding is obviously, as often happens, right? Sometimes deals get struck at the 11th hour before there's, a hearing, a court appearance, a vote, whatever. So I hear you. I think testimony was that correctional officers have not been heard. I would respectfully disagree with that, based on, I think, the changes that have already been proposed and a newer version of the bill that is likely to be voted out of this committee next week. But please stay engaged with us. And
will there be another meeting once everybody gets to read the new bill?
There won't be another public hearing, but you can certainly submit emails to myself and to the other leadership of this committee. All right. Thank you, sir. Appreciate you being with us today. All right, Ileana Pujols. Norma Schmidt, I'm sorry.
Good afternoon, distinguished members of the Judiciary Committee. My name is Norma Schmidt. I'm a resident of Fairfield and a priest in the Episcopal Church in Connecticut. I've served in parish and healthcare settings for more than 20 years, and for the past 7 years have taught applied ethics courses at Fairfield University. I support SB 459, the PROTECT Act, because as a person of faith, I deeply believe we have a responsibility to treat our most vulnerable populations with dignity and care. As a person of faith, I believe the measure of our society is how we treat our most vulnerable members. As a person of faith, I believe we're called to practice mercy, compassion, and hope. Now, besides being a person of faith, I teach university ethics courses. I know students can't remember everything. And so I always say this: if you forget everything else, remember this one thing: do no harm. That's the bottom line in ethics. Do no harm. Now, all people of goodwill, religious or not, can agree to do no harm. The PROTECT Act deserves support because it helps us do no harm to people we've incarcerated. The evidence is clear that prolonged isolation does harm. Lasting mental health harm can occur in as little as 7 days, and pre-existing mental health illnesses are exacerbated in the same time frame. Self-harm, including potentially fatal self-harm, is more than 6 times more likely among those put in solitary. Now, the PROTECT Act moves our state in the direction of do no harm in 2 ways. First, it brings Connecticut's use of isolation in line with the UN Nelson Mandela rules. The act allows no more than 15 consecutive days of isolation, and it increases out-of-cell time to help protect mental health. Second, the PROTECT Act provides corrections oversight by an independent interdisciplinary commission, and it re-implements the ombuds. These measures will help Connecticut achieve rehabilitation while avoiding harm. With hope and vision, the PROTECT Act moves our state closer to that ethical bottom line: do no harm. As people of goodwill, please give it your support. Thank you.
Thank you, ma'am. And go Stags, alma mater. Seeing no questions, appreciate being with us today. Joseph Marioni.
Hi, can you see me?
We can.
Okay, thank you very much. My name is Joe Marioni. I'm the past president of the Connecticut Trial Lawyers Association. I'm here to speak in support of the repeal of the incarceration lien, number 5390. When I studied the legislative history in connection with this bill, there were 4 major reasons advanced in the debates that went forward. It said from time to time, there's a case where an inmate does have significant financial resources, and they should have to pay for a portion of their time in prison. The other argument was that this is a way for the state to recoup some of the expenses. The third basis was, well, you know, this shows them to be responsible citizens and how they should be able to manage their finances. And that other states were doing this, and you know, there was no complaint. Now, this is 1997, a surplus year for the state of Connecticut. Well, I'm here to show you that none of the reasoning that existed back in 97 exists today. First of all, the 4 states that I know of that had these kinds of statutes in play, Utah, Michigan, Virginia, and Pennsylvania, have repealed them. That there is no environment in a personal injury litigation where there is a windfall. And you need to understand that when somebody is harmed, they recover for economic losses, past and future, for medical expenses, past and future, and for the change in the loss of their quality of life. There's no part of that formula that says we're going to give you some kind of a significant financial resource. I want to tell you briefly about, this is true, about Stephen D. Stephen D had a tough life. That at 14 months, he was in foster care and went through the foster care system. That over time, he tried a lot of good things. And in fact, he had saved $1,600 through his newspaper route to buy his first car. And that his foster father was in tears saying, in my entire life, I've never saved $1,400. So Steve was industrious and hardworking. He had broken his back. He had 2 rods in his spine. He walked with a tilt. He had a gruff nature about him, but he had the heart of a teddy bear. He got into trouble because of anger issues. He spent 1,100 days in jail up until 2004. He came out of prison. He found a new path. He developed a business being a handyman. He would fix things, electrical and plumbing, and worked hard. And he did work a lot of people didn't want to do. He prided himself in the fact that he had now got a pickup truck with his tools in it. He was committed himself to his faith and to AA principles and with helping people. And he had developed a significant relationship with Sharon. On this day, he was going to, on a Sunday, he was going to a funeral of a fellow AA member's wife. Sharon had made him a cup of coffee that he left saying, I'll see you later. Got on his motorcycle, went to the funeral and was on his way back when by Clinton Crossing, somebody cut him off. He avoided it and crashed into a car. 4 days later, because of traumatic injuries, he passed.
Sir,
Police could never identify that bad person. The bottom line was that there was a limited policy. Hopefully they share with Sharon and all. And the state turned around and issued a lien of $128,000. No significant award.
Sir, I gave you a little extra, and I hate to cut you off because I know.
Okay, I'm sorry.
But
I just say that the day has come for to look hard at the reasons that underlined its need, and now that those days are over, and we ask that it be repealed. Thank you.
Thank you, sir. Seeing no questions from the committee, I want to thank CTLA for your testimony on this. Maybe not the typical bill that we usually hear from CTLA on, or the typical type of bill we hear from CTLA on a sort of criminal justice type issue, but I think you put a fine point on the need for this bill, that we're not talking about windfall money. Oftentimes we're talking about really the state profiting off of money that is needed for someone to get on with their life after an accident or after the death of a relative or the like.
With a 20-year statute of limitations, which makes it, here this man was.
Let me ask, that was actually a question I had when you're so what happens if the money is spent, right? Somebody collects, well, I guess it's a lien, right? But so
it's a lien. Yeah, we get notice.
It's not okay
through the state. Yeah.
Yeah. Okay. All righty. Thank you, sir.
Well, thank you very much.
Rachel Talamo.
I'm here.
Go ahead, ma'am.
Good afternoon, esteemed members of the Judiciary Committee. My name is Rachel Talamo, and I'm a second-year law student at Yale Law School, speaking on behalf of the Lowenstein International Human Rights Clinic. We strongly support the passage of the substitute language for SB 459. While this compromise bill does not go far enough, in our view, to remedy ongoing violations in Connecticut prisons, it is an important first step to recognize the safety, humanity, and dignity of all people who live and work in Connecticut's prisons. It is especially gratifying to see Commissioner Quiros work collaboratively with Stop Solitary Connecticut to codify progress to date and create an oversight system that will enable transparency and a forum for greater public participation. I wish to focus my comments on why this bill is not simply a good thing to do, but necessary to meet Connecticut's obligations under international human rights law to prevent torture in its prisons. I also refer the committee to my written testimony that provides more detail, and I'm happy to answer questions about it. Since 2010, our clinic has been investigating abusive isolation and other abusive practices. At Northern CI, we met scores of people with long histories of mental illness. Faced with unrelenting isolation, they deteriorated even further, often to the point of grotesque acts of self-harm. But these cries for help were not met with mental health treatment, just more punishment. DOC routinely responded to mental health crises by forcing individuals into shackles and chains, even though they were in locked cells, typically for a default of 72 hours. We documented our findings in a 2019 letter to the UN Special Rapporteur on Torture. The rapporteur confirmed, and I quote, "There seems to be a state-sanctioned policy aimed at purposefully inflicting severe pain or suffering, physical or mental, which may well amount to torture." Northern's closure and the governor's executive order are important steps, but Connecticut should never have engaged in these practices, and more work is urgently needed. Across the Connecticut system, and since Executive Order 21-1 was implemented, we have heard numerous reports of short shackling in direct contravention of DOC policy, deplorable medical and mental health care, malnourishing food, needless strip searches, protracted use of in-cell shackling, and isolation used as a repeated disciplinary tactic against people with serious mental illnesses. In just the past few weeks, we've spoken to people who have gone years without seeing a tree. Their limited outside time constitutes a concrete holding cell outdoors and a patch of air and sky. Bringing light to our closed system through independent oversight is a vital first step. Most importantly, SB 459 begins to address the reality that the harms of criminalization and incarceration have fallen for far too long on Black and Brown people in Connecticut. The PROTECT Act will finally establish a sustainable infrastructure for stakeholders to understand what is happening inside our state prisons and find a better way forward together.
Thank you, ma'am. Thank you for
I have to disagree.
Oh, hello. Thank you, ma'am. Appreciate your testimony. Sorry about that interruption. All right, next up will be Mustafa Salahuddin. How about Marissa Mascolo-Ham? Judith Resnick.
Hello, I'm here. Hope you can hear me. First of all, thank you all. I know you have a long and full day with many bills. So I want to be quick. My name is Judith Resnick. I'm the Arthur Lyman Professor of Law at Yale Law School. And I think at a critical juncture to be here to discuss Bill 459. As the commissioner told you this morning, I hope that in addition to enacting it, you will help fund it because it's a real step forward in important ways. How can I be useful? I can report to you that over the last decade, the Lyman Center at Yale Law School has been trying to understand something about the metes and bounds of solitary confinement nationally, not just in Connecticut. Exhibit A reports that we've sent to some of your staffers are now 6 books, and I can give you 4 fast facts from these lengthy volumes. 1, it's really too easy to get into isolation. Threats to security is often all you need. 2, it's too hard to get out. 3, it's too hard to be in. And 4, there are too many people. Our national surveys, which are done in conjunction with the people who run prison systems around the United States, tells us that as of 2019, we think that somewhere between 50 and 60,000 people were in isolation. Under the definitions of the systems that they were in, more than 3,000 had serious mental illness. According to the counts of the systems they were in, more than 3,000 were there for 3 years or more, and more are disproportionately of color. So where are we now? Even though solitary is a pretty common practice in the United States, it is actually understood and seen as a radical act. Think about being immobilized in a 6x8 space for months, days, and years on end with limited sociability. It's bizarre, it's weird, it's not a natural part of human or other kinds of animals' interaction. And over the last decade, a momentum has gathered across the political spectrum to end this form of corporal punishment. which is so harmful to mind and body. And your legislation is one of a series across the United States, so I can here again report by zooming out a little, if you will, that more than 15 states have enacted legislation and the feds to limit either to subgroups such as pregnant women or juveniles, and to require reporting. And there are more than 30 bills pending now across the country. And so your legislation is A, critical, and B, innovative. Your features of limiting hours in cell, limiting the length of duration there, and critically recognizing that doing this isn't something that is alone. You don't undo solitary by yourself. So pulling in and working with the Department of Corrections and then building in an ombudsperson and building in an advisory committee is a terrific, innovative, supportive infrastructure that enables understanding. You can't undo solitary without knowing how it's being used, and to know how to use it, your proposed substitute bill enables a mechanism to bring to closure this form of confinement. So it's a genuine contribution. Thank you. And I know my clock has clicked, and so I can see the timer, and I'm happy to respond if I can be useful in any way. There's submitted written testimony too.
Thank you. Representative Porter.
Thank you, Mr. Chair. And just really quickly, I know we have time constraints, but you did say something that resonated with me and I find quite, I was going to say fascinating, but that's not the right word. It's radical to put somebody in a 6x8 space for days, months, and years. And when you think about if you do that to an animal, you end up in prison. It's considered, a criminal act. So I just find it really ironic that we are discussing solitary confinement in a way that we don't relate to how much better we treat animals than we actually treat people who have been incarcerated, have lost their freedom, and are paying the price for the crime that they've committed. So thank you for including that in your testimony and making the time to be with us today. Thank you, Mr. Chair, for the opportunity.
And thank you for your work on our behalf. I should point out that in the 1960s,
ma'am, thank you. There was
okay.
I do appreciate it. I know but we do have a lot of folks that
yes,
still
we're
want to testify.
Glad you're at work at this, not to delay you. There are a lot more people to hear. Thank you.
We do have your written testimony. So
thank you.
Thank you very much. All right, Abby Steckel.
Yes, hello. Good afternoon. My name is Abby Steckel. I'm a resident of New Haven. I support Senate Bill 459, and I'll be using my time to read excerpts from Robert Homar's testimony. Robert cannot be here today because he's incarcerated, so this is what he has to say. My name is Robert Homar. I'm writing from Cheshire Correctional Institution, but I'm known by staff as inmate number 243878 or cell 27. Sometimes this place makes you forget who you are. I'm currently in for a violation of probation and was sentenced to 3 years for police contact. The day of sentencing, I was told that DOC would protect me from COVID and I would be able to see my family. Yet since I've been incarcerated only 10 months, I've caught COVID on January 11th, 2022. Now I have to take medications and worry more about what will happen in future outbreaks. Before the outbreak, we as the building of Cheshire CI were on many lockdowns. There were times I couldn't call my family, only because we had to choose between taking a shower or phone call within a 45-minute time frame. Mind you, this is a tier of 50 other inmates out with you and only 12 or 7 phones to use depending on what block you're in. I've seen so many fights over a phone only because of the frustrations of not talking to loved ones. I speak for myself, it's been a strain, emotional and financial. In my eyes, I feel they want these disruptions to feed the people in the public that prison is a dangerous place. There are more codes against inmate to inmate than staff, and it's mainly over a phone call. The facility has the power to fix this, yet they don't. I'm eligible to get contact visits, and Cheshire CI claims to be on phase 1 COVID protocol, yet there is no contact visits going on. Virtual visits is only 3 inmates at a time on a first come, first served basis. How is that right for a facility that holds well over 1,000 inmates? It makes no sense. I understand that this is not supposed to be anything like freedom, but just the simple things that should be given to us inmates are not being upheld by staff or overseers to them. I know that imprisonment takes away from not just myself, but also loved ones. I ask for only the rules to be fair to us and used as it should by the book. Please stop staff from bending the rules for themselves. I would like to remember how it feels to be a person, not just a number. Thank you for your time.
Thank you, ma'am. And we appreciate being with us. Day McKnight.
Greetings of peace be unto you, Representative Stratstrom, Senator Winfield, entire Judiciary Committee. My name is Dai Muhammad McKnight, and I've been a forensic social worker for about 13 years, working in the field of reentry. And I'm here to support HB 5390, repeal of the cost of incarceration. But I'm here in a double capacity. I'm also here to support SB 459, the PROTECT Act, but I'm going to give testimony on 5390, the repeal of the cost of incarceration lien, something that me and Fred have been working on for over 10 years. And also thanks to our coalition of great researchers from Quinnipiac Law School, Yale Law School, and UConn Law School. I've had the opportunity to look at this issue from both sides of the fence as being a frontline reentry service provider, and hearing and seeing the horror stories in my office of people who have lost loved ones, and losing a loved one and receiving an injury in an accident, being compensated or receiving inheritance is definitely not a windfall. And I've seen people in my office in tears, not only because they lost their loved ones, but they haven't even had a chance to process that. And here we go again, after they've been released, after they served their time that they were sentenced to in a court of law in the judicial system, they now have to serve another sentence out, which is a financial sentence. And I've witnessed this in a personal capacity where I've been out of prison for 16 and a half years, and I haven't reoffended. I haven't went back to prison. And 12 years after I was out, I was in a car accident. I was injured twice in a car accident to make me whole, and a portion of what I received was taken from me. And actually, there's not only a moral issue, but there are legal implications here. I was sentenced in 1988. This law did not exist. So actually, there's something called ex post facto, that I was affected by a law that did not exist. And usually you're only grandfathered into something that is less of a harm, not more of a harm. And I remember when I got sentenced, they said all fees and costs associated with this crime shall be waived. And I had been released from the Department of Corrections for the past 16 and a half years with no parole, no probation. And up to 20 years since I've been released, I'm still subject to a law where they illegally take money from me after I have served my time, and not only served my time, but went back into the community to help facilitate positive reentry for others and help people become productive citizens so they can contribute legally to a tax base that the Connecticut citizens contribute to for the benefit of the citizens and our state. So I understand this from a couple of perspectives. And like I said, there are legal implications here when you start peeling back the layers to see that there's a violation of people's 14th Amendment for people like me who was sentenced before the law was enacted. Now I see the timer just went off, but any questions that you have, I'm willing to answer. This is an issue I'm very familiar with. Thank you.
Thank you, Dai. Representative Palm.
Thank you, Mr. Chair. I'll be brief. Thank you, sir, for being with us. I'm wondering if anybody has ever done a relative study of the amount it costs the state when people get, when all the people who, I'm not sure what the verb is, recidivate, is that correct? When all the people who have been let out, commit no crime, go back into prison, what does that cost the state versus what we quote unquote make on gunning people for windfalls or inheritances? I just wondered, I'm not asking you to answer that question. I just think it would be a good thing to know if there were anybody, do you know if anybody's studying that, you know, that cost benefit ratio?
I'm not sure if anybody's studying that exact figure of how that is come to, or the comparison of that. But I do know that when you have people in situations like mine, where I was incarcerated at a different time period from 1987 all the way into 2005, for you to take someone like me and charge me a flat rate of $220 something a day, that is illegal, on top of it already being illegal, because the cost of incarceration was cheaper when I was sentenced, but you charged me a flat rate from 1987 to 2005, instead of a rate which was based on what it was at that time period. I
Right.
do understand that.
Yeah, and I do see your point. There are, if you look at criminal justice, there are people who approach it from an equity and a fairness and a humanitarian standpoint, and there are people who are more convinced by the economics. And I think in this case, my gut tells me that it costs us more, to have people recidivate and go back in than it does to just let them keep, in aggregate. Anyway, I just was wondering if you know of any studies or anybody working on that issue.
Yes, ma'am. Thank you.
And thank you for your work.
Yes, ma'am. Thank you.
Thank you. Thank you, Dai. Great to see you. And thanks again for all your advocacy and work on this.
Thank you all. Have a great day.
All right. Next is Sandra Kerr.
Good afternoon to the esteemed members of the Judiciary Committee. My name is Sandra Kerr Clark. I reside in New York. I would like to express my strong support for the Project Act SB 459. I am testifying on behalf of my brother, Casey Lewis, prison number 165480. My brother was held at Osborne Correctional Institution in solitary confinement this month, March 2022. He's been incarcerated for at least 15 years. During this time in solitary confinement for 7 days, he went on a hunger strike because his legal documents were confiscated by a correctional officer and his CD player was damaged. The officer wrote a false inventory report and his documents were for the documents belonging to him. After he lost 20 pounds and almost died, his documents were returned to him. Then he was transferred to Madogo and placed on restrictive housing. No letters in or out, no visits, only phone calls were allowed. I believe this was a tactic used to silence my brother once again, because he has filed several lawsuits and he did win one. Casey has shared with me that there has been times when shackles were placed from his wrists to ankles. Clearly, this is torture, degrading, painful, and sadistic. Solitary confinement does not help, at least the mental illness. And if you enter a prison with mental illness to begin with, surely this type of torture will make it worse. I believe my brother has become a target for the many lawsuits that he filed. My brother Casey is college educated and he earned a degree in associate's degree in applied science. While he was out, he was working and going to school at the same time. He would often drive to New York to see me from Connecticut. Our last visit was about 10 years ago. We shared a pizza together. Casey comes from a loving family of 3 sisters and 2 brothers. We are his support system. Banning solitary confinement would end the use of unnecessary lockdowns and denying basic human rights for days, weeks on end. It would also address severe enduring harms of isolation in Connecticut prisons. The Project Act SB 459 would promote officer wellness, which will require reporting to key indicators within the Connecticut correction system, including prevalence of mental illness, use of force incidents, and availability to programs, to education and other programs. How do you think my mother feels, my 80 plus mother feels when she hears that her son is placed in shackles, wrist to ankle? I'm sure this reflects back to slavery. I thank Commissioner Angel Quiros, I hope I'm pronouncing your name correctly, for answering my email concerning my brother. I thank Barbara Fair. I thank Risha Bivens. I thank you for this time that I've been able to express myself about my brother. Thank you.
Thank you, ma'am. Appreciate being with us today. Next up will be Cindy Prizio.
Hi, good ranking members and all distinguished members of the Judiciary Committee. My name is Cindy Prizio, Executive Director.
Cindy, we can't see you.
Wait a minute. I'm in a car. I mean, you
want to testify later?
No, can I do it now? Can you see me now?
Yep, now I can.
Okay, let's try it. I just have to hold it. Okay, start over, Representative Staffstrom. My name is Cindy Prizio, Executive Director of One Standard of Justice, a civil rights advocacy organization. Today, I come before you as the mother of a justice-involved child. I dedicate my testimony to Colleen Lord and Robbie Talbot, Barbara Fair and her son Kishar, Mrs. Johnson and Layton, Stacy Rivera, and all the scared, powerless moms I stood with over the past 3 years on the steps of the Capitol, whose children suffered the mental anguish of solitary confinement within our Connecticut prisons. I'm here to speak on the PROTECT Act. And I just want to tell a story. A person who looks like me was targeted in prison by a bad actor, DOC employee. This behavior can only be classified as psychological and sexual abuse and physical intimidation. The mom spoke to the DOC commissioner under Governor Malloy, who assured her that her son was not in harm's way, that this particular officer was what he called a by the book. The mom asked if there were any actions or litigation on this staff person. The commissioner responded, "Do you think we'd place someone who is dangerous in the prison population?" But there were multiple civil suits that had been settled and one that was active. The commissioner went on to say he would never take the word of an inmate, quote unquote, over a corrections officer. That's a large part of the problem here. Why not? This is a fairly innocuous situation, not to this mother and her son, but totally different than the life and death situation impacting the family of Robbie Talbot's. The mother would be driving 2 hours to visit her son when she'd receive a call, sometimes an exit away from the prison, to hear, "Don't come. He's here." Her son didn't want to go through the humiliation of standing naked for an extraordinary length of time while the CO went inch by inch over his clothing after a visit. Bill SB 459 will help with the transparency of our most vulnerable in the care of the DOC. Independent oversight is critical. Too many are harmed, including maimed and murdered within the prisons by staff. And then there's the cover up to protect their interests. Callousness has replaced compassion by those who work in prisons. We must return human dignity or set a new standard of culture to support human dignity for the sake of the DOC employees and their charges. And we must honor mental health needs of both the incarcerated and the staff. I'd like to see restorative conferences brought in by independent organizations like Friends of Restorative Justice Connecticut to help the people inside express their feelings in conversation, just as they would express themselves in their art, where trauma-informed advocacy will recognize.
Thank you, Cindy.
Can I finish the sentence? No.
No, we're good. We're moving along.
All right.
We appreciate it, Cindy. You know how to get us written testimony. We do appreciate being with us. Next up is Ann Massaro.
Thank you.
Good afternoon, distinguished members of the Judiciary Committee. My name is Ann Massaro. I write in strong support of Senate Bill 459, also known as the PROTECT Act 2022. Last year, my husband, Michael Massaro, testified before this distinguished committee in support of Senate Bill 1059, the PROTECT Act. Michael was a lifelong Republican and lifetime resident of Connecticut. He testified that he believed solitary confinement or extreme isolation, by whatever name it's called, is torture. He said that his humanity would not allow him to support solitary confinement, that he did not want his tax dollars being spent on torturing other human beings. He went on to say that the issue of solitary confinement is not a political issue, but a humanitarian one. He told a story he kept private until his testimony. He said, "If you think this cannot happen to you or your loved ones, I'm here to tell you that you're wrong. My daughter was incarcerated and spent time in solitary confinement. After 3 years of being on the outside, she only now has found her voice to speak about this horror. Her experience in solitary confinement caused her great psychological harm, from which she may never recover." He continued by saying that prison conditions generally are inhumane, and extreme isolation is the worst and most harmful. Michael passed away this past November without ever seeing Senate Bill 1059 passed into law because of Governor Lamont's veto. One of the cases that continually cited by people to support this continued torture in Connecticut is that of the two men, Joshua Komiskarjeski and Stephen Hayes, who committed the heinous crime against the Pettit family in 2007. This particular example of violent criminals often used by white people in Connecticut when arguing for continuing solitary confinement at the most extreme level. However, 80 to 90% of those people incarcerated are Black and brown, with only 3% of incarcerated people having committed violent crimes. Both of these men were transferred to medium security prisons in Pennsylvania. Neither of them are enduring the atrocious conditions in Connecticut prisons. To constantly use these men as example for continuing solitary confinement and to justify the harsh conditions within Connecticut prisons is deceptive, manipulative, and racist, because neither of these white men are enduring the prison culture in Connecticut. You have another chance to make my husband's testimony mean something by passing Senate Bill 459, the PROTECT Act 2022, codifying the importance of independent oversight and while reducing the use of solitary and promoting public safety. I am writing to you in honor of my Michael's memory. If he saw beyond the politics of this issue and touched his own humanity by understanding this is not a political issue, my hope is that you too will touch your humanity and vote to support Senate Bill 459, the PROTECT Act 2022.
Thank you, Ms.
Thank you for the opportunity to be heard on this issue. And I want to honor and thank Barbara Fair for her enduring leadership on justice around solitary. Thank you.
Thank you. Appreciate you being with us today.
Thank you.
Christina Quaranta.
Good afternoon, Senator Winfield, Rep. Staffstrom, members of the Judiciary Committee. My name is Christina Quaranta, and I'm the Executive Director of the Connecticut Justice Alliance. We are a statewide youth adult partnership that works to end the criminalization of youth. And I'm here to submit testimony in support of Senate Bill 459, which is an act concerning the Commission for Correctional Oversight, the use of isolated confinement, seclusion, restraints, strip searches, social contacts for incarcerated people, transparency for conditions of incarceration, and correctional officer training. In my testimony before you today, we'll keep it short and simple. I would like to highlight the following points from the bill. We've all heard from people this morning, and most importantly, and especially from folks with lived experience, why passing the PROTECT Act and actually having it signed into law this year is so important. But we really need independent oversight of the Department of Corrections, and the Commission for Correctional Oversight would do that. It would include a civilian advisory committee of people who are formerly incarcerated and family of people who are currently or formerly incarcerated. It would include a true commitment from the Department of Correction to begin the process of allowing incarcerated people more out of cell time, which includes structured programming for them that's sorely needed. It would also include the important use of the end of abusive restraints and would significantly reduce the use of degrading and humiliating strip searches. I heard all of the points that my colleagues and friends have highlighted today, and I think I'd just like to point folks into the direction of the Department of Justice report that came out in December of 2021 that found that Manson, which is under the Department of Corrections, where you are housed if you commit a crime and are charged as an adult age 15 to 17 or all the way up to 21 in Connecticut, is violating the civil rights of young people today, right now here in Connecticut, with the use of isolated confinement, with lack of mental health care, and by violating their special education rights. So while we look at the PROTECT Act and the whole system underneath the Department of Correction needs an overhaul, specifically for me and my organization, we're just going to highlight that today so folks can be aware that their children inside the Department of Correction and the way they are being treated today and have been is unacceptable. So you can see submitted testimony, and if you are curious about that Department of Justice report, it's a quick Google search. US DOJ, Manson Youth Institute, you can look that up. So thank you. If you have any questions, I am here to answer them.
Thank you, Christina. Appreciate being with us today. Next up will be Michael Vargo.
Good morning, members of the Judiciary Committee. I am Michael Vargo, President of Council 4, Local 1565. I am also speaking for Sean Howard, President of Local 387, and Colin Provost, President of Local 391. Our union opposes Senate Bill 459 as written. Our members were perplexed by last year's passage of Senate Bill 1059. This bill mandated that only captains could authorize as much as handcuffing an inmate. The language was barely expanded to say that in the event that a captain wasn't present, the commissioner could authorize another person to allow for handcuffing an inmate. This simply is not how prisons work. Violence happens unexpectedly and quickly. An example of this happened at McDougal Walker this year. An inmate stabbed a wheelchair-bound inmate. The wheelchair-bound inmate was of low social standing. Suddenly, the inmate pushing the chair pulls out a shank and repeatedly stabs a wheelchair-bound inmate. The video is chilling. It shows a lone corrections officer diving into the fray and stopping the stabbing. The officer quickly disarmed and handcuffed the stabber. If the officer had not done this, the wheelchair-bound inmate would have been murdered. We urge you to ask the commissioner to let you see this footage. Yet, if Senate Bill 1059 had become law, the corrections officer's actions would have been illegal. It would have been in handcuffing in violation of the law. We know that COVID crisis had made legislating difficult. We believe that it was not the intention of the legislature to make such a life-saving action illegal. Please do not pass language that encumbers our ability to safely shackle inmates. We are now told that strip searching inmate will be curtailed. A few weeks ago, 2 inmates died and 1 staff in person was injured because of fentanyl exposure at the New Haven jail. The vast majority of drugs or contraband enter the prison through inmate contact visits. Curtailing strip searches will increase the likelihood that more contraband, such as dangerous drugs, will enter institutions. Strict department rules regarding strip searches already make conditions as humane as possible. Also, increasing contact visits without a large increase in staff to supervise such visits creates a safety problem. Please vote no on Senate Bill 459. Thank you for hearing my testimony.
Thank you. Mr. Varga, I don't know if you were here when I asked a couple of folks about this earlier, but you haven't had a chance to read the new language yet, I presume, correct?
No.
Okay. So we will certainly look for, if you could, get us some thoughts on that when you get it, as opposed to, the language in the underlying bill, which will not be moving forward. All right. Thank you, sir. Appreciate you being with us today. Colin Provost.
Good afternoon, Chairman Winfield, Chairman Staffstrom, and members of the Judiciary Committee. I am Colin Provost, President of Local 391, and I am also speaking on behalf of Sean Howard and President Vargo as well. Our union opposes Senate Bill 459 as written. We know that the bill is changing as we speak and has changed as of last night. We have not had an opportunity to review it in its full context. We're doing our best to follow what is in it. Our understanding is that it will codify much of the current executive order regarding the Department of Correction. Our members have had several problems with the executive order. We hope that it is not made law without the several changes that are suggested. The executive order vastly increases rec time for inmates. That is a problem because correctional institutions are not laid out for having that many inmates out of cell at one time. When bad things happen, it's usually when these inmates are out of their cells. Our biggest challenge is keeping predatory inmates from preying on the rest of the inmates. The vast majority of inmates want to serve their time and get out, but the predatory inmates can cause a lot of problems and whip up the normally cooperative inmates. Please remember that one of the Connecticut's biggest prison riots started over the issue of whose turn it was on a washing machine next. Hundreds of inmates wound up rioting and 2 inmates were murdered during this riot. As correctional professionals, our prime job is to keep inmates, staff, and the public safe. We are dangerously short-staffed to handle today's conditions. Increasing rec time safely demands an even larger increase in staff. Please vote no on Senate Bill 459 as it was presented to us, and I thank you very much for listening.
Thank you, sir. And we, like I said, we do appreciate that. Obviously, this bill changed last night. I think even members of this committee have not had a chance to fully digest the new language yet. So, I mean what I say. Get us your thoughts in email after the hearing, after you've had a chance to read new language, because it will be important for us to hear that. We do appreciate the difficult work of our folks in the corrections facilities, and we do want to hear your thoughts on the new language of the bill. All right.
Thank you, sir.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Mr. Provost, great to see you again. I don't know if, I don't know if you had an opportunity, but earlier the steward, corrections officer Tower, came and testified, and I told her that, hey, all you folks in 391, that's our neck of the woods here in North Central Connecticut. And I definitely will stick up for the folks that are the boots on the ground. The bill is changing. I'm hoping that you folks have a good relationship with Commissioner Quiros. He certainly worked his way up through the ranks. But if after you see what's purportedly the final iteration and you still have concerns, please reach out to me directly. You guys know how to get a hold of me. And by the way, I was there in person back when I had recently couple of years become a state senator, but I was outside Carl Robinson when that riot took place. I was there with the late, great Jack Bailey. I believe, I don't know if he was chief state's attorney at the time or just the state's attorney for Hartford County. That was a scary evening. I mean, the COs inside that facility, they just locked themselves in their stations. We had state police out there that said, we are not going in there. And we had to wait patiently for the corrections emergency response team. And we could hear, part of the thing is you hear their boots marching down the road. And they did an awesome job. And I learned later on, and I'm sure you're aware of this, but our previous commissioner, Scott Semple, was a member of that CERT team that evening. So that's another individual that worked his way up through the ranks. So I've toured all the facilities in our neck of the woods. I've toured other facilities such as Manson and Garner and others in the state of Connecticut. I hear you. I think until people really see what that is to work in that facility or those facilities, it's danger all the time. I understand most of the inmates do not cause problems, but you have to know these people have been convicted. And quite often they're in there for something of violence. And it's one thing to say, oh, just anger management, but the anger manifests itself in ways that can be very dangerous to humans. So I know we have a ton of people on the list, but I wanted to associate myself with the remarks of Chairman Staffstrom. And I thank you for all your hard work in our facilities here in North Central Connecticut, Mr. Provost. And thanks for taking the time and let's keep the lines of communication open. Thank you, sir.
Absolutely. I appreciate that, sir. And I do encourage you to maybe take a look at McDougall Walker again, because now we don't have Northern anymore. And it's a little bit different constraints than we had at Northern. So it might be worth taking another tour, a more recent tour, to see how we're handling that inmate population.
I'd absolutely like to do that and like to meet with you folks in your office here in Enfield as well. I am concerned about the uptick in the workers' compensation claims. So I'll reach out to the commissioner's office and see if I can't line up a tour of McDougall Walker as well. Thank you once again. Thank you, Mr. Chair.
Thank you. And thank you, Mr. Provost, for being with us. All right, I am going to turn the gavel over to Vice Chairman Blumenthal for a little bit. And next up will be Nathaniel Warren.
Thank you and good afternoon, members of the committee. My name is Nathaniel Warner. I'm a lifelong Connecticutter. I grew up in New Haven. I went to college at Wesleyan. I went to law school at Yale. And I'm proud to say I still live in New Haven today. I'm here to support HB 5390 and oppose the unjust practice of charging incarcerated people for their time in prison. Right now, a person who is sentenced to a year in prison is not just punished for that year. They will spend a year in prison and another 20 in over $80,000 of debt. And I was ready to come here and talk about why exactly that's unjust, how it's unfair that judges don't consider those debts at sentencing, that it's horrifying that a prisoner who prevails in a Section 1983 suit against DOC could see that money clawed back by the government that they just sued for wronging them. But I want to address something that I heard today, which is about the finances. I think, I want to be clear, I think that the fairness, justice, rehabilitation, those are the reasons you should support this bill and change this law. But if members of this committee are making their decision based on financials, you should still support this bill. It is not an efficient use of DAS resources to collect what are very small amounts of money to the state, but very large amounts of money to the people DAS is collecting from. And we know from research at the Aspen Center during the pandemic, a 2015 NIH report that involved research in Connecticut, as well as countless comparative global studies, that the poorest people are the most efficient spenders, that a dollar spent by a low-income individual is magnified many times over in its direct effects on the community and downstream effects on state GDP. The money that DAS doesn't collect from triggering events like lawsuits, property sale, and inheritance, that will still show up on state ledgers. It will show up in the higher tax revenues from larger GDP. It will show up in the savings on medical care and welfare services that as fewer formerly incarcerated people are forced back into poverty. And it will show up in lower rates of incarceration overall as reentry gets easier and recidivism goes down. In other words, if the current law just doesn't make economic sense, and if that's your reason for supporting it, your reason is wrong. Thank you for your time.
Thank you for your testimony, Mr. Warner. Are there any questions or comments from the committee? Seeing none, thank you for your testimony, Mr. Warner. Next up is Nancy Alsberg, followed by Sean Howard.
Dear Commissioners Winfield, Sastrom, Vice Chairs Kasser and Blumenthal, and ranking members and other members of the Judiciary Committee. My name is Nancy Alsberg, and I'm a resident of West Hartford, and I would like to express my strong support for Ray's Senate Bill 459, also known as the PROTECT Act. I am a former member of the Stop Solitary Connecticut Steering Committee, the former managing attorney of the State of Connecticut Office of Protection and Advocacy for Persons with Disabilities, and the now retired legal director, Disability Rights Connecticut. I did significant prison work during my professional career. I am not testifying as a representative of any of these organizations, but rather reference them to show that my professional experience gives me a unique perspective with knowledge that is particularly relevant to the bill before you today. And I cannot speak to the substitute language, but I can say why it is important that this bill pass again. We all know that Northern Correction Institute, the former Supermax prison, has closed. That does not mean that the conditions that existed at Northern are not being duplicated elsewhere. We all also know that the governor, upon vetoing the PROTECT Act in 2021, issued Executive Order 21-1 that purported to do some of what was included in the PROTECT Act. However, as opposed to the PROTECT Act, the executive order has no enforcement mechanisms. Its implementation is left up to the good faith of those DOC officials who enact its provisions. However, the executive order is only valid until a new governor decides to withdraw it, or even until Governor Lamont himself withdraws it at any time without any oversight. Therefore, given the lack of enforceability, it is critical that the legislature do what it did a year ago and pass the PROTECT Act as amended. And the fact that DOC and Stop Solitary have worked together on the language of this bill should answer any concerns of the governor and of any individuals who are still have questions about it. The legislature did the right thing in 2021. It enacted a bill that will provide much needed training and support to DOC staff to mitigate burnout, substance abuse, aggression, and suicide, as well as protect the prisoners. I have attached my 2021 testimony to my 2022 testimony, which goes into more detail about why the PROTECT Act is necessary. There have not been sufficient changes in conditions at DOC as a result of the executive order that changed that original testimony. We expect that the changes in the 2022 bill as amended will answer the governor's concerns, and I ask you to once again pass Senate Bill 459, the PROTECT Act, and I'd be happy to answer any questions.
Thank you, Ms. Allisberg. Any questions or comments from the committee? Any questions or comments? Seeing none, thank you, Ms. Allisberg, for your testimony. We appreciate it. Next up is Sean Howard, followed by Hope Metcalf.
Good afternoon, Chairman Strassman and members of the Judiciary Committee. I am Sean Howard, President of Local 387 from Council 4. I'm also speaking for Colin Provost, President of Local 391, and Michael Vargo, President of Local 1565. Our union opposes Senate Bill 459 as written. There's been discussions of promising inmates not just more out of cell time, but more phone calls and contact visits. The infrastructure of the prison and jails does not allow this. Many of them have very few phones available for inmate use. Making promises to inmates that you cannot keep raises the temperature in the facilities. That is dangerous. You want things to be calm and predictable in a prison. You do not want to raise the level of disgruntlement and dissatisfaction. Prohibiting the use of chemical agent is also another area of concern. It may seem counterintuitive, but pepper spray reduces injuries and it also saves lives. During the last few years, there's been legislation to ban pepper spray from Manson Youth Institute. Pepper spray use is strictly regulated. Not all staff, not even a majority of the staff carries pepper spray in any institution. If pepper spray is deployed in any institution, there are reports that must be filled out. When staff deploys pepper spray, staff usually gets sprayed as well. An example of the benefits of pepper spray was seen in a fight just last year at the Manson Youth Institute. 6 youths ambushed 2 youths in the hallway while youths were moving between classrooms. Much physical injury can be inflicted quickly in an altercation when there are many attacked a few. Pepper spray was quickly deployed and the attack stopped immediately. If there is no pepper spray, the security protocol demands that twice as many staff assemble as inmates involved in a violent attack. This would take several minutes. A youth could be severely injured or even killed during that time. If pepper spray cannot be used, then such a fight must be stopped by the staff through hands-on means. Hands-on almost always leads to staff and inmate injuries. Hands-on interventions often leads to hard feelings and a want for vengeance from the inmate. Pepper spray does not lead to such a hardening of feelings. We urge you to not curtail its use. Also, the use of the term solitary confinement is a concern. There is no solitary confinement in the Connecticut correction system. Administrative segregation used to correct the behavior of assaulted inmates. Most of the inmates are against other inmates. Administrative seg is not solitary confinement. It is a step-down program to encourage inmates to not assault on the behalf of the community. This was normally a 90-day program where an inmate in single cell but receives several daily visits from staff. He also receives recreation and has access to television and at least 2 hours of out of cell per day. Under the new executive order, an inmate can only be in administrative segregation for a maximum of 15 days. Then the inmate must be given a 45-day buffer. This has been the administrative segregation program much less effective. This has led to the need for more staff. It would make sense to restore administrative segregation to a 90 or 120-day program. Please oppose SB 459 as written, and I thank you for hearing my concerns.
Thank you, Mr. Howard. Questions or comments from the committee? I see that Representative Quinn has raised his hand. Representative Quinn, you have the floor.
Thank you, Mr. Chairman, and thank you, Mr. Howard, for being here and sharing your views. And, I just want to say that I appreciate all that you and your fellow corrections officers do on a daily basis. I mean, you've got a very difficult job, and hopefully we don't do anything to make it any worse. Have you, as a union leader, seen the substitute language that the commissioner alluded to this morning?
We received it very late last night, so I haven't had a chance to review it yet.
Okay. All right. As I think has been said earlier, there unfortunately won't be another opportunity for another public hearing, but after you've had a chance to review it, I would encourage you to reach out to us and just let us know what you think about it. If it's gone far enough in making changes that are going to be helpful,
or if there's still work that needs to be done on it.
I appreciate that, Representative. I just want to say, I think Mr. Kissel has said it quite a lot. He talks about boots on the ground. I think boots on the ground should have brought in for discussion while this bill was going on. I mean, we're the ones that do the job. I don't feel our input was really taken into consideration. So I think that needs to be looked at next time something like this is brought up.
Okay. No, thank you. And I appreciate that. Thank you, Mr. Chairman.
Thank you, Representative Quinn. Are there further questions or comments from the committee? Seeing none, I would just echo Mr. Howard, Representative Quinn's comments. And we'd love to hear further feedback on the substitute language. So please do provide us that feedback when you have a chance to go through it.
You have my word, you'll get my feedback.
And thanks very much for your testimony. Next is Hope Metcalf, followed by Merritt LaJoy.
Hi, good afternoon. My name is Hope Metcalf, and I'm a resident of New Haven, and I also teach the Lowenstein Clinic for International Human Rights at Yale Law School. I will be using my time today to read a statement by Kyle Pashal-Barros, who cannot testify directly because he is incarcerated. Dear committee members, I want to tell you my story in hopes that you will take a stand. In the summer of 2012, when I was 17 years old, I was arrested and detained as a mentally disabled adolescent. There is scientific proof of the psychological limitations of youths as their brains develop. The evidence is as old, if not older, than I am young. My dual conditions of an underdeveloped brain plagued by multiple mental illnesses pushed me far beyond DOC's management capabilities. As a result, almost immediately, I was placed in prolonged isolated confinement. Since then, I've spent more than 5 years in isolation, including several years at Northern. Really, I never truly made it out. The last years of my brain maturity, a stage in all humans' lives that significantly shapes their future adult selves, was in isolated confinement. Things grew worse. I've turned into someone I shouldn't be, and who I was feels like a lifetime ago. I've deteriorated to the point where I've gone days without sleep. I've hallucinated. To my horror, I've developed intrusive thoughts that would make Stephen King's best horror story seem like a child's bedtime story. I pray the scientific consensus is wrong, but research finds that some of these effects are irreversible. The DOC took someone's child, me, and pushed them to the brink of insanity. They took a father, me, and rendered him gravely disabled. While in this toxic environment, I've been degraded with incel restraints. I've been brutally sexually assaulted by people labeled correctional officers. I've been treated in ways that if you did to a dog or a cat, you'd have an inmate number. I've been found gravely disabled and psychologically in need of inpatient hospital care. Indisputably, I am supposed to not only be removed from this environment, but I'm supposed to be in a hospital, but here I am. The executive order will never provide the mental health care that I and others need and deserve without oversight and accountability, neither will the Connecticut Department of Correction. We need external oversight and we need it desperately. Please support SB 459. Thank you.
Thank you, Hope, and it's great to see you. And thanks for all your work on this and every other issue that you've been working on with the students of the Lowenstein Clinic. Are there questions or comments from the committee? Questions or comments from the committee? Seeing none, I'm going to be handing the gavel back to Chairman Winfield. I just want to apologize to Thomas Burr, whom I skipped accidentally. And Mr. Burr, if you are here, please come forward and you can give your testimony.
No worries, and thank you, Representative Blumenthal and members of the Judiciary Committee. My name is Thomas Burr, and I am the Community and Affiliate Relations Manager of the Connecticut chapter of the National Alliance on Mental Illness, otherwise known as NAMI Connecticut. I am testifying today in support of SB 445, an act concerning the provision of emergency medical services to an individual who is in the custody or control of a peace officer, SB 458, an act concerning the provision of substance use disorder services and mental health services to individuals who are incarcerated, and last but not least, SB 459, an act concerning the Commission for Correctional Oversight, the use of isolated confinement, seclusion, restraint, strip searches, social contacts for incarcerated persons, transparency for conditions of incarceration, and correctional officer training. You have my written testimony, and the committee leadership should have received many emails from our members and partners, so I will briefly summarize. Regarding SB 445, this bill's stated purpose is to require the provision of emergency medical services to an individual who experiences an emergency medical condition or is medically unstable while in the custody or control of a peace officer. While in a perfect world, anyone in distress with a mental health condition would always be initially addressed by responders from mobile crisis, the reality is sometimes police are called or simply happen to be the first to arrive on scene. Requiring emergency medical services be provided to those that require them should lead to better outcomes for both the persons needing assistance as well as the first responders. Therefore, NAMI Connecticut supports this bill. I'd also like to echo Kathy Flaherty's earlier comments regarding a bigger focus in Connecticut on creating more non-criminal justice and non-locked ward focused solutions for people in emotional and psychiatric distress. Regarding SB 458, this bill is intended to require the Commissioner of Corrections to review, evaluate, and make recommendations on the provision of substance use disorder treatment services and mental health services to individuals who are incarcerated. NAMI Connecticut wholly supports this, as the current availability of substance abuse and mental health treatment in Department of Correction facilities to date has been underfunded, understaffed, sporadic, and could definitely stand improvement. Last, regarding SB 459, I am pleased to hear that there is a revision of this bill that has been successfully negotiated. I can't wait to see it. As part of the Stop Solitary Connecticut Coalition, we support SB 459. The bottom line from our perspective is simply this. We know that solitary confinement can be a trigger for serious mental illness. When you couple this with the fact that most of the people that are incarcerated will eventually re-enter society, solitary confinement is simply bad public policy, both from a human and fiscal perspective. The citizens of Connecticut deserve better from our government. So again, glad to hear that an agreement has been reached. Therefore, in conclusion, we support SB 445, SB 458, and SB 459. Thank you so much for your time and attention. I'd be happy to answer any questions you might have.
Thank you. I couldn't get off mute. Thank you. Are there comments or questions from members of the community? Comments or questions? I don't see any. Having said that, thank you very much for joining us to offer us your testimony today.
Thank you, Senator.
Next, we'll hear from Merritt LaJoy.
Good afternoon. Last year, the legislature passed Public Act number 21-102, which in part dramatically changed the eligibility for a convicted defendant to file a motion for a sentence modification. I testified then in strong opposition to the proposal due to the devastating impact the proposal would have on crime victims and their families. Now, Senate Bill number 425 seeks to clarify that the changes made to the sentence modification statutes were intended to be retroactive. The Office of the Victim Advocate strongly opposes this legislation. A few months ago, a surviving family member of a murdered victim contacted the OVA when they received notice that the inmate had applied for a sentence modification. The OVA had to explain that the law had changed and that the inmate was now eligible to make the motion. The prosecutor also explained that due to the change in the law, the prosecutor no longer had to sign off on the motion, a safeguard that was removed last year. Obviously, this news was devastating. The inmate was convicted of murder and sentenced to 60 years in prison. Although the crime occurred on September 3rd, 1986, the inmate was not charged until February 17th, 2010, after DNA identified him as the perpetrator and exonerated a man that spent 21 years in prison for that crime. Last week, I had the unfortunate opportunity to attend that hearing. It should be noted that while the OVA was notified of the hearing date by the victim, the sentence modification hearing was not publicly posted on the Judicial Branch website or on the daily docket information. Additionally, the hearing was conducted remotely, so the OVA had to contact the clerk and request the team's link to attend the hearing. In essence, these sentence modification hearings are being conducted in secret. The hearing began with the inmate explaining his reason for requesting a sentence modification. COVID-19, that was it. The prosecutor informed the court that the inmate had served about 10 years of his sentence, and that he had not satisfied the 25-year mandatory minimum portion of that sentence. The prosecutor also offered details of the heinous murder and subsequent conviction of the wrong individual. The surviving family members then offered their victim impact statements. Aside from the obvious pain still present in their lives, the victim also shared their extreme disappointment in now having this disruption to their lives every 5 years. You see, new subsection C was added last year. Subsection C states that if after a hearing, the court denies a motion to reduce the defendant's sentence or discharge the defendant may file a subsequent motion after 5 years. You see, the only available options for the court are reduce the defendant's sentence, discharge the defendant, or deny the motion, which allows the defendant to refile every 5 years. This is the new reality you have created for crime victims. Many crime victims have lost confidence in the criminal justice system, confidence they once had as they stood before the court to deliver their victim impact statement, confidence they once had in the sentence the judge gave them, confidence they once had to pick up the pieces and move forward. That confidence is now lost, and I fear many more will follow. I strongly urge the committee to not only reject Senate Bill 425, but to fix the bad law from last year. I'd be happy to take questions.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? I don't see any. Thank you for joining us. I believe you've joined us in the past. Thank you for coming back again. Next, we have Catherine David.
Yes. Senator Winfield, can you hear me?
Yes, we can.
Okay, thank you. Senator Winfield, Representative Staffstrom, the rest of the Judiciary Committee. I'm a little nervous because I've never done this before, but my name is Catherine Davitt and I'm here in opposition of Bill 425. My mother, Barbara Pelkey, was the murder victim that Merritt was just talking about. She was murdered in 1986. She was brutally raped, bludgeoned to the head and neck, and strangled with a telephone cord at her place of employment. She left behind 4 children, and it's been, September will be 36 years since she was killed. We thought he was going to be serving 60 years, no chance of parole, no early release. That's what we were told. We were kids. Obviously, we were naive to think that things wouldn't change. I asked, where do my rights end and this person's ability to torture us and drag us into court every 5 years, even though he's not eligible? He's not eligible. Why is he allowed to drag us in and torture us every 5 years? We're victims. My family recently experienced the sentence modification. I have to tell you, what victims and their families have to go through is inhumane and cruel. We received the letter stating the request for a sentence modification request had been made. Our first hearing was January 6th of this year. There was a mix-up, of course, that didn't happen. We did a second hearing, January 18th. We were present and everyone but the convicted murderer was in attendance. Staff couldn't reach the Department of Corrections. We tried a third time on February 4th of this year. That morning, we were notified he was in medical isolation and the hearing was not going to happen. Well, we finally had it on March 14th and it was denied, but we had to go through this how many more times? How is it that a convicted murderer of 60 years is allowed to request a hearing and be granted? I wish I'd known last year or I would have spoke up. I've never spoke up at a hearing before. Believe me, I would have been there, but I just was not aware. The bill does not protect victims of crimes in any way. It allows the system to force the victims to relive the horrific events and experiences over and over without regard to our health and well-being. Convicted criminals should not have more rights than the victims and their families. My family, we were 4 children under 13 years old when she was killed. We've been through a lot. I wish things were different. I look forward to answering any questions, but I am in strong opposition of this bill.
Thank you, Ms. Davitt. Sorry for mispronouncing your name.
No, that's okay. Happens all the time.
Are there comments or questions from members of the committee? Comments or questions? Senator Ciccarello.
Thank you, Senator.
And I just wanted to thank you for your testimony today. I know it must be hard to have to talk about such a terrible thing. And I just wanted to thank you for your testimony and your courage today. I will continue to pay attention. I did receive your letter. And if you have any other questions or concerns, you can reach out to my office anytime. And again, just wanted to thank you again for your testimony.
Thank you.
Thank you.
Senator, comment or question from members of the committee, comment or question? I don't see any. Ms. Davitt, I want to thank you for showing up today. And I know you were concerned about your testimony, but you did a fine job. Thank you. Mila Reed Guevara, followed by Tracy Bernardi.
Hi, hello, members of the judiciary. I would like to begin by thanking the co-chairs, Representative Staffstrom and Senator Winfield, for their leadership in putting forward House Bill 5390. My name is Mila Reed Guevara, and I am a 2L at Yale Law School and a student director of the Arthur Lyman Center for Public Interest Law. I spent the last year and a half researching, in conjunction with a community-based coalition, the impact of Connecticut's incarceration lien on citizens in our state. I'm a co-author of written testimony filed by the Lyman Center before this committee in preparation for this hearing. And so today, with my limited time, I'll be testifying to the economic impact of the lien, but I'm happy to answer any questions regarding any aspect of the submitted testimony. Our research has shown that the incarceration lien creates economic burdens, undermines reentry goals. This instability not only harms the targets of the lien, but the communities which they return to. Those downstream consequences contribute to intergenerational debt and wealth gaps. This lien creates an economic burden for not only those returning home from prison, but their families. The amounts that are collected by DAS, sometimes as low as $50, can mean the difference between being able to pay child support or an energy bill. While the collections on this lien only amount to less than 1% of the state budget, they're matters of survival for these families. The lien functions essentially as a poverty tax with long-reaching and downstream effects. In the course of my interviews, I heard from people who told me that their lien obligation forced them to make hard economic decisions. For example, one man told me that the money he would have spent towards his granddaughter's higher education went to the state of Connecticut to pay the cost of his incarceration. As a result, his granddaughter had to take out loans to complete her degree, creating her own debt burden. This economic burden also has direct impact on reentry. Coming home from prison is difficult under any circumstances. The formerly incarcerated will struggle with finding housing, jobs, and simply adjusting to life outside of prison. When someone is faced with the burden of this lien, they might reoffend in order to survive. One person I spoke to was desperate to make some money to get out from under the burden of this lien. If it hadn't been for the strong support of his family members, he would have gone back to selling drugs to survive. Forcing people into these choices harms the communities they return to. If our government is serious about lessening crime, then it should take these economic burdens seriously. If people were to return home to stable homes, they could participate in their local communities and function as leaders, talking about their rehabilitation. Unfortunately, the current reality created by this lien doesn't support this vision and contributes to recidivism rates. If reentry fails, we spend more money on the cost of incarceration. People who go back to prison will continue to incur these liens, feeding into a cycle of incarceration and release back into poverty that exacerbates these community harms and costs the state more money. HB 5390's repeal of the incarceration lien in Connecticut recognizes the harmful effect of incarceration-based debt and seeks to address that harm by removing the sources of this debt. For these reasons, we at the Lyman Center strongly support HB 5390. Thank you.
Thank you. Comment or question from members of the committee? Comment or question? I don't see any. Ms. Reed Guevara, thank you very much for joining us this afternoon. Tracy Bernardi.
Hello, everyone. I just, in the interest of time, I'm just going to start. Thank you for having me. My name is Tracy Bernardi. I am an ACLU Smart Justice Leader, and I am here to testify for SB 459. and the 2022 version of the PROTECT Act. As I lived in Waterbury, and I'm a stepmom of 5 amazing kids, 3 that lived with me. I've worked as a warm line operator. I've been a recovery support specialist, and now I work for one of the largest reentry organizations in the state. And I'm also a person who was incarcerated for 23 years. And from 19, and when I started when I was 19 years old, and I spent 7.5 years of my 23 years that I spent in prison. I spent them in solitary confinement. And I believe that I am an expert on the harm that restrictive housing, solitary seg, whatever you want to call it, administrative segregation, punitive seg, there's a list of names that it is called, but a rose is a rose by any other name. It's solitary is cruel and unusual punishment. We need to ensure that people in Connecticut prisons and jails are not being abused, re-abused, traumatized, re-traumatized. The most abuse happens in the darkest places. Solitary confinement drives the human spirit to despair. I know when I lived in solitary confinement, I ended up hanging myself. And in that moment of hanging myself, I decided that I didn't want to die. I wanted to live, but I needed to figure out how to live. And some of us don't figure out how to live. Some people die. Like right now in this moment, I'm going to be totally honest with you. I'm having complete post-traumatic stress because there is a guard that's present on this call. And I'm sorry that that happens, but that's one of the things that happens when you are in solitary confinement. And when you are a former person that was incarcerated, you have completely, most of you know me and I'm going off my testimony, but you have my testimony to read. I'm just going to say that you move on with your life, but even in the most composed times where you guys have seen me before, never see me. You've never seen me break down or lose it. And I am in a total moment of post-traumatic stress right now. But ladies and gentlemen, I just want to tell you, these are the effects of solitary confinement. And it lives with you. You can move on. You can work in a big organization and you can help people and you can save lives and you can do everything that you can. But when you see a correctional staff, and I'm sorry if you're a good staff, because there are good staff, I don't know, but this is the mode that it sends you into. You know, you start remembering those times in solitary where it wasn't a good staff. And I just want to thank you guys for listening to my testimony. And I apologize that I went off track, but you guys got to see today a real effect. And I did not plan this. You have my testimony.
Thank you. Thank you. Comments or questions from members of the committee? Comments or question? Ms. Bernardi, Tracy, it's okay. It happens. I want to thank you for coming and providing us with your testimony again. I know you've been before us many, many times. It is helpful to get the perspective that you have. Thank you. We will next have Brian Sullivan.
Good evening. Senator Winfield, Representative Staffstrom, Ranking Members Kissel, Fishbein, and all the distinguished members of the Judiciary Committee. My name is Brian Keith Sullivan, Sr. I am a smart justice leader with the ACLU. I am also a proud resident of Hartford, a father of 4, a student, a taxpayer, and a person who strongly believes in accountability, equality, and fairness. Today, I'm testifying in full support of House Bill 5390, an act repealing statutory provisions that impose liability on an individual for repayment of costs incurred when the individual is incarcerated. I support this bill because people who have served their time and paid their debt to society have completed their sentence, period. It is wrong, it's unjust, and it's oppressive to attempt to charge people for the prison debt. I was incarcerated in Connecticut for over 31 years. While incarcerated, I became driven to do anything and everything it took to change the person who I was into a man I can look in the mirror and be proud of. I availed myself of every program in the Department of Corrections and always held employment. I became one of the first hospice volunteers in the state and sat bedside with 20 men whose last breath was in a cell. That experience strengthened my resolve that if the opportunity ever presented itself outside of prison, I would apply the same value and hard work that I did while in prison. I've been home since 2019. Anyone who knows me knows I work extremely hard and stay positive, but the past 2 years have been a challenge. Despite my work ethic and attitude, the great references that I have, my criminal record continues to be held against me. On top of that, I have this prison debt hanging over me and a risk of being sued by the state of Connecticut. If the state charged me $90,000 a year, that would be around 2.7 million. And I could potentially be sued for half of that, 1.3 roughly. That is a staggering number. It is almost unfathomable. When I try to explain it to people, they don't believe me. That Connecticut would try to charge people for each day they spend in prison after they've been released is not only morally wrong, it disproportionately targets Black and Latino residents that will haunt them and their families long after their deaths. I want to be able to pass along what I've earned in my life to my children, to help them be successful in their lives. That should not be vulnerable and have to suffer from my incarceration. Once people have earned the chance to be part of society after incarceration, they should have the opportunity to support themselves and their families. HB 5390 will end an excessively punitive and unfair practice and give members of our society a fair and equal chance to lead successful lives. I thank you for your time. I thank you for listening to me.
Thank you. Are there comments or questions from members of the committee? Comments or questions? I don't see any. Thank you for joining us, Greg. Enjoy the rest of your day.
Thank you.
Next, we have Patrick McGoldrick.
Good afternoon, Chairman Winfield and Staffstrom and other esteemed members of the Judiciary Committee. My name is Patrick McGoldrick. I'm a corrections officer at Garner CI in Newtown, Connecticut. I'm here today to express my vehement opposition to the latest version of the PROTECT Act, SB 459. The irony in the name of this proposed bill is not lost on me because it does nothing to protect the public, inmates, or correctional staff. Before I get into my general opposition to this proposed bill, I'd like to touch on a technical objection I have to Section 2, subsection G12 regarding life-threatening physical restraint. How would correctional staff go about handcuffing a combative inmate during a facility emergency without immobilizing his arms? This is but one example of the impossible situations this bill would place our staff in. While I truly believe that this bill was crafted with good intentions, as the saying goes, the road to ruin is paved with good intentions. I am positive that this bill would place us firmly on that road. This bill strictly caters to, in my estimation, the 3 to 4% of our inmate population who are constantly violent and disruptive. It does nothing for the other 96 to 97% of the inmate population who do their time peacefully and attempt to better their lives in some way. The current executive order, while also good intention, has already caused a huge uptick in both inmate-on-inmate assaults and inmate-on-staff assaults, as referenced recently by Commissioner Quiros. This proposed bill is guaranteed to cause these already elevated statistics to skyrocket. The increased number of incidents, which will occur if this bill is passed, will have an added negative consequence for the vast majority of the inmate population. They will have to secure in their cells until these incidents are complete, which is obviously detrimental to both them, and it causes increased tension in facilities both between inmates and staff. The choice before you is very simple. Either you vote to support the overwhelming majority of the inmate population who do the right thing while housed in our facilities, or you vote to support the small part of the inmate population who will be emboldened to cause more havoc in the facilities and turn those facilities into gladiator schools where no one is safe or protected. If this proposed bill is passed, my colleagues and I will reluctantly be forced to become hands-on peacekeepers on a daily basis. However, I would much rather spend my work days doing what I can to rehabilitate those inmates who want to be rehabilitated in a safe and secure environment, while also protecting all of you who make up the general public. I believe I have made it painfully obvious what the right choice is. Thank you very much for your time today.
Thank you. Comment or question from members of the committee? Comment or question? I don't see any. Mr. McGoldrick, thank you very much for joining us this afternoon.
Thank you.
Next, we'll hear from Greg. Is it Boucher? Boucher? You're on mute, sir. There you go.
Voucher.
Voucher. You may proceed.
Thank you. My name is Officer Greg Boucher, and I've been employed at Garner Correctional Institute, a maximum security facility which houses the highest level of mental health inmates in the state for the past 10 years. And I implore all members of this body to vote no on Bill 459 as is written, as well as any future bills that support similar language. Proposals such as this threaten the ability for correctional officers to safely do their jobs. As activists seek to dismantle the system the department has set in place to manage the most violent and destructive offenders the state has to offer. Segregation units or restrictive housing areas are the units in which we place and manage inmates who are unfit for prison population, who are in violation of housing rules and administrative directives. Solitary confinement is a term being wrongfully used by activists because it garners a negative connotation and stirs up images of Shawshank Redemption or Oz. But the fact is those images could not be further from reality. Unfortunately, the vast majority of you voting on this bill, or who wrote the language in this bill, or who are advocating for it, only know prison through TV shows and movies. And because of that, these important units have already been grossly altered by dangerous progressive legislation that has stripped away the structural measures from our system that allows us to properly and safely manage these inmates and deter future behaviors and limit dangerous incidents in the prison. Sentence durations in segregation units have been shortened to near laughable levels. Violations have been completely dismissed. Consequences have not been applied, while instead greater privileges have been afforded to the inmates, such as more out-of-cell time, allowing for visitation that was previously restricted, more property and belongings in their cells, allowing more time for phone calls, more recreation time, all the while receiving less restrictions, creating an environment where the worst inmates, those in violations of rules, are given the same, if not more privileges than inmates in good standing. This progressive system goes directly against the principles of rehabilitation, where now we have a prison system that rewards bad behavior rather than deters it. If you support this portion of the bill and claim to be in support of eliminating recidivism, you're lying to yourselves. The inmates understand these changes. They understand the loopholes and how to exploit them. They understand that multiple violations will not lengthen their admittance into restrictive housing, that the time will run concurrently. These expanded privileges you've afforded them have not magically curtailed their behaviors. It has not eliminated the violence in prison or the assaults and the danger they pose. In fact, it has emboldened these inmates and increased our incidents. What is lost in this argument is that inmates who are not in violation of rules are not placed in restrictive housing, or as many like to refer to it as solitary confinement. Thousands of inmates come through our system and never spend an hour in restrictive housing, but those that choose to break the rules in prison do. Voting yes for this bill is playing accomplice to the many assaults that will undoubtedly inflict upon correctional officers who are tasked with managing these troublesome inmates, inmates that rape other inmates, inmates who assault staff, who create major disturbances, who viciously assault other inmates, who habitually destroy property, who manufacture weapons, who start fires, who bring deadly drugs into the facilities, who throw urine and feces at officers, who conduct gang activity, inmates who continue to perpetuate. Yes.
Your time is, can you summarize?
Basically, as I'm saying, that we will, if this bill passes in this form or any other form, it's going to pose a great danger to the correctional staff that's in these prisons trying to manage the small population of inmates who are in restrictive housing. I'll take any questions if anybody has them.
Comment or question from members of the committee? Comment or question? I don't see any. Thank you. You jumped on my screen. Thank you very much for coming to us and offering your testimony.
Thank you.
Have a good day. We will next hear from Richard Ross. Lisa Pineda.
Senator Winfield, I'm sorry. I think 61 was trying to get into the room and just joined. Brian Sullivan.
I thought we heard from Brian right after Tracy.
I think you're right.
Yeah.
I think there's a duplicate. I apologize.
No problem. Patrick Wells.
Hello, how you doing?
Hello, you may testify.
Hi, so first of all, my name is Patrick Wells. I am a correctional officer at Garner Correctional Institution for a little over 4 years. I want to start by asking a question. Now, is it typical for the language in a bill to be discussed and changed immediately prior to a testimony?
There's no real typical in the legislature. There was, I'm going to ask the timer to hold up for a second. This is a little unusual, but the language is worked on at different points. The language here has been being worked on for a while, so it would be about right for it to be potentially changed right before we go into this period. Plus, the Judiciary Committee is at the end of its process, so a lot of bills are being worked on currently. You may begin your testimony.
Gotcha. In 2021, Governor Mott vetoed this last proposed bill. He then made an executive order 20-1, which has changed many things to the normal operations of the facility, such as to increase the out-of-cell time to 4 hours, which at my facility, Garner, we have adhered to. Since this, our staff assaults have increased in the last 2 months, or last several months. We've had over 21 staff assaults, over 20 inmate assaults. And with this current executive order, we've now been limited on the amount of time an incarcerated person to be placed in isolated confinement. Isolated confinement is now defined as to be out of the cell for 4 hours a day, and restrictions include no more than 15 consecutive days and no more than 20 days within a 60-day period of time. This places our staff and other inmate safety at a grave risk. So say an inmate gets to a physical altercation with an inmate, he goes to SEG for 15 consecutive days. He does it again within the 60-day period. He can then only go for 5 more days. And after that, he's basically, with this bill, saying scotch-free. So he can continue to be placed in housing units to be able to commit other serious grave incidents. This bill also suggests that incarcerated individuals have an increased out of cell time to 7 hours a day. At my facility, it's barely possible to adhere to the 4 hours of out of cell time. If we were to abide by this, we need to increase staffing to at least minimum 8 officers per first shift, second shift. And this is just by an approximation, approximate about $800,000 in just base salary alone for my one facility, not to mention this bill discussing 1 hour of outside recreation per day. At my facility, we currently offer programming, religious services, grouping, et cetera, and incarcerated individuals aren't even attending that now as we offer it. The other day, I worked in a housing unit where 1 hour Catholic service was offered. We had 15 inmates who designated the religion as Catholic, and out of the 15 inmates, only 2 went. Our in-unit social worker held a group session. Out of 68 inmates in the unit, 3 signed up to be a part of it. We are currently offering more out of cell time. The inmates are currently not taking advantage of it or even requesting it. So.
Is that your testimony?
Yes.
Okay. Comment or question from members of the committee? Senator Ciccarella.
Thank you, Senator. And I just had a quick question for you, Patrick. I understand that there is some additional language that you have not got a chance to see. So it makes it hard to really speak on the language that's here because it's kind of irrelevant. Considering you have a great understanding of what's going on in the facility, if you were to see a few things come out of the bill as it is written that you were able to read, what would you see come out that would be beneficial to make sure that the inmates as well as the staff are safe and be able to conduct the day-to-day business without putting anyone in any danger, including the general public? If you were to hit a few of the most eye-opening pieces of this legislation based upon your day-to-day boots on the ground experience.
Sure. We're currently, like I said, we're currently adhering to the executive order from Lamont for 4 hours of out of cell time. We're barely making that possible. If we're talking about, to make things safe, I think if we continue to operate how we've been operating and not making any changes where we are, it's like you said, it's kind of tough to discuss on this as to all this language is changing prior to today. So I have no idea if anything is changing to the strip search language, if anything's changing to the mechanical wrist restraint language. So for me to honestly speak on that, it's pretty tough for me to do that, as I'm sure it is for a lot of people. So.
I appreciate, I know that's a challenging question, not knowing what is going to be taken out, but since the implementation of the governor's bill, have you seen an increase or a decrease or any change in the activity when it comes to either assaults on inmate or inmate on correction officer?
Oh, absolutely. I mean, so we're talking about what I discussed before about the amount of time that an incarcerated individual can spend in the segregated housing unit, which when we're defining segregated housing, it's no longer really segregated or isolated confinement because they are allowed or offered 4 hours of out of cell time. So these guys know that if, they assault someone else, they assault an inmate, they assault a staff member, they, light a fire within a housing unit, that they can only go to the isolated confinement for 5 days, 15 days, maximum of 20 days. So at that point, the repercussions are no longer there. So to them, it's like, okay, I can kind of reign free and do whatever the heck I want because there are no repercussions any longer. So this, just allows them to kind of just do whatever they want. And, I've spoken to inmates. I have relationships, rapport, speak to inmates on a day-to-day basis as an officer in a housing unit. And I hear specifically from them, there are no repercussions. So, I'm just going to keep on doing what what I've been doing.
And as a result of that, I know then clearly there's some more violence, both inmate and on inmate as well inmate on staff. Is there an increase in contraband or weapons or other things that may jeopardize, again, the day-to-day flow of operation as well as the safety and security of the inmates and the officers?
Yeah, absolutely. I mean, I don't know if I'm really able to speak about specific incidents within my facility, but, there have been incidents where they found weapons, they have found drugs, and this is just speaking in my facility. Since this executive order has come about last year, we've gotten rid of our maximum security facility, Northern. We've now decreased some of our administrative segregation rules and our units and stuff like that. So the repercussions for these kind of inmates are very, very minimum, and they're continuing on with this, knowing that there are little to no restrictions.
Thank you so much for answering the questions and giving us a kind of understanding of the day-to-day. I really appreciate it. Stay safe.
Thank you.
Thank you. Mr. Wells, just in answer to Senator Ciccarelli, you just said that since the executive order, you found weapons and drugs. Is your testimony that you weren't finding any of that stuff before that?
No, I didn't say that. I just said that they have found that since then. So, I mean, I've only been there for a little over 4 years. This stuff has been found before my time, before I started there, before I was born. So I couldn't say specifically on the statistics of the amount of stuff since the executive order from last year, but I know that, we have found, that those things have been taking place.
Okay, I just want to, because it sounded, maybe just to me, but it sounded like you were suggesting that it wasn't happening before that. I just wanted to get clarity. Comment or question from members of the committee? Comment or question? Mr. Wells, thank you very much for joining us to offer your testimony.
Thank you.
Next, we'll hear from Joseph Busalachi. Maybe. I'm not sure I got that one right. Joseph Busalachi, Ed Valente. Ed Valente.
Hello, thank you. Sorry for the delay. I'm General Chairman and Director of the Association of Commuter Rail Employees. I'm representing the organization today in support of Senate Bill 462, an act concerning assault of a public transit employee. Our members are conductors, locomotive engineers, signal maintainers, rail traffic controllers, yard masters, and assistant station masters in the Metro North Railroad system. The bill lists specific actions that will constitute aggravated assault of a public transit employee as being a Class C felony. ACRE supports this change. In some respects, I wish I wasn't here today, but frankly, the situation at Metro North has reached a boiling point. The overwhelming majority of passengers who ride our trains are good people. They depend on the conductors and our team to get them to and from their destination each day. It might be the dad going to work from Stanford to Wall Street in Manhattan, or it might be the mom doing the same thing from Milford to New Haven. It could be kids riding to and from school. Maybe it's a family going to the Yankee game together. Whatever the reasons, we carry tens of thousands of people at Metro North every day. Our job is to get these passengers to their destination safely and on time. I maintain that our members do this job well, and they do it with a very high degree of professionalism. This is happening despite one of the most difficult times in our history. Unfortunately, we have seen an uptick in the number of unruly, intoxicated, or disturbed passengers who refuse to pay their fares, bother other passengers, swear or act in a disorderly, harassing, or even violent manner. These individuals scare our riders and make their trip uncomfortable. Let me give you an example of a situation one of the conductors had to go through. He was loading his train, answering questions from the passengers. One of the passengers asked him if the train went to a certain stop. So as the conductor was trying to tell them, no, the other train is over here. For some reason, the passenger, the customer, spit right in the conductor's face, got in his eyes. He called for the police, and he ended up missing 6 weeks of work on, obviously had a COVID test. He was on anti-HIV medication, which kept him out of work because he works in a safety-sensitive position. That is the effect of something like that happening. We want, with this bill, to make people who take those, make those decisions and act that way to be more accountable. Here today. I also just want to conclude by saying that the vast majority of our customers, 99.9%, are good and decent people. Senate Bill 462 will protect our members and our passengers and help make the riding public experience safe and enjoyable for everyone. Thank you for your time, and I'll be happy to answer any questions that the panel may have.
Thank you, Mr. Valente. Are there questions or comments for Mr. Valente? Comment or question? I don't see any. Thank you very much for joining us to testify before the Judiciary Committee this afternoon. Have a good day. Next, we'll have Alexis Wilcox, followed by Darrell Johnson. Alexis Wilcox, Darrell Johnson.
Darrell Johnson is here.
You may testify. We can't, just so you know, we can't see you. So if you can turn on your camera, please do.
Okay, let's see. I'll make it better. Am I there? I'm sorry, my camera seems to be unable to.
Okay. Well,
my image, but you can hear me okay, correct?
We do hear you. Proceed.
Okay. Well, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the committee. My name is Darrell Johnson. I'm a conductor on Metro North Railroad, and I also serve as legislative representative for Local 1 of the Association of Commuter Rail Employees. I'm here to voice our strong support for Senate Bill 462, and that concerning assault of a public transit employee. And I also thank you for raising this discussion today. You just heard from my colleague, Mr. Valente. He outlined our thoughts on this bill in his written statement. And I just want to say that we pride ourselves, our members at Acre One, we pride ourselves on our focus of getting our passengers to their destination safely and on time. Now our ridership is coming back as the pandemic has been easing. We're seeing more riders, but unfortunately, we also are seeing more incidents of violence and threats against our members that involve firearms, knives, and other weapons such as box cutters, pipes, and so on, as well as those who spit or throw bodily fluids on our members. I'll give you a quick example. Service on Metro North came to a stop not too long ago because we had to deal with one passenger who refused to pay his fare. Our conductor on that train asked for payment. The passenger proceeded to argue with the conductor over the fare and then hit him, and the conductor wound up on the floor. When the train stopped at Westport train station, the passenger tried to get away, tried to flee on foot. And fortunately, he was quickly apprehended by officers there. But that didn't, he didn't get away without injuring the conductor on that train, the guy who first encountered him. And I just wanted to say that throughout the pandemic, we've been there. We're considered essential, and indeed we are. We've got those healthcare workers and other frontline workers through the pandemic. We've got them to their places of employment, healthcare workers, and so on. We've provided public transportation in and out of the city and in and around the cities in Connecticut, and we just kind of are reaching out in hopes that you guys will kind of back us on this as well. So we've been there for the public, and we just kind of want you to kind of be there for us, and by making these bad actors accountable. And thank you for considering our views today. And we also have Alexis Wilcox. She's a conductor, and she wants to give a little statement about something she encountered. Actually, several situations she had to endure.
I see that Alexis has joined us, and I will go back to her. Let me finish your and see if there are comments or questions for you. Are there comments or questions for Mr. Johnson? Comment or question? All right, seeing none, thank you very much for joining us this afternoon to provide us with your testimony.
Thank you, sir. Thank you. Thanks to the committee.
Next, we'll hear from Alexis Wilcox, and I see your camera is now on, so you may proceed.
Thank you. I've summarized my account in the following written statement, so I'll be reading that in case I'm not looking at you, that's why. Senator Winfield, Representative Stateroom, Senator Kissel, Representative Fishbein, and members of the committee. My name is Alexis Wilcox. I am a Connecticut resident and a conductor on the Metro North Railroad. I have a brief story to tell you. Since starting with Metro North on October 31st, 2018, I have been threatened with spit in the early stages of the pandemic, punched in the face, and been harassed. In the first incident, a young man boarded the train at Grand Central Terminal. When I asked him for his ticket, he admitted he did not have one. He then proceeded to call the female conductor and myself several insulting names, and he cursed at us. As the conductor left to go get the police, while she was gone, the young man followed me around, audibly working up the spit in his mouth and alternately yelling at me and stepping much too close for my comfort. At one point, I was holding my spring conductor's cap in front of my face. This is what that looks like. It's not much protection. And he asked me why I was doing that. I replied, I'm protecting myself as best as I can in case you spit on me. He walked off the train and up the platform toward my conductor, who was returning with the police. The police walked away beside the young man. After that, in September 2020, I was punched in the face after I had knocked on the bathroom's door, and a man exited. He did not have a ticket. He asked for a free ride to New Haven. Since this was the third time in 4 weeks, the same passenger was asking for the same thing. I refused and told him he would have to exit at the next station. As I escorted him to the door, he asked again for the ride and said, why am I doing this to him? He then sucker punched me on my left eyebrow and he stepped out of the car. I immediately closed the door with my key. Finally, in early 2022, I had a passenger with no ticket get on at Fordham, going to Grand Central Terminal. After inappropriately pulling down his multiple pair of pants to readjust himself and his clothing, he asked if medical could meet us in the terminal. We called ahead and asked for that assistance. I assured the man that we would have help for him when we got to the terminal. At this point, he started walking up and down the aisle of the car, muttering and directing his spit spray at passengers, engaging in other inappropriate behaviors, and threatening to rape a female passenger. When we arrived at the terminal, he just walked off the train and up the ramp. Please make it clear that these types of assaults against us will hold these aggressors accountable. Ladies and gentlemen, we are here to ask for your help and protection. Senate Bill 462, an act concerning assault of a public transit employee, will do that. Thank you for your time.
Thank you. Comment or question from members of the committee? Comment or question? If not, thank you very much for joining us, providing us with your testimony and giving us some insight with your story. Have a good afternoon. Next, we have Lenore Dewey, followed by Alex Zarkov. Lenore Dewey.
They have not accepted the promotion to panelist.
Alex Zarkov.
Good afternoon.
Good afternoon. You may testify.
Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. For the record, my name is Alex Sarkoff. I'm the Executive Director of the Connecticut Sentencing Commission. The Commission is a permanent statutory body of 23 members that include 4 judges, the Chief State Attorney, the Chief Public Defender, as well as appointees from each caucus at the legislature. I'm here to testify in support of 2 bills. First is Senate Bill 425, an act concerning sentence modification. Last year, the General Assembly passed major reform to sentence modification, a process that gives judges discretion to reevaluate and modify a criminal sentence. Under previous law, defendants had to obtain an approval from the state's attorney for the court to hold a modification hearing when the defendant's sentence exceeded 3 years. Legislation that passed last year removed the prosecutorial approval requirement for modifying the sentence of 7 years or less of incarceration after a hearing and showing of good cause. In addition, those defendants whose sentence is a result of trial are now allowed to move for sentence modification without an agreement from the state's attorney, regardless of sentence length. The bill before you would simply clarify that the changes to sentence modification passed last year are to be applied retroactively. Sentencing Commission in its discussions has always intended for the bill to be retroactive. I'm also here to support House Bill 5390, which would repeal the cost of incarceration liens. Current law gives the state a claim for incarceration costs against property owned by formerly incarcerated people, including the state, lottery winnings, inheritance, and lawsuit proceeds. Sentencing Commission members have noted in their deliberations that these policies generate barriers to reentry and encourage a cycle of poverty that is difficult to escape. Formerly incarcerated people face challenges finding employment and housing, and these liens make it all the more difficult to make progress. Thank you for raising these bills and opportunity to testify.
Thank you. Comment or question from members of the committee? Comment or question, Representative Paul.
Thank you, Mr. Chair. Mr. Sarkoff, thank you for being with us. I have a couple of questions. One has to do with, I think you've mentioned that both prosecutorial and defense sides are united in believing that this bill should be retroactive. Can you explain how rare is that? It seems to me that that probably is pretty unusual, is it not?
Representative, as you know, we have an adversarial criminal justice system where prosecutors and public defenders are often on opposite sides in the courtroom. But on the policy level, Sentencing Commission presents an opportunity for members to come together and sometimes propose to the legislature consensus proposals. It doesn't happen often, but every year we have a few for the legislature, and last year's proposal and this year's proposal were both consensus proposals, and you can see that from testimony from the public defenders and from the Division of Criminal Justice today.
Yeah, thanks for that. I think that's significant. And can you just give a couple of quick examples of what kind of person might benefit? I mean, the one that occurs to me would be a person who was incarcerated when very, very young and has, for lack of a better term, learned his lesson. Can you help me understand who would be most helped if this were made retroactive?
Well, the statute is very broad and it's standard. You have to show good cause. So it could be people who were convicted when they were younger, people who received longer sentences that have minimum mandatories. Now, this doesn't affect minimum mandatories. They'll still have to be served first. But it at least provides an opportunity for people to, for some people to get a foot in the door and so they can present their case. It doesn't guarantee modification, but it allows some people a foot in the door.
Thank you. And then, Mr. Chair, just bear with me, one more question quickly. Regarding HB 5390, do you know if other states are moving in this direction or not? This is the bill I'm referring to as the liens.
Certainly, other states have been moving in this direction for years. Other people have testified may have more of a complete picture, but several states recently have made these changes, including Illinois, New Hampshire, California in 2020. So this is definitely a movement that's been happening for years.
And I think those are 3 states in which Connecticut tends to have similar juvenile justice ethos. So that's interesting. Thank you. Thank you for being here, Mr. Sarkoff. Thank you, Mr. Chair. That's it.
Thank you.
Thank you, Representative. Senator Kissel.
Thank you, Senator Winfield. Alex, great to see you. Thank you for being patient today. Earlier, we had testimony from a young lady. She was quite young when her mom was killed. It took a while. There was apparently an incarceration of someone that was innocent. So that's a injustice in and of itself. But later on, it was DNA that found the real culprit in what clearly was a heinous murder that took away the mom of 4 young children. And what I gathered from her testimony, now this is one of the children grown up, was that the perpetrator that was found guilty based on the DNA was sentenced to 60 years. And I didn't ask her any direct questions when she came up, but what I sort of gathered was that there was at least 25 years that could not, that the individual would have to serve. So we have this sentence modification law that we passed, and I know we want to modify it, so there's a vehicle, but it sounds to me, because this gentleman applied for the modification after just 10 years, and it really, it got scheduled and canceled and scheduled and canceled and scheduled and canceled, and it really was putting through these the family members, the children of the victim, through this horrible time in their life all over again. And the judge just clearly within the law said, no, denied. And they're fearful that they're going to have to live through this for, in 5 years. And again, if there's a minimum of 25 years that has to be served, I don't understand why the statute has been framed where the sentence modification can just go forward. If there's something fundamentally wrong, we have the habeas corpus process. So if we have this bill before us, do you see any problem with us trying to remedy that, at least if there's a portion of the sentence that could not possibly be waived or modified by the judge?
Thank you, Senator, for the question. I would say a few things. First, if there's a minimum mandatory, it sounds like there may have been in that case, if the sentence was that long, that has to be served first, and you can't modify minimum mandatory, and that's in statute. Second, there's still a prosecutorial role here with the bill that passed last year and the bill that's before you this year. Any sentence that carries over 7 years, that's plea bargained, in order to modify that sentence and bring a case forward to a judge, you would still need to get a permission from the state's attorney first for the judge even to hear the case. Right. So so there is that, and also until last year's bill, defendant could apply for sentence modification as many times as they want. Under the bill that passed last year, you have to wait 5 years. So if the motion is denied, now you have to wait 5 years to come back with a second motion. Before, it was really unlimited.
So Alex, and again, I hope you don't mind me calling you by your first name, but we just go so far back. But I appreciate that, because I sort of vaguely remember when we were debating that bill, and I did sort of remember that it went from somewhat unlimited to it actually was more restrictive. The testimony, though, I heard from some folks earlier was that they felt that the state's attorney didn't have to sign off on it. I'll have to dig into that fact pattern more closely, but it just was heart-wrenching to hear them having to go through that. And if we can make that system more equitable, at least we have a bill that seems to be moving through the process where we could do that. But I appreciate all your hard work. And you guys do an awesome job on the Sentencing Commission, tackling some really nettlesome problems. And again, have a fabulous weekend, and thanks for everything that you folks do and the Sentencing Commission do. Thank you very much, Mr. Chairman.
Thank you.
Thank you, Senator Kissel. Comment or question from other members of the committee? Comment or question? I don't see any. Mr. Sarkov, thank you for joining us again. I'm sure we'll see you again in about a year. Let's see, we have Lenore Louis has joined us. Are you there and ready to testify? Or at least I had you. All right. maybe some issues going on there. Stephanie Valentin, Germano Kimbrough, Brittany Lamar, Sean Kyler.
Thank you, chairs, vice chairs, ranking members, and members of the Judiciary Committee for the opportunity to share with you the Vera Institute's research and experience related to the practice of solitary confinement in the United States. My name is Sean Kyler. I am the operations manager for the Advocacy and Partnerships Department at Vera, a 60-year-old national organization that works to transform the criminal, legal, and immigration systems until they are fair for all. As you all know, Vera has been a proud partner of the state of Connecticut on groundbreaking work to transform its justice system, most notably in co-creating the true and worth young adult units at Cheshire and York Correctional Institutions. And we strongly believe Connecticut could again demonstrate its leadership in justice reform by choosing to seriously restrict the harmful and counterproductive use of solitary confinement through SB 459. When solitary confinement is not comprehensively restricted, it is abused in three ways. Its use becomes the default, confinement becomes more lengthy, and it impedes reentry planning. Conversely, restricting solitary confinement can increase safety for incarcerated people and staff. For example, you heard testimony earlier about Colorado. And when Colorado ended its practice of solitary confinement in 2017, by guaranteeing a minimum of 4 hours out of cell time for even its most restricted individuals, assaults within the prisons declined by 17%. In 2 Colorado prisons, assaults, forced cell entries, and the use of heavy restraints declined by 40%. When Maine reduces population in solitary confinement to less than 1% and guaranteeing people in restricted housing greater out of cell time, violent incidents in the population fell. And when Washington State experienced a 57% reduction in serious assaults on staff and a 45% decrease in self-harm and suicide attempts in solitary units when it decreased its use of solitary confinement. SB 459 will seriously restrict the use of solitary confinement and contains 2 important safeguards: oversight and data sharing. Independent oversight ensures the practices on the ground match the values and policies that are supposed to govern institutions. Data collection and sharing will make sure that any use of solitary confinement is tracked so that the public can see if the law is being followed. Again, I'd like to thank you for the opportunity to share this information. Thank you for contributing to the national effort to comprehensively restrict solitary confinement by supporting SB 459.
Thank you, Mr. Kyler. Comment or question from members of the committee? Comment or question? I don't see any. Thank you for joining us and sharing your testimony with us this afternoon. Enjoy the rest of your day. I see that we have Brittany Lamar. You may testify. Just before you testify, Ms. Lamar, let me give the same PSA that I did earlier. The administration is working to make sure that people are able to get in and testify. You will get a notification when you do. Please join as a panelist so that we can get you on. Ms. Lamar, you may testify.
Thank you. Dear Chairs Winfield and Staffstrom and members of the Judiciary Committee, my name is Brittany Lamar and I'm a Justice Advisor with CT Justice Alliance. I'm writing this testimony to communicate my strong support for SB 459. The CTJA is a statewide youth adult partnership working to end the criminalization of youth. The Alliance includes justice staff, justice advisors, and a steering committee members, which includes lawyers, researchers, clinicians, and social workers who work across issue areas such as mental behavioral health, family advocacy, substance abuse, youth services, legal representation, education. So I'll try and keep this brief because we've had a lot of testimony that's kind of related to what I'm going to say here. But Juan E. Mendez, the former UN Special Rapporteur on Torture, explicitly stated that segregation, isolation, and lockdown constitute torture. Solitary confinement is a form of cruel and unusual punishment for any human being. It's a violation of fundamental human rights. There's unanimous consensus among doctors, mental health providers, and corrections professionals that isolated confinement causes serious harms to an individual's mental and physical health, harms that can be irreversible. More potently, Additionally, I can speak from experience about the detrimental effects of having experienced isolated confinement to myself for days on end. During 3.5 years incarcerated, I experienced a cumulative total of 50 days confined to myself for various reasons. Sometimes we would go on lockdown for 5 to 6 days at a time for trainings, meetings, if staff lost something on the compound, and for a multitude of other staff-related reasons. I will never forget the amount of anxiety, angst, and depression I experienced during those days, being unable to speak to family, shower, or move beyond the space I was confined to. Additionally, I can also note that almost always, once the compound came out of lockdown, there were fights within the hour and we were back on lockdown for some time. This was because angst, anger, fear, depression, rage, and impatience were mounting for all individuals for days on end. I would also like to note that this was the result of just 5 to 6 days on lockdown at a time. For individuals who are confined for years in solitary confinement, the harms and depreciation of mental health can be irreversible. SB 459 would eliminate the misuse of lockdowns and bring CT in compliance with the internationally accepted Nelson Mandela rules. I would like to highlight that this is a critical piece of legislation, especially for youth who are incarcerated. For a young developing brain, the traumas inflicted by solitary confinement can have detrimental effects that alter the way young people navigate life and return into communities. As pointed out in the DOJ report on MYI, the use of solitary confinement for young people is extremely harmful and violates the US Constitution. When 95% of our prison population will be returning to society, we should not be returning these individuals with more trauma and mental health issues than when they were initially admitted to DOC. We have added barriers to their successful reentry into our communities and society at large. When it comes to incarceration, the loss of freedom is the punishment. Everything following should be focused on rehabilitation and restoration. That is a system that supports and respects all individuals' fundamental human rights and will lead to lower recidivism rates.
Thank you, Ms. Lamar. Comment or question from members of the committee? Comment or question? If not, thank you for joining us again. It is always good to see you. Enjoy the rest of your afternoon. Next, we will have James Brennan.
Thank you. Senator Winfield, honorable members of this committee. I'm an attorney who practices in Waterbury. I've been admitted to the Connecticut Bar for more than 36 years, and I'm here to support the passage of House Bill 5390, which would end the state's filing incarceration liens on convicted felons from the proceeds of personal injury settlements and inheritances. And I agree with the position taken by the Connecticut Trial Lawyers Association, why incarceration liens are onerous, unfair, and act to set back a inmate's, former inmate's attempt to become fully integrated in society. The settlement of a judgment of a person, and I've seen this happen on numerous occasions, of a personal injury lawsuit is not a windfall. Our system is set up to award persons for compensation to which they are entitled, no more, no less. To take away half their awards is to deny them just compensation. And it not only deprives the inmate, but it also deprives his family, as has been testified by many people before me. And similarly, inheritances. People give to loved ones or people they admire, they want to leave and share their material wealth with them. Nothing in House Bill 5390 would allow a convict to profit from his crime. They've already served their time, they've been punished, they've been found guilty. And so therefore just believe that it just hinders the person from becoming a full member of society and a productive member of society. And I thank you for the time it's given me.
Thank you. Comment or question from members of the committee? Comment or question? I don't see any. Having said that, I want to thank you very much for joining us this afternoon to provide us with your testimony.
Thank you.
Time for another public service announcement. I see that we've had off and on several people join us who may have missed their turn. The way that I've been proceeding is I will go back one or two because there may have been an issue with your connecting. If you're well back, you will get a chance to, but we aren't going to break the flow. We're going to go forward and then come back around to grab you just so that everyone is aware of how we are proceeding. And again, if you get a notification to join us, please do so we can get you in the process. Ramon Garcia. I just saw you, Ramon. You're on. There you go.
All right. Greetings, Senator Winfield and other distinguished members of the committee. My name is Ramon Garcia, and I have been a lifelong resident of New Britain, Connecticut. Since 2018, I have been actively involved in community work, helping the homeless and those struggling with addiction and mental health issues. I have also been working to pass legislation in order to make Connecticut a more just, balanced, and equitable state. Along the way, I met and worked alongside some truly wonderful people, including judges, legislators, and even formed a friendship with an assistant chief state's attorney. Currently, I work with at-risk youth in a number of middle schools to deter them from the many vices they are faced with every day. I also happen to wear the felon label, and I have spent time in about a dozen Connecticut prisons, including time in solitary confinement. I have experienced many situations where corrections officers have placed myself and others in solitary confinement for the most frivolous of things, such as using the bathroom during facility count, or making a three-way phone call, or even refusing to be housed in a cell with someone they fear they may end up getting into a fight with. So rather than move the individual, it is common practice for a lieutenant or shift supervisor to tell you the only cell change you're getting is solitary confinement, or SAG, segregation, or RHU, restrictive housing unit. And so I personally was put in a situation like this in McDougal when I was placed in a cell where someone doing multiple life sentences for rape and murder, even though I was only doing a few years. I was asked to be moved. They never moved me. I practically begged them, and I was arrested while in the facility for defending myself. And even when I faced the judge Scheinblum in Enfield Court, he was so upset and said, "Why did they do that? Why did they put you in a cell with someone like that?" And I said, "That's just how the DOC is." And you can refer back to the transcripts. So this is common practice. They get away with so much, and they have this culture, this blue wall of silence that they stick by. And until that's rooted out and people are held accountable, you will hardly ever see any real change. Thank you very much for your time. Pass SB 459.
Ramon, thank you very much. Representative Porter.
Thank you, Mr. Chair. Thank you, Mr. Garcia, for your testimony. I've talked to many people that are currently serving time, have previously served time, and many of their stories reflect what you are sharing. And it really does fly in the face of what we've heard here today about the most violent people, in Connecticut are the ones that are in solitary confinement. My son was put in there and he was not being violent. He was defending himself as you were. So I think that the whole story needs to be told, and I appreciate you bringing this different perspective, especially through your lived experience. And I don't have any questions. I just really wanted to thank you for making the time to enlighten us on this matter from a different perspective. Thank you, Mr. Chair, for the opportunity.
Thank you,
You're
Robin.
welcome.
Gary.
Thank you.
You're welcome.
Sorry, I didn't mean to step on you. Thank you, Representative Porter. Comment or question from members of the committee? Comment or question? I don't see any. Ramon, it's good to see you again. Thank you for joining us to offer your testimony today.
Thank you.
Dana Brooks. Dana Brooks, followed by Josh Mitchum.
I guess if Ms. Brooks isn't here, shall I go then?
Mr. Mitchum, you are on.
All right. Thank you, Senator. Thank you, Representative Stafford, members of the committee. I come to you today to ask you to support SB 459 to stop solitary confinement and to provide some oversight for the Department of Corrections. I'm speaking in my capacity as a Hartford City Councilman, And a lot of folks have spoken much better than I can about the personal impacts of solitary confinement and other abuses in the system on them. I just want to speak from the perspective of someone who represents a community about the impact on the community. That's Representative Porter actually this morning asked Barbara Fair about that question, and that's really what I'm here to talk about, because we're already in a position where communities of color are over-policed, over-criminalized, and over-incarcerated by tremendous margins. And we're also already in a position where the municipalities where the largest numbers of people of color live are the least served and the most hurt by residential segregation, by educational segregation, by underfunding pilot, by the structures of funding that Connecticut operates on that hoard wealth into various little communities instead of sharing it where it's needed. So our communities are already suffering, the cities especially, Hartford, New Haven, Waterbury, Bridgeport. And what exposing our residents to the abuses of prison without any check does is it sends folks back home when they've done their time more damaged, right? That's the whole community has to take them in and care for them, and does. But we're already communities that are down in so many ways and disadvantaged by state structures in so many ways. And we already don't have the services we need in terms of mental health, in terms of jobs. So to be putting our neighbors, my neighbors, through solitary and its effects is just another downward punch by a system that's been punching down like that a lot. And I would just say there was not too long ago, there was a corrections officer, Mr. Wells, who testified about how if we didn't have the ability to do solitary and handcuffs that we have now, it would require an increase in staffing and an increase in costs. And I would say maybe what it requires is a decrease in incarceration and a complete change in how we treat poor people in this state. So I won't take any more time, but I would urge you all to pass this bill. Thank you for your work on it. Thank you for passing it last time around, and really consider that things like solitary have impacts that radiate out from the individual to families and to neighborhoods, to children, and the damage is really extraordinary. Thank you.
Thank you, Ms. Mitchell. Comment or question from members of the committee? Comment or question? If not, thank you for joining us today. Thank you for your service, and enjoy the rest of your day. Rahisha Bivens.
Hi, good afternoon, Senator Winfield and esteemed members of the Judiciary Committee. My name is Rahisha Bivens, as Senator Winfield said. I'm a licensed clinical social worker. I'm a justice advocate. I'm a board member of Stop Solitary Confinement. And I got involved in this work when my younger brother, Joshua, who has schizophrenia, was incarcerated. And he was held in pretrial detention for 3 years in a cell for 21 hours out the day. And, just imagine my surprise as a licensed clinical social worker when I learned that the one prison in Connecticut, when we were housing people with serious mental illness, that their idea of care and treatment was holding someone in their cell for 21 hours out the day. And the nightmare of my brother's incarceration continued when I went to every single court date and he became morbidly obese in front of my eyes. The nightmare continued, and it got worse when my brother at 29 years old got diabetes and he became insulin dependent and needed insulin several times a day because of the conditions of his incarceration. And the nightmare got worse when he got into a fight because he thought someone was threatening him and trying to rape him because he was hearing voices, and he was put in restrictive housing for 5 days. Now, I tell my brother's story because his story is the story of thousands of people who are incarcerated with serious mental health issues in the state of Connecticut. Now, through my advocacy a year ago, my brother was actually given time served for his charge. And today he's the happiest and healthiest he's ever been. He's on decreased psychiatric medication. He's returning to college in September and fulfilling a lifelong dream to study marketing. He has plans to make a difference in the community he came from in Bridgeport. And I'm clear that that would have never happened if he would have served a longer sentence in prison. And I am urging you today to support Senate Bill 459 as you did last year, and really err on the side of compassion and humanity. There are 13 states, there are over 13 states in the United States who have implemented solitary legislation. And as other people have stated, conditions have gotten worse, violence has decreased. So even though I hear the concerns of people that work in corrections, if you work with us, which what would be allowed to happen with the Ombudsman and the Community Commission, we will make sure that whatever is implemented is not a risk to safety, but it's actually protecting people and protecting yourself, right? And as someone that worked, for years with people with considered difficult behaviors, there are ways to really decrease all that with the proper training. So I am urging you today to support SB 459 and really ensure that when people incarcerated in Connecticut return to the community, that they're actually rehabilitated and that they don't leave worse off than when they entered. Thank you for your time.
Thank you very much. Is there a comment or a question from members of the committee? A comment or a question? I don't see any. I want to thank you for joining us. And I know how you were fighting for your brother. Many conversations about that. Thank you for the work that you're doing. Thank you. I am going to hand this back to Representative Staffstrom.
Thank you, Senator Winfield. Looks like Denise Paley is ready to go.
Hi, thank you. Hi, chairs, Staffstrom and Winfield, and members of the Judiciary Committee. My name is Denise Paley. I'm a resident of Guilford, where I serve as a board member of NAMI Shoreline and on the Connecticut State Advisory Board for DEMAS. However, I'm here today as a mother of my son, who is a person experiencing incarceration, and I'm here in support of SB 458 and 459. I'm here because my child was arrested during his first psychotic episode, and now he navigates his unfolding mental illness through the DOC. Through our experience, I continue to learn truths about how dehumanizing and unproductive our criminal justice system can be, and I'm compelled to speak out with the hope of making it better. According to the recent Connecticut Memo on Mental Health, 40% of our state population in prison has a history of mental illness, and about 30% is living with a serious mental illness. If our prison system is to be effective, it needs to address what caused people with mental illness to break the law. To be constructive, it needs to provide meaningful treatment aimed at more than symptom relief, but aimed at recovery. People incarcerated with mental illness are those most often subjected to isolation, which is in direct opposition to their needs. Isolation is not always used for safety or reserved as a last resort. Anytime minimal contact is taken away for extended periods of time, it's isolation, and this can cause mental health issues for any human being. I've learned people like my child are kept in a cell about the size of a bathroom. It can be difficult to come across basic necessities like a spork or a pillow. There is no outdoor time for fresh air in the winter. Currently, Ellis is in his cell for a minimum of 21 hours a day. This bill would require up to 5 hours a day at a cell, which could benefit his mental health. Ellis has previously been taken to the infirmary for his mental illness, which meant subjection to a strip search and isolation for 23 hours a day. It's how my son is managed during his crisis, in segregation, alone with his illness. When Colorado banned the use of solitary confinement in 2018, Rick Bremer said, "We made the policy change because we are committed to public safety. The research has shown that housing someone in a cell the size of a parking space for 22 or more hours a day for extended periods of time damages them both mentally and physically. Since most people who go to prison, 97% in fact, return to their community, that means we are releasing people back into their communities in worse shape than when they arrived." Personally, I've lived in a state of unrelenting despair since my child's incarceration. At the root, it's not the time away, though, that's most painful. It's the damage that will be done by what our state deems rehabilitation. It's the futility of the system. That's what's most painful. Knowing that every day my child spends in prison, he moves that much further away from any possibility of recovery. So that's why I'm here to plead and beg you, move these bills forward as you did in the past. Please help fix this. Thank you.
Thank you, ma'am, and thanks for being with us today. Lisa Foster.
Thank you, Representative Staffstrom, members of the committee. I'm Lisa Foster. I'm the co-director of the Fines and Fees Justice Center, the only national organization focused exclusively on the imposition and enforcement of fines and fees in the criminal justice system. I am here today to strongly support HB 5390. But before I do, I want to take a moment to thank you all for being here for these 6 hours. We work in legislatures all over the country, and it's rare to see legislators who stay in a hearing for 6 hours, stay engaged for 6 hours. Of course, that's your job. You should be listening to your constituents, but it isn't always the case. So thank you all. I did submit written testimony, but I want to focus my comments this afternoon on providing you all with some national perspective on this issue, and also to address some of the questions that some of you have raised during the hearing. First, Connecticut charges more than any other state or local jail in the country that I am aware of. And that's by orders of magnitude. The next highest pay to stay charge in the United States was Riverside County, California, which charged $142.50 a day. But 2 years ago, California eliminated the authority of its counties to charge pay to stay fees in its jails. So Riverside today charges nothing. In contrast, Connecticut, as others have testified, in contrast to Connecticut, Connecticut's neighbors charge, none of Connecticut's neighbors charge pay to stay fees for their state prisons. But I want you to know that it's not just blue states in New England that do not charge pay to stay fees. Texas, Utah, and even Alabama do not charge pay to stay fees for their prisons either. Second, I want to take issue with the premise of pay to stay fees. Well, the intention may have been to compensate or to reimburse the Department of Corrections for the cost of incarceration. That's not how they operate today. They really are a regressive tax. Connecticut's pay to stay fees go to the general fund, just like any other tax would. And more importantly, our justice system is supposed to serve all of us. People who are incarcerated are in prison as a punishment for committing a crime and to protect public safety. Both of those goals are intended to benefit the entire community. Yet Connecticut attempts to charge the cost of incarceration only to the people incarcerated and not to the broader community. And the overwhelming majority of the people in prison are indigent, and they are the least likely to be able to afford to pay.
Thank you, Mr. We do, on occasion, it does feel like we run our state government like an old Puritan colony with staying here as long as folks want to listen, but that is our system. And I assure you 6 hours is actually not a long hearing for this committee. But we do appreciate being with us. We appreciate you bringing in the national perspective, and we'll be sure to look for those stats on Connecticut's cost vis-a-vis other states in your written testimony. So thank you for being here. Next up will be Allie Perry.
Hi, good afternoon, Representative Staffstrom and members of the committee. And I too want to thank you for the time and the attention you're giving to this. My name's Allie Perry, Reverend Allie Perry. I'm a resident of New Haven and a member of Stop Solitary, and I'm here to speak to Senate Bill 459 and urge your support. I have submitted written testimony, so I just want to use this time to make a few points. First, I want to begin by commending and really celebrating the collaboration that has led to the substitute Bill 459. I think that bill is the fruit of a process that is really critical in this time. Somebody earlier on said dialogue's the word of the day, and I think it is. In a time when our country is so polarized and people are not talking to each other or with each other, but at each other, I think it's really commendable that this bill that we now have has come out of a process of people getting together and talking about their shared commitments and seeing how we can work together. I want to just make a comment about that. Given the polarity and the kind of violent discourse in our society, we heard from correctional officers their concerns about the spike in violence that they're seeing, and I'm struck that the people from the transit system, from the train system, were describing also spikes in violence. We're seeing spikes in violence across the country. It's not just in the prisons, and I think it would be a mistake to think that any spikes in violence are necessarily because of any changes that are happening right now. To the contrary, it's observed in some people. I think as we address the issue of prolonged isolation and limit its use and its abuse, we will see, as we have in other states, decreases in the violence. This bill is really about addressing the need to change the culture of punishment as it has existed in this country as well as in the state. And particularly as we see it being routinely used by the so-called tool of prolonged isolation. For me, this is really a matter of faith. As a religious person who believes everybody carries the image of God, I think given that, we cannot and must not as a society be in the business of willfully subjecting anybody, including those in DOC's care, to prolonged isolation. Why? Because it's inherently degrading and dehumanizing. In no way does it contribute to correction and rehabilitation, and it's disproportionately used in Black and Brown people. This is about our humanity. We cannot be engaged in practices that dehumanize people. So I would suggest we're at an inflection point, not just in Connecticut, but across the country, as more and more states are realizing the need to limit the use of isolation. We heard that from Judith Resnick. We heard that just recently from Raisha. There are other states that have passed legislation. With this bill, the substitute bill 459, we will become aligned with New York and New Jersey that have passed legislation to limit the use of solitary and to implement humane alternatives.
Thank you, Ms. Perry. We're at the 3-minute mark. Seeing no questions, I appreciate you sticking with us today.
Thank you.
Jennifer Root Bannon. Ron Lamorix. Rebecca Harris.
Good afternoon, and thank you for the opportunity to testify. My name is Rebecca Harris. I live in New Haven, and I support SB 459, the PROTECT Act. I will be using my time today to read excerpts from Agustin Morales Rojas's testimony, as he is incarcerated and cannot be here today. My name is Agustin Morales Rojas. I've been incarcerated since 2005, and many horrible things happened to me. I've suffered physical and verbal abuse, as well as sexual abuse many times. I thought no one would help me because I'm an inmate. I truly felt abandoned. I've come to learn that not everyone deserves to be treated like me or other inmates are treated in city prisons. Since the union helps COs fight their cases, the officials have no authority to control what they do. When inmates report any issue, a staff member is told the grievance is thrown away. I have reported a lot of issues, but nothing has happened. When the officer is told about the grievance, the officer retaliates. Even when we go to the box, the food is cold. They pass it out when they feel like it, or when they get tired of playing with their phone or taking a nap. Also, when they strip search us, the officers make comments on your ass. Is it ugly or cute? If we tell a supervisor, all they do is tell us to shut up, and if we persist, we get pepper sprayed. They put us right in the cell with only a mattress and blanket. I support any law that ends isolation and to stop the lockdowns. I was incarcerated at the age of 22 years old. Now I'm almost 40, and I have seen things that I would have never imagined happened in a prison. When I get out, I'm going to need professional help. I've seen an officer named Angel bring alcohol and give it to 2 officers while they got drunk. I reported it, but nothing happened. She continues to work this facility. I've also seen things in Garner CI that marked me for the rest of my life. I have witnessed how officers killed an inmate. Once the inmate was complaining about some medical issue. When the inmate flooded the cell with water, when the officers noticed, they ran in the cell. I heard the inmate scream, "He can't breathe." After a moment of silence, they carried him out with handcuffs, put him out the cell on the floor. He did not move. Medical came to check his vitals and take him away. 2 days later, I found out he was dead. I will never forget it, how they killed him. Thank you, and God bless.
Thank you. Appreciate you being with us today. Next up will be Poonam Diriani.
Hi, good afternoon. Greetings to the committee and thank you for the opportunity to testify. My name is Poonam Diriani. I live in New Haven and I support SB 459. I'm using my time today to read the testimony of Troy Westbury, who is currently incarcerated and can't be with us. My name is Troy D. Westbury Sr., and I am from Hartford. I strongly support the PROTECT Act, SB 459. I support every aspect of the PROTECT Act bill. I feel that the oversight and accountability and stopping extreme isolation and promoting effective alternatives are very important. The Oversight and Accountability Board is needed in the DOC. The rule breaking and lack of accountability that takes place behind these walls is an abuse of power. The officers love enforcing rules, but don't follow the rules. You have officers on their phones constantly, eating at their stations, and not abiding by the mask mandate when it was active. From experience, whenever the commissioner would come, the officers would tell the workers to clean areas that should be cleaned regularly. The public needs to see the rust in the cells and showers. They need to see the worms and the fruit flies that are in the showers and the block. The vents aren't cleaned, nor the mirrors that are in the blocks. There are heavy layers of dust building up on it. Here in Cheshire Correctional, they always find a way to circumvent the system and letting us out of the cell. The term they always use is they are, quote unquote, short of staff, but you will have 4 officers at the desk or 8 officers hanging out in the hallway. If officers aren't on their phones, they are sleeping when we're locked up. When issues are written up, they aren't addressed. It's hard for change to happen when the administration knows about the indiscretions. And Cheshire, they will say they can't run out of cell time the way it's needed to be run. In Cheshire, second shift has the most downtime between first and second shift. Even now, we get 1 hour and 40 minutes out of self-time, which is supposed to be 2 hours. They have included 20 minutes to eat lunch and dinner into the time we were supposed to be out of the cell. We can't use the phone, take showers, and do whatever we need to do. So how is it fair? This is an abuse of law and rules. We are already entitled to 20 minutes to eat lunch and dinner. This is in Cheshire Handbook on page 14. This is circumventing the law that was passed and signed by the governor. I would like for every provision in the PROTECT Act to be passed. The Oversight Accountability Committee and Stop Extreme Isolation and Promote Effective Alternatives will help for accountability within the DOC and mental health with inmates. Thank you.
Thank you. Representative Palm.
Thank you, Mr. Chair. Mr. Yanni, you're one of several people who has testified on behalf of incarcerated people by reading their testimony. Can you tell us, are you working with some sort of an advocacy group or a legal representation group for these people?
I'm a student at Yale Law School, and I know that there are individuals at Yale Law School who work on the Stop Solitary campaign, and I believe I was put in contact through them. And in fact, Madeline Batt, who is speaking right after me, will be addressing this in her testimony.
Okay, would you just make a point, please, of telling your colleagues how much I appreciate your representing the people who can't be here with their own voice. I'm not going to ask you any questions because I know you're speaking on behalf of somebody else, but I do want them to know we are hearing them.
Absolutely. I'll pass that along to the folks who organize these testimonies. Thank you.
Thank you.
Thank you. And thanks for being with us today. And now the aforementioned Madeline Batt.
Thank you. And I want to start by thanking Representative Palm. Those words mean a lot, so thank you very much. My name is Madeline Batt. I live in New Haven, and I strongly support SB 459, the PROTECT Act. However, I will be using my time to highlight testimony from other supporters who cannot be here today because they're incarcerated. As of yesterday, 27 people in prison have written to the Lowenstein Human Rights Clinic, where I'm a paralegal, with testimony in support of SB 459. Some you've heard today, others I urge you to read from the record. We've talked a lot about on-the-ground experience today, but these are the people whose well-being and lives are threatened by isolation and, more broadly, by what Keslin Mendez calls DOC's, quote, power without supervision that is used and abused on a new and different level. Their names are Andres Sosa, Agustin Morales Rojas, Bernard Bury, Diego M. Vaz II, Gerald Terry, Jackie Robinson, Jason Good, Jesus Torres, John Vivo, John Russell Bose, Jonathan Perdue, Keslin Mendez, Chris Prudhomme, Kyle Paschal Barros, Luchise Richardson, Mirage Gochai, Mitchell Joyner, Noah Hendren, Richard Now, Robert Homar, Roberto Alvarado, Shaquille Brown, Troy Westbury, Vanshawn Wheeler, Vernon Vassell, Victor Jordan, and William Wilkins. 18 of them cited specific instances of rule breaking and abuse of power by DOC, including brutal excessive force, degrading and harassing them during strip searches, submitting false disciplinary reports, and subverting any protections from isolation by abusing lockdowns. I'll direct you to John Vivo's testimony on that last point. He attached a record of the days upon days of lockdowns he experienced at Cheshire and the reasons for them. Among them, COs stopping work to watch an NFL game, holidays, and a corrections union party. 6 different people independently wrote that the treatment made them feel like animals. 11 said that the abuse they suffer in an institution meant to rehabilitate instead causes them lasting trauma. And if they try to seek help requesting mental health care, reporting abuse, the response is retaliation or nothing at all. Agustin Morales Rojas, for example, as you heard, has had countless grievances ignored and said complaining too much about sexual harassment during strip searches can get you pepper sprayed. As Vanshawn Wheeler testified, quote, accountability within the DOC is needed because it will stop the abuse and extreme isolation tactics used on us prisoners. I'll end with the words of Roberto Alvarado, quote, I urge this committee to pass the PROTECT Act. You, have the potential to create long overdue changes. It is time that prisoners are viewed as members of the community, as human beings. Thank you.
Thank you, Ms. Brett, for your testimony, or for, I should say, for sharing all this testimony with us today, certainly. Seeing no questions, appreciate you being here. Next up will be Zoe Rubin.
Thank you. I'm a law student at Yale. I live in New Haven, and I strongly support SB 459 or the PROTECT Act. I will be using my time to read testimony from Gerald Terry, who cannot be here today due to his incarceration. They write, my name is Gerald Terry, and I am from New Haven. I'm currently incarcerated in Connecticut, and I strongly support SB 459, the PROTECT Act. Since I've been in jail, isolation has been very troublesome to my mental health. It has been a few times where I was put in solitary confinement for something I didn't do. I spent 14 days. I was only allowed to take showers every other day, no weekends. When I was taken to segregation, I was put in a room and I was told to strip naked, bend forward, take my hands and spread my ass cheeks. And this was with about 6 men standing around me while a camera was on me. It was the most degrading thing I've ever had to do. To this day, I think about it and it makes me want to cry. Being locked up makes you feel like an animal. When you lock up an animal for a long period of time, then let him out, they go crazy. Well, it is the same thing with humans. We are already locked up, then we get put in another jail, seg. We don't know how to deal with that, so we get put in another jail in our mind. That is when mental health issues arise. The DOC don't know how to or is not equipped to deal with. The other day in my block, this dude, we'll call him Jay, and his cellmate, we'll call him A. And A went to work and Jay was in the cell. So Jay told the CO that he is going to hurt himself, or A, So they took Jay and put him in SAG for about 5 days, and then brought him back and put him in the same cell with the same person he said he was going to hurt. They both went to the CO and said, "We can't live together." The CO told them if they want to move, fight, and go to SAG. It's like it's mental warfare in here. On some holidays, we get isolated in ourselves, only to come out for a shower or a phone call. They tell us short staff. It's so many ways isolation affects us, directly or indirectly. I think it should be done away with or revamped to where it helps people, not hurt them. Nowadays, they send people to SAG for any little thing. They say this is a place for correction, and all they do is make us worse. That is why I support the PROTECT Act with every fiber in my being.
Thank you. Thank you for being with us. Next up is Annie Harper. Annie Harper, Heather Zimmerman.
Hello. Can you hear me all right?
Yep, go ahead.
Wonderful. Thank you. Good afternoon, distinguished members of the judiciary. My name is Heather Zimmerman, and I'm a resident of New Haven, and I strongly support SB 459, the PROTECT Act. I will also be using my time today to read Richard Now's testimony. A written copy of the testimony has been entered on the record as well. As others before him, Richard cannot be here to testify with us today because he is incarcerated. Hello, my name is Richard Now. I was from Stratford, Connecticut prior to my incarceration, and I strongly support the PROTECT Act, SB 459. I have been incarcerated for almost 9 years and been housed at 5 different facilities to include Bridgeport, Cheshire, Corrigan, McDougall, and Walker. During my incarceration, I have been falsely labeled as a security risk group member twice and spent 4 years in punitive segregation in these SRG units with restricted access to my family in visits and on the phone, punitive searches of my cell and my person, punitive lockdowns for extended periods of time, of days and even weeks, restricted access to medical and mental health treatment and diagnosis, and restricted access to showers and personal hygiene items, even a mirror to shave. I have contracted COVID-19 3 separate times at Corrigan and was held in the admitting and processing area of the facility for 2 weeks one of the times, with the lights on 24 hours per day, having to use the bathroom and change in full view of all staff, females included, other inmates and outside contractors. I received no recreation or access to outside the cell time. I didn't even have a window so I could look outside to see if it was night or day. I have also been put in restrictive housing several times over my 9 years for a total of a year in increments. I've been subject to strip searches where I had to bend at the waist and part my butt cheeks so officers could look at my anus. When I would refuse, I would be chained, handcuffed, and shackled for days. If I acted out, I would be chained to a bunk, all 4 limbs to 4 separate corners. I had to go to the bathroom, I would go and be forced to lay in it for hours because officials would not let me up. If I still acted out, I would be shot up against my will with meds and put to sleep. This was a repetitive thing for a while because officials would, and still do, change the rules and don't post them when there is a change, moment to moment, refusing to explain anything. I'm not saying prison should be a 4-star resort, but there should be a requirement to learn a skill, get an education in programming, not just be warehoused and tortured or treated inhumanely as some officials do. There's no recourse except to sue officials. There should be some sort of oversight committee, including persons currently incarcerated from each facility. If officials were held accountable, the state would pay a lot less in lawsuit settlements every year. Thank you for your time.
Thank you, ma'am. I appreciate you staying with us and sharing that testimony. Next up will be Catherine Bradley. Deborah Dorfman.
Thank you.
Members of the Judiciary Committee, thank you for the opportunity to be here today to speak with respect to SB 459. My name is Deborah Dorfman. I'm the Executive Director and one of the attorneys at Disability Rights Connecticut. We are an independent nonprofit organization designated as the protection and advocacy system for Connecticut. I have been a disability rights attorney for decades and practicing throughout the United States, representing individuals with disabilities, including numerous individuals who are incarcerated. DRCT, Disability Rights Connecticut, is currently a plaintiff in a lawsuit against the Department of Corrections that is currently pending before the United States District Court of Connecticut that seeks to address discriminatory and abusive treatment for people with mental health disabilities who are kept in isolative status. And I'm here today to provide educational information on several aspects of SB 459 that could have an impact on people with disabilities, particularly mental health disabilities and intellectual disabilities who are in DOC's custody. One impact that SB 459 would have on people with mental health disabilities and other disabilities is that would be very helpful is the limitations on the use of isolated confinement that the bill contains. Research, as others have mentioned today, has shown that isolation has detrimental effects on the human psyche, and the effects can be particularly profound for those individuals living with mental health disabilities and also with intellectual disabilities as well. Another aspect of SB 459 that can be particularly helpful to people with disabilities is that when individuals are placed in isolated status, they do, under the bill's provision, would receive both a medical and a mental health evaluation within 24 hours, and also receive regular monitoring of their well-being, and which can help to protect them from the deleterious effects of isolation. Also helpful to beneficial to people with disabilities is the provisions under the bill that include access to reading materials, writing implements, and at least 2 hours out of their cell will also go a long way to be helpful to people with disabilities. Additionally, the provisions of SB 459 that require reporting on a variety of different metrics, including the use of force, the use of full stationary restraints, in-cell restraints, and therapeutic restraints can also be extremely beneficial to people with disabilities because it will help track trends and track what other interventions are being used in advance to see whether or not other ways in which their mental health, the conditions of their mental health disabilities could be addressed.
Thank you, ma'am. Thank you, ma'am. We're at the 3-minute mark. Questions or comments from the committee? Seeing none, appreciate you sticking it out and being with us this afternoon.
Thank you.
All right, next up will be Nicholas Scarlett.
Hi, thank you so much. Good afternoon, members of the Judiciary Committee. My name is Nicholas Scarlett, and I'm a second-year law student at Quinnipiac University School of Law. I live in Wallingford, Connecticut, and I'm here on the behalf of the Quinnipiac Civil Justice Clinic and as a member of a coalition of Connecticut law schools and community advocates who support House Bill 5390 and the repeal of Connecticut's cost of incarceration statute. This statute allows the state to impose liens on previously incarcerated individuals to recover the cost of their incarceration for 20 years after their release from prison. Under this law, the state can collect up to 50% of any inheritances and lawsuit proceeds that these individuals receive, and can even take their entire estate, subject to some narrow exclusions. Currently, the state is charging individuals $249 for every day they're in prison, which is approximately $90,000 a year, making Connecticut's cost of incarceration statute one of the harshest that we've encountered throughout our research. This statute creates significant barriers to reentry for individuals who have been incarcerated. Money from inheritances and lawsuits serve as important lifelines for helping individuals get back on their feet and successfully reintegrating into society. These funds can help pay for food, housing, education, childcare, and other essential needs that are necessary for successful reentry. With these liens, the state is targeting individuals who are already economically disadvantaged as a result of their incarceration. Studies from the Brennan Center for Justice show that having a criminal record decreases a person's earning capacity by more than half. Therefore, this money in particular makes a substantial difference in a person's ability to become a productive member of society. Taking this money away from people when they need it most increases the chances that they will reoffend and make their way back into the system, further adding to their cost of incarceration debt that they will likely never be able to repay. Individuals targeted by liens and their families have already suffered from a loss of income from their family member being incarcerated. Now they're being punished again by preventing them from leaving money to their children, which perpetuates intergenerational poverty. The state is essentially imposing an additional 20-year financial sentence on these individuals, which raises both Eighth Amendment and due process concerns. So these so-called pay-to-stay statutes were enacted around the country in the 1990s. States are now beginning to recognize the harm that these statutes cause, and some states have repealed their cost of incarceration statute in recent years. New Hampshire and Illinois repealed their cost of incarceration statute in 2019, stating that these statutes are, quote, morally wrong and unconscionable. Connecticut should follow suit by voting to support House Bill 5390, which fully repeals Connecticut's cost of incarceration statute. Thank you for your time, and I'm happy to answer any questions you may have.
Thank you. Seeing no questions, we appreciate you being with us today. Amber Blangus.
Hi there, can you hear me?
We can, yep.
Great. Good evening to the distinguished members of the Judiciary Committee. I appreciate all of the time that you've spent today hearing members of the public and those of our folks who are spending their time incarcerated now. My name is Amber Valangas. I'm a resident of Sherman, Connecticut. I'm here representing Restorative Action Alliance. We are an advocacy group that's made up of both survivors of crime and those who have been impacted by the criminal legal system. I've testified on this bill before. I am here to testify in regard to the PROTECT Act. I also would like to express our support for HB 5390 that would end cost of incarceration liens in our state, and also in support of 458 that would address the mental health of those who are incarcerated. I want to spend my time on the PROTECT Act today as a person who is the spouse of someone who is formerly incarcerated and has had to spend significant time holding the hand of my formerly incarcerated loved one through panic attacks and help him navigate the effects of his time he spent in solitary confinement, and also as someone who has had to explain to my children why these things are happening to their father. I want to address some of the things that I've heard here today and not kind of rehash the arguments. We fully support the PROTECT Act, but one of the things I want to really tear down is this idea that we're choosing between safety and torture, because what I heard from the DOC commissioner is that there has been language that has been worked out, and the important things that we see that are still remaining in the bill are this idea of transparency. We don't have other agencies in our state that just are allowed to police themselves, so that is very important. Also, there is a data collection component and a reporting component that also speaks to transparency and accountability. And then there is a provision in there that talks about wellness for correctional officers. So as we're looking at like the environment of DOC and treating people as people, we need to take into account that we need to treat people who are incarcerated and in the care of the state as such people who are in the care of the state. And then we also need to pay attention to our correctional officers who are experiencing their own set of trauma while they're at work. So all of those things are important. I've heard a lot of agreement today on that. And I think those are the things that we need to focus on as we're working out the language of this bill. I also want to point out that some of the testimony that we have heard today from corrections officers just is, testifying against last year's version of the bill without having seen the language. So I would like both the public and the folks on the committee to take that into account.
Thank you, ma'am. We appreciate your testimony. Seeing no questions, appreciate you being with us today.
Thank you very much.
Alicia Williams, Marco Coria.
Yes, sir. How are you today?
I'm good, sir. How are you doing?
Very good. All the senators, representatives, I'm glad you gave me the opportunity here to speak today. My name is Marco Correa. I am a resident of the town of Newington. I'm a correctional captain for the state of Connecticut Department of Correction. I'm here providing testimony not in complete support of Bill 459. I've been with the agency in the capacity of a correctional officer, lieutenant, and captain with a total of 15 years of experience in multiple types of correctional facilities. I've been physically assaulted on 3 different occasions while on duty in my 15 years and responded to many staff assaults as well as inmate assaults that have led to correctional officers being injured both physically and emotionally. Some have never returned to duty. We work in a violent environment, must be hypervigilant at all times. My duty is to ensure my staff go home every night safely, and offenders are allowed to serve their debt to society safely and according to the state statutes set forth by our legislators. Our duties as correctional professionals is not to punish these offenders, but to hold them accountable. We must not forget the victims, and the people of Connecticut expect correctional professionals to maintain discipline and security every day for 365 days a year. Correctional professionals are men and women in uniform. We are not robots. We bleed and we have emotion. We would also like to go home safely to our families. Our institutions need extensive training in the mental health needs of offenders. Correctional officers and line supervisors do not receive any type of mental health training to help us at our jobs. We are the first line in de-escalation, and it has been done every day in our housing units. Solitary confinement is a term that is far from accurate. Restrictive housing is for offenders who commit crimes within the institutions, and as such, they are held accountable with sanctions. These offenders have access to recreation, books, religious personnel, medical mental health, interactions with other offenders, as well as other correctional personnel. They are simply held in a more controlled environment for a limited time serving sanctions. Many offenders are here to complete their debt to society and do so orderly fashion. 10%, however, do not. The 10% are intent on assaulting each other, smuggling contraband, creating weapons, assaulting staff, manipulating others, and impacting normal day-to-day services of the agency. These 10% are controlled with the tools that are provided, from restraints to verbal intervention and a last resort force to maintain order and discipline. The 10% are the reason for our hazardous duty. We maintain order and ensure the remainder of the population is safe. We are not strip searching offenders for harassment. It is for safety. The use of in-cell restraints is a last resort to prevent self-injurious actions or deter from any further assaultive behaviors, not to punish. We have procedures that must be followed and de-escalation techniques to remove those offenders as soon as it is safe for all. In conclusion, we have a duty to keep the offenders safe and hold them accountable. The victims deserve that. We have a duty to keep the public safe. We have a duty to the victims, once again, and we have a duty to our correctional professionals to go home safely. Thank you for your time. Thank you for allowing my testimony on behalf of all the brave men and women that maintain order and discipline. We do walk the most dangerous beat in the state every day with pride.
Thank you, Captain. Let me go back to your first sentence. I think you said you're here in not complete support of.
Yes.
So I'm wondering, have you had a chance to look at the new language, or are we still kind of on the old language? I
did briefly review the new language. I was forwarded it to me by my union, but I did not read it in its entirety. Now, looking at the old language, it does speak a lot about mental health for the offenders, also mental health for the correctional professionals. We need that. The mental health of those offenders needs to be upgraded. We have great professionals in there that are providing mental health, but it's not enough. We don't have enough to satisfy the need that is being done. I have 1,000 inmates in my current facility, over 1,000, and it's just not enough. And there needs to be change in that aspect.
No, I hear you, and I appreciate you putting it the way you did, because I think obviously this committee's job is to try to strike the right balance here, right?
Yes.
And that's, I think, what we're trying to do. And I don't think you're going to find a single member of this committee who doesn't think that we are understaffed in our prisons right now. And we recognize that, you know, we are striving to hit the right balance, I think. And you know, I guess what I'm trying to focus in on today is does the new language, again, it's very fresh, it's very new, strike that. Yes. So after you've had a chance to digest it, same invite. I've said to others, feel free to shoot me an email directly and let me know your thoughts on it after you've read the new language.
I appreciate it. I've been back and forth with my state rep as well regarding it, and regarding, you know, mental health of staff as well as the offenders. So it is definitely important, and I will review that, and I appreciate your time.
Yep, hold on. I think I may have a quick question for you from Representative Howard.
Yeah, Mr. Chairman, very quick, and I know we're moving along well here, but I do want to thank you, Captain, for being here, and really all the DOC employees and officers that came here today. But most specifically, your testimony sort of culminated the what I think gets lost sometimes. And you know, I think sometimes the legislature, you know, inadvertently, and certainly society likes to paint an us versus them within our prison. You know, it's the inmates versus the COs. But what I think you just outlined is basically that, you know, you actually do have a care for them. You know, we talked on a different bill on today's agenda about the mental health needs of the inmates in our facility and how we can address that. And I just want to say thank you on behalf of myself and my colleagues that you outlined that the COs, and I'm sure it's by and large, aren't there to intimidate. They aren't there to humiliate, but they are there to try to maintain the safety and get those inmates safely back out in the street. And I think your testimony just encapsulated that perfectly. So I didn't want to steal, you know, 45 seconds of everybody's time to just from a wholeheartedly thank you for the way you laid that out. I think it was very, very beneficial. So thank you, sir.
Thank you very much, sir.
Thank you both. All right. Next up, I have Thomas Lally. Jesse Schwartz. Jesse Schwartz.
Can you hear me?
Yep, go ahead, sir.
Okay. Sorry. Good afternoon, members of the Judiciary Committee. My name is Jesse Schwartz. I'm a correctional officer of over 13 years. I currently work at Cheshire Correctional Facility, and I've also worked at York Correctional Institution. I'm here today to speak in opposition to the Senate Bill 459. I had a prepared statement to give, however, finding out that the language of the bill has changed, I'll do the best of my ability as to my understanding of the new language to speak to that. The first thing I want to speak to is listening throughout the day to a lot of people. They've painted quite a picture of what's being called solitary isolated confinement. Isolated confinement or solitary confinement does not exist in the state of Connecticut as it's being described. We are to believe that a human being is isolated in a small box with no windows, no light, no connection to any other human being or outside source. When in reality, these restrictive housing units are units with cells, windows, along with other cells. Sometimes they have cell mates, many visits from staff throughout the day, including religious services, medical, mental health, as well as correctional officers themselves doing many, many tours. To add to that, there is a minimum of 2 hours of out of cell time, as well as recreation and showers. Isolated confinement as defined in the bill would be what we call the restrictive housing units. The restrictive housing units are to deter dangerous, illegal, and violent behavior of the inmates. It is a small percentage of the population that is predatory to the rest of the population that is just trying to do their time. By taking away the tools that deter such behavior, you are not only making it more dangerous for staff that work in the facilities, but also making it extremely dangerous for the other inmates that are being preyed upon by the predators. To speak on the increase in the out of cell time, following the governor's executive order, out of cell time increased the general population to 4 hours per day. In this new bill, it will increase even more than that. I invite anyone in the committee to please visit a correctional institution so that they could see that these buildings cannot physically accommodate the amount of out of cell time safely, and surely don't have the staff to do so safely. The rise in assaults on both staff and inmates following the increase of out-of-cell time speaks to this point. Your decision on this bill will dictate the safety of both inmates and staff members moving forward. Thank you for allowing me to speak, and have a good day.
Thank you, sir. We appreciate you sticking with us and sharing your perspective. Zakingio Jess, I think it's probably been, go ahead. Hey, how are you?
Good. How are you?
Good.
Oh, all right. Okay. Senator Winfield, Representative Staffstrom, ranking members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Jess Sacanino, and I'm the Policy Counsel for the American Civil Liberties Union of Connecticut. I'm testifying in strong support of House Bill 5390, an act repealing the statutory provisions that impose liability on an individual for repayment of costs incurred while the individual is incarcerated. The ACLU of Connecticut is an organization dedicated to ending mass incarceration, eliminating racial disparities in the criminal legal system, and reducing harms to justice-impacted people. The debilitating effects of mass incarceration linger long after a person returns home to their family and community. The Connecticut legislature passed a law in the 90s allowing the state to collect money from people incarcerated by the state. This law allows the state to charge a person hundreds of dollars per day for each day they were incarcerated. The state is legally permitted to take this money from people's inheritances, from deceased loved ones, from lawsuit proceeds, and from the person's estate upon their death. This purported debt is not included as part of the sentence, nor is it restitution. The state only calculates the cost of a person's debt until after their incarceration has already begun, which includes charges that are completely unrelated to that specific person at all. This debt does not directly cover the cost of the person's incarceration, but instead is deposited into Connecticut's general fund. The state charges over $90,000 per year for their incarceration. That is more than the price that an in-state student would owe for 2.5 years of attendance at UConn, my alma mater, which includes housing, food, and books. For nearly 30 years, the state of Connecticut has wreaked harm upon our residents. Once people finish their sentence, they should have the same opportunity to support themselves and their families like anyone else. Like all barriers to reentry, prison debt not only harms just the person trying to build a new life, but also their loved ones, both living and dead. Because of systemic racism, prison debt disproportionately falls on Black and Latinx people, serving as another wall preventing people of color from building intergenerational wealth. These clear harms are compounded by the fact that Connecticut's prison debt system allows the state to reward its own lawbreaking by clawing back money from people injured by prison brutality. The state, among many other instances, has instituted proceedings against people for settlement money relating to clergy abuse lawsuits, an inheritance from a loved one, settlements from personal injury lawsuits, and even members of the York Correctional writing program who won prize money for an essay. There are also numerous cases in which the state has been sued to recover for prison debt money, there are also numerous cases where the state has sued to recover prison debt money after successful suits against the state for prison brutality. For example, Brian Wiseman died while being restrained by DOC employees, but when his mother sued and won, the state charged his estate with a bill for that and very incarceration that directly caused his death. Connecticut's nearly 30-year prison debt law is inhumane, unjust, and morally repugnant. The ACLU of Connecticut wholly supports efforts to decisively end this practice in Connecticut. We encourage this committee to go even further and completely abolish the practice of charging for prison debt in its entirety. As such, the ACLU of Connecticut supports House Bill 5390 and enthusiastically encourages this committee to support the bill as well. Thank you.
Thank you, Jess. Appreciate you sticking with us.
Thanks.
Next up will be Pierre Jones.
Thank you. It's Pierre. Thank you.
I apologize.
It's okay.
It's been a long week.
Yeah, I understand.
So sorry.
Hello, Senator Winfield, Representative Stratford, and Ranking Member Senator Kissel, Representative Fishbein, and all distinguishing members of the Judiciary Committee. My name is Pierre Jones, and I'm a leader of the ACLU of Connecticut Smart Justice Campaign, and I am here to testify in support of SB 460, an act concerning compassionate and medical parole and credit awarded for release during an emergency declaration. No one should ever again have to die in the custody of the Department of Corrections during a public health crisis. I spent 27 years incarcerated at York CI, and I worked as a hospice worker, caring for women in their final days and months of their lives. I am here to tell this committee that many of those women should not have spent their final days in prison. In particular, I like to speak about one woman who I cared for. I won't say her name, but she was well in her 60s and has been incarcerated for over 20 years. She has multiple sclerosis in addition to other medical issues. She poses no risk to anyone, and her family is willing to take care of her and her needs. The 17 months that I spent in New York during COVID, I don't think I was, it was a scary time for me, and I felt helpless. And during that pandemic, prisoners prisoners don't have a healthy health plan, to begin with. The DOC has been dealing with epidemic levels of Hep C and HIV for years, as well as the infectious disease of MRSA. The inability of people who are incarcerated to access medical care within due budget cuts and unfilled staff vacancies and the end of the relationship with UConn has been known for a long time. But when COVID hit, jails and prisons went into an entirely new level of unhealthiness. At one point, the DOC had a higher infection rate than any municipality in Connecticut. Since the pandemic has begun, 29 people have died after becoming infected with COVID-19. While in DOC custody, 8,374 incarcerated people have been infected, and I was one of them. If we truly respect the lives of those who are incarcerated, then the pandemic is exactly when compassionate release should be easier to obtain. SB 460 seeks to remedy this. SB 460 provides that the Board of Pardons and Paroles shall consider compassionate release during public health emergencies. It recognizes that incarcerated people are dependent upon the state for their health, and since they cannot change their living environment, cannot socially distance, cannot move freely for safety, and cannot otherwise take action that people who aren't incarcerated are able to do.
Thank you, ma'am. Thank you very much for your testimony. We appreciate it. Questions or comments from the committee? Seeing none, thanks for sticking with us on this Friday afternoon. Next up is Thomas Finucane. Mr. Finucane, you're on mute. There we go.
There we go. Can you hear me?
We can. Go ahead, sir.
Okay, happy Friday. Good evening to all the Judiciary Committee members. And thank you for taking the time and the attention to look at this bill. And it's going to be good to hear from everyone. My name is Tom Finucane. I'm a lieutenant with the Connecticut Department of Corrections. I've been a lieutenant now for approximately 2.5 years. Before that, I was a rank and file officer. I worked in the admitting and processing room. I worked with the intelligence unit. I've been spat on, have feces thrown at me. I've had urine thrown at me. I've been punched in the face. I've been to numerous occasions and incidents where I've seen all sorts of things. Today I testify, and as I've seen, a lot of dialogue has been thrown around where things have changed, and that's a good thing. That advocacy groups and the commissioner have come together to make some changes. I just want to point some things out because my testimony has drastically changed since then. I read the new language, and I just want to say to this committee that the new advocacy group only has one member with any correctional experience. I find that a little biased when we have advocates going into the correctional facilities, ex-offenders going into the correctional facilities. We should have more than one person with correctional knowledge there. They could put things in context and explain things to those members who are on that advocacy group. I also want to say that this may be a slippery slope into next door, our neighbor in New York. I'm referring to the New York Times article, January 12th, referring to the cavalier attitude that Rikers Island now has with treating with their offender population. Once you put the most manipulative, predatory offenders in charge of the facilities and take away our tools like the restrictive housing units, it's going to turn into a melee. Right now, as we speak, all across the state of Connecticut, the minority group of predatory manipulative offenders know this. They understand that this is a bill that is only going to be, in layman's terms, give them the keys to the kingdom. I urge all you guys, men and women, advocacy groups, lawmakers, to come into the correctional facilities, actually see what it's about, especially the restrictive housing units. There's mental health staff, medical staff, counselors, supervisors, and your strongest officers that work in those units. On that note, I wish you all happy Friday. Thank you for taking the time to listen to me.
Thank you, sir. And thanks for service to the state and for sticking it out with us today and for giving us at least your initial impressions on the rewrite of the bill. Senator Champagne.
Been listening all day myself, and the restrictive housing. Can you just give me a little more insight on that? To me, it sounds like it's not very restrictive, but can you just give me more insight on that, Tom?
Yes, sir. So when an offender is brought to the restrictive housing unit, it's because they had done an offense. And it's usually a class A offense. We have 3 different classes of offenses. So for this example, let's say fighting or assault on a DOC officer. So when the offender goes into the restrictive housing unit, subsequent things are happening. A strip search to make sure that there's no contraband on the offender, which is done all on camera, by the way. And then the offender is seen by medical staff and mental health staff before they are cleared to go into the restrictive housing unit. Once they go into the restrictive housing unit cell they are assigned to, they may have a cellmate, they may not. However, they're allocated water. It's not like Shawshank Redemption, electricity. They could come out and take showers. They're able to come out of their cell for 2 hours. They're able to see mental health services, medical services at any time. And you have the strongest officers down there. And when I say strongest, I mean the most senior officers, the one who know how to de-escalate situations at the best before they elevate. So they're given, their sanctions. They could spend time in there up to 5 to 15 days now with the executive order. However, that too is an issue because if the offender keeps acting out, what they're going to do is they know that there's a time limit and then they're going to be kicked back to general pop. Ultimately, what this does is protect the majority of general population, the offenders who just want to do their time, sir, from these small minority groups of manipulative inmates.
So what about a violent attack on an officer? What happens to the person who does that?
Well, that individual is usually brought to the restrictive housing unit. However, when they're assessed by medical and mental health staff, sir, determinations could be made if this individual does have mental health issues. And if they do have mental health issues, they are then brought to maybe an inpatient medical unit inside the facility where they be placed in something like a safety gown so they don't harm themselves or continue to act out. It's really a collaborative effort with custody staff, medical staff, and mental health staff before we make the determination to put that person inside the restrictive housing unit. We're very objective about that. And all of it is video recorded.
Okay. It's, when I'm listening today, you're absolutely right. It's being made that it's this evil place. But really, in order to get into the restrictive housing, you have to do some sort of offense, and it has to be a Class A offense. And
yes.
You're not just putting people in there, and if their behavior corrects itself, then they're not in there. Same thing with prison. You wouldn't be in there if you didn't do something wrong. Thank you, sir.
Thank you, sir.
Further questions or comments from the committee? Seeing none, thanks for being with us, sir. I am going to turn this over to Representative Blumenthal.
Thank you, Mr. Chair. Looks like next up is Jillian Davey, followed by William DeBacco. Ms. Davey? Is Ms. Davey available? If not, we will move to William DeBacco. Are you available to testify?
Yes, let's get this open.
Whenever you're ready.
All right. Good. I started with this as good morning. So good afternoon, Chairman Winfield, staff firms, ranking members, Kissel, Fishboone, and to all distinguished members of the Judiciary Committee. My name is William DeBacco, and I am the president of the Connecticut Auto Recyclers Association. I'm here today to talk about SB 446. We are 100% in support of addressing the current public crisis with the stolen catalytic converters. This is a tremendous issue that is burdening all businesses and residents in Connecticut to operate or live their life interruption-free. Connecticut Auto Recyclers respectfully request that the bill be amended. As we discussed with the Public Safety Committee, we request that the bill be amended to prohibit licensed motor vehicle recyclers to purchase individual catalytic converters, similar to the JFS language adopted by the Public Safety Committee for SB 256 LC 0378 or 3780. What we'd like to have proposed is eliminate the ability for auto recyclers to purchase catalytic converters off the street, thus removing another avenue of where these catalytic converters can be sold. All our purchased vehicles have, as we mentioned with the public safety, have titles or allowed bill of sales and registered with both state and federal agency. So by this amendment, the only stock of scrap catalytic converters we sell are from the vehicles that we have purchased and documented in the proper agencies. Please see the Connecticut Auto Recyclers testimony for further details there. We move on to the main issue now is with VIN etching on every catalytic converter. Since we are such small operations, our issue is there are only so many hours in a day, and the amount of time to do what is requested doesn't seem like a possible option. The Vice President of Connecticut Auto Recyclers, Joe, will present in a few people, and he'll give you a little bit more information there. Many of the vehicles we purchase have exhaust systems that are extremely corroded and rusted. Keep in mind these vehicles are anywhere from 5 years old to 20 or more years old. I've watched my fair share of videos online of etching since the public safety hearing, and we didn't see a feasible way to do a VIN etch on older corroded piece of metal. All those videos were with new steel without any defects. VIN etching is a whole different story when the vehicle is brand new and has never seen a New England winter. What we currently do is write in permanent ink the stock number of the vehicle that each catalytic converter came off of. We do this on every part we remove from a vehicle so we know what that alternator or that bumper came from. Every operation uses a short digit stock number for two things. One, so the stock number can easily and quickly be written on that odd shaped part, and I should say, for us to know what vehicle that part came off of. Well, I have hundreds of parts, I don't know what they are. What we are questioning is that how our current operations work is formidable for what is needed in the documentation aspect. A question arose of what if a truck carrying our purchased catalytic converters were to be pulled over on a Sunday, and since all of our operations will be closed, how is this situation would be resolved in a timely manner? Since our core buyers we sell to give us a duplicate receipt of the number and types of cats they purchased that day, it would be a simple calculation of how many scrap items were purchased via that receipt that matches the number of catalytic converters in one's vehicle. Please keep in mind, auto recyclers cannot sell pieces of exhaust as recycled parts to consumers or repair facilities. So this is because of the state's laws and standard emission standards. So catalytic converters are purely just scrap in our eyes. So the only thing we see that would make sense is for the VIN to be etched upon it being new, which allows for a much effortless engraving system. This idea would have it put on the part from when it leaves the showroom floor and will be well before surfaces begin to rust. In the minute,
Mr. DeBacco?
just kind of like.
Excuse me, I'm sorry for interrupting, but your time has elapsed.
Yeah, I'll set it up. Just like metal tags are.
One sentence.
Okay. Yeah. Just like how metal tags are used on like rear ends to figure out ratios and gear ratios. That's all. We can even like brush away metal to see what that actual documentation is. So that's why we're suggesting it being put on from the manufacturer's aspect, because yeah, it's because it's like I said, it would be a very burdensome on the Connecticut Auto Recyclers aspect. Thank you for your time. I'm glad to hear any questions.
Thank you for your testimony. Questions or comments from the committee? I see that Representative Dubitsky has his hand raised. Representative Dubitsky, you have the floor.
Thank you, Mr. Chairman, and thanks for coming in. I appreciate it. I just have a quick question. Obviously, we have a big problem with people stealing catalytic converters, cutting them off the cars and selling them. And obviously, we want to be able to do something to prevent that. But what about a guy who's got an old car whose catalytic converter burns out and just wants to buy a new one and can't afford, you know, hundreds and hundreds of dollars to buy a new one? How do they?
Thousands most of the time. I'm sorry, thousands most of the time, but go ahead.
Thousands. Okay. So, how does somebody go about getting a legitimate used one?
In the state of Connecticut, it's illegal. So we don't sell them, we're not allowed to. So it's purely on the scrap basis per Connecticut law. So the only option they really have is purely two options of new, either go right through the OEM dealer, which is going to be 3-4 times as much as an aftermarket unit, or an aftermarket cat. Problem with the aftermarkets, yes, it's significantly less money, like a third to the cost of an OEM one. They tend to burn out quicker, and then you're going to have the same problem in 2 or 3 years when your vehicle's check engine light comes on again, reading its faulty cat. So you got to do the process again. So the cat industry, like I said, we don't sell them in terms of as a used unit. It's not allowed. So this bill doesn't really affect that. It's more so just us selling them to our licensed scrap buyers is kind of what we're trying to solve here.
Okay, so looking at this bill, so if you take a car in and it's got a catalytic converter, and you obviously want to get the most value out of the scrap car, right now you can cut up the car, sell the metal, sell the parts. And with regard to the cat, what do you do with it now?
So we sell to licensed buyers. Many of them are bigger scrap facilities, and they only mainly deal with dealer-to-dealer transactions. So we normally do in bulk purchase, 20 or more per sale in that regard. So and then what they would do is they would sell, either they would do it themselves, is gut it and take the precious metals out, or they would resell it to a bigger shop that only mainly deals with the precious metals. So there's a couple like in large ones. Raz, like I said, out of Rhode Island, buys a lot from different yards here. There's a scrap buyer I deal with in Springfield. There's a couple big facilities in New Hampshire. We're all over like the auto recycle aspect, and a lot of yards across the country will freight them, whatever, 200, 300 at a time in a box to them, because they're able to pay the most because they're like one of the final end customers. So it just comes down to where like your avenue of selling is. But I'm sorry, actually, what was your main question of what I do with it, correct?
Well, my question was, how is it done now? And then I was going to ask you, how would the bill change how you handle it?
So the main thing that, like, the VIN etch is like the problem, like, that we see mainly, because like I said, all these things are 10, 12 years old, anywhere, depending on what car you buy, obviously. If you buy a brand new 2022 from auction, yes, it's going to be a much better shape. But recyclers, we really don't touch the brand new cars. Our main window of any part vehicle we buy is anywhere from like 3-4 years old up until about 10 to 15 years old, because those are the cars that are on the road that people are going to be fixing at a lower cost or do it at their own home as a backdoor mechanic.
Okay, so again, so how does this bill change the way you handle the catalytic converters? Would it prevent you from selling them?
No, it would still be business as usual with our scrap buyer, with the receipt that they give us and however many they purchase at that time. It's more so what we see is how it's kind of written up with the idea of doing VIN etching. That's kind of our problem. So as our situation with Senator Champagne brought up before, I see he's got a question, so he'll be asking me soon, is he wanted us to kind of put the VIN number on every part. So every catalytic converter comes in many sizes. Every car has anywhere from 1, 2, 3, 4, depending on the vehicle, year, all that. So the problem is some of these units are like the size of a grapefruit. So, and what his idea is to do a VIN etch, and don't forget, all these are circular circumferences. They sometimes have little grates on them to allow like airflow to kind of get out and to direct heat away from it and all that. So it's just, we feel is the problem is doing a VIN etch rather than doing just our permanent ink on any of these cats is kind of our issue, because our operation as is works. But the problem is, like I said, where these thieves are going, it's not like the auto recyclers. And that's kind of how this bill is positioned. Like, we're one of the culprits. They can be selling them anywhere. They can even go as far as out of state, you know? So, but that's why, one, we'd like to just make it illegal for us to purchase them off the street. That makes it simple. So we buy a whatever 2000 Buick. If it comes with one GM cat, that's the only one we have for that car. Well, like I said, where these thieves are going, I can tell you it's not to the auto recyclers. So that's a problem that still needs to be found out. You know, it's almost needs to be put in task force to purposely set up and follow it, you know, and almost trackings. But all of our cats we buy or we sell are from vehicles that, like I said in our previous few testimonies, is that we have proper type paperwork for the title or the bill of sale, depending on the year of the vehicle, and all that gets sent to the state DMV and also the federal agencies.
Okay, well, thank you very much. I appreciate your testimony. Thank you, Mr. Chairman.
Thank you.
Apologies, I'm having trouble unmuting. All right. Thank you, Representative Dubitsky. Next up, Senator Champagne had some questions, I believe.
Yes, Senator Champagne, go ahead.
Well, it wasn't my idea to etch it on there. It was the chair of the public safety. The law we have before us doesn't have the change. This is the law that I developed in public safety was actually copied and put into another bill here in judicial.
Correct.
The one in public safety has been changed. This one in judicial has not been changed.
Right. So we're looking to amend it along those same lines that are there.
Right. And you know, I met with you know, several of you yesterday, and basically said if you can come up with a different way to just you know, label those catalytic converters from the point of your sale over, I think that would make the chair of the public safety happy, and that's the goal. But you know, we do have a problem, and you know, I don't believe it's the auto recyclers. That's why we changed ours in public safety to make it illegal for the auto recyclers to accept them.
Mm-hmm.
And like I said, you know, if you can come up with an idea that would work for the chair of the public safety, that law, that would change it. This one has not been changed yet, though.
Correct. So I feel like the main aspect would be just how a car gets labeled from the get-go, right from the factory line. It's got VIN numbers on a lot of the parts. It has it normally in a few spots, doors, obviously underneath on the dash. It's even coming to the complexity of you can request for more VINs and etching. So it used to have just, you could pay extra to put it on the glass and all that. But this is something that we feel it should almost be on the manufacturer's responsibility. So every vehicle physically is stamped out of the factory line with the VIN. And like I said, then in that case, the trickle-down effect, it won't affect us because the vehicle is already stamped. So the problem with our current situation is, yes, we can put the VIN on it, but that doesn't truly stop anyone putting any VIN on any cat, you know, because it's not stamped from OEM. So as someone who could be trying to beat the system, they could just be like, oh, we sold this car 6 months ago and they still have the paperwork, and this is the same car. We're gonna put the same VIN on it. And because there's really no like tracking on the end table of when they finally get truly processed to the point of taking the precious metals out, that's like the dilemma. There's no way to track it along its whole process from it leaving the showroom floor to the end. So even if like we put our VINs on it, but like I said, that's why we're trying to go with just keeping it to the point of our stock numbers, because all 30, all 40 that we sell at that time will all match, same type of paint, same appearance, this stock number, this stock number, this stock number. It shows we sold this particular buyer 28, he's got a 20 in his truck. If he's got hundreds in his truck, then obviously I can't be accountable for his situation from there, in terms of just make sure he has all the receipts for everyone else. But at least the 26 that are all labeled, in particular me, like we do a 4-digit. They're all stock numbered, they're all uniform, they all match. We even go to the point of numbering. So once we start, like, oh, this is 1, this is 2, this is 3, with the stock number on it. So we have an exact number of how many we have in the pod to get sold.
I understand that, and you explain that.
Yep.
All right. Thank you.
Yep.
Thank you, Senator Champagne. Representative Dillon, you have a question or comment?
Yes, thank you very much, Mr. Chairman. And thank you for being here. I'm sorry, I don't appear to have your testimony before me, and I'm not sure why. But I guess it's difficult, as you know, and I'm sure this was discussed earlier, that we've had a tremendous problem statewide. We had it certainly in my own neighborhood, but we had I think one of the Goodwills testified before appropriations that 12 were stolen from their fleet in the parking lot. So that this is affecting homeowners, renters, and I know
Absolutely.
that you folks are trying to, you have different segments of the industry, and you're trying to make a living and do the right thing, and I respect that. And I'm trying to recall, in Connecticut, have we banned cash sales of catalytic converters?
To my knowledge, I do not know that answer, to be honest with you. If there's a law, or I know every buyer is different, but we normally do a check base with the buyers we sell to. So there's no cash in that regard, but I do not know if there's any kind of amendment or law on it. I do not have that answer.
Well, I'm going to try to track down your testimony, sir, and I think it's really good that you're trying to be helpful. And
like I said, if we can cut ourselves out of one extra avenue that these people can go to, but our entire industry, the whole auto industry, these hats can be going in any direction for the most part, but the auto recyclers, whatever we have from our own stock is what we sell.
There's a lot of money in this too, and you could be, I believe the yacht of one of the oligarchs that everyone is talking about is called Palladium. That's how that oligarch made his money. So that I have to admit, I had a grandfather who was a mechanic, and I thought I knew a lot, but given that I generally don't know a lot, but I knew more than I thought I did, but now I know I knew a lot less.
Yes, this bill is quite aggressive. I mean, in terms of the cars. Oh, sorry.
Well, we need to do something now. Many of us have renters who don't have a place to park their car, and I really understand and respect some of the things you're pointing out about the VIN. And I appreciate, I had spoken to one of the chairmen of the committee about maybe doing something, and it looked like something was going to happen in public safety, but obviously if it's a felony, it comes here one way or the other. We need to figure out how to deal with tracing these things. Because I don't believe a 17-year-old out there is really thinking about Palladium. There's somebody behind it. And there's a lot of money going through the system, and it's hurting a lot of people. So that those of you sort of in the middle of the chain have a duty, I think. And I'm really pleased and impressed that you're trying to be helpful, but we need to figure this out.
Yes, absolutely. Because like I said, these cats can be going any direction for the actual sale. So, I mean, even all of our scrap buyers are all licensed, and they only deal dealer to dealer, but it's like, who else is buying them and who's doing it illegally is a big aspect. So just restricting it and targeting kind of like the scrap, which everyone does their business different, but the scrap and junkyards is kind of like the main target here. But like I said, anybody can sell them as like a dealer. So it's a little bit of a broader of a base that you've really got to target, which is unfortunate. But like I said, yeah, a lot of people just wake up and they start their vehicle, or like I said, you said fleets are getting whomped galore. It's super sad, and it costs thousands of dollars, and everyone has to pay deductibles or pay for it out of pocket. But the auto recyclers in our situation is just, if we can't buy it from the street, they can't come to us. And if they do, we're just going to say, please leave. We're not going to buy your cat. So that's one less avenue that they can go to. But
so did you think that banning cash sales might be helpful?
Banning cat sales of how?
Well,
cash
That's
sales.
one of the proposals.
Oh,
That
cash.
was,
Oh, I think you said
Yes.
cat, because
Right.
we call these things short. It's like a cat. So a catalytic converter. I thought you said cat. I think that would be a start in a direction, because then it would have to be a process of a few days for a check to get cleared and all that. I think that's definitely a start. If it, like I said, the problem is it's such a small, most of them are relatively small, and the transaction can happen in seconds. It's kind of like almost like a drug deal. It's something that it's like how are you going to track like all this crazy fentanyl stuff? It's like if only there was a way to truly track it, but there's not. And just like that, it's kind of like these cat thieves are in that same situation. It's like it's a very tough thing to truly point a finger at who's doing what and where it's going.
right. There were some states looking at banning cash sales, and I guess I was looking for a magic idea that would help us. And
It's a start.
okay. Listen, thanks a lot. And I'll check out your testimony from public safety too. Thank you. Thank
Yes,
you.
thank you.
Thank you, Representative Dillon. Mr. DeBacco, did you submit written testimony?
It should have been turned in, yes. I will double check with my lobbyist to make sure it gets to you, but it should have, yes. Under
Appreciate
Connecticut Auto Recyclers. Yes, sir.
Great. Thank you, Mr. DeBacco. Seeing no further questions or comments from the committee, we will move on to Jillian Davey, if she is available, followed by Kanisha Boyd. There she is. All right. Ms. Davey, you have the floor.
Thank you. Good evening, Representative Blumenthal and members of the Judiciary Committee. My name is Jillian Davey, and I am a Hartford resident and a student at the UConn School of Social Work. I am here today to urge you to pass SB 459, the PROTECT Act, SB 460, HB 5390, and other legislation like SB 445 and SB 458 that promote the human rights of justice-involved people. You have heard from many here today about how the conditions of solitary confinement constitute torture and are a direct violation of human rights, and you've heard about the need for legislation that protects the rights of incarcerated and formerly incarcerated people. I would like to take this time to urge you to pass legislation that centers the humanity of incarcerated people. Through my time studying human rights and working in reentry spaces with justice-involved men and women and children of incarcerated parents, one point has been driven home clearly. We are all human beings. Every single one of us, whether we have spent time behind bars or not, we are all human. Although we may come from different places, and although we may not look the same or sound the same, we have far more in common than we have dividing us. We must pass legislation that always keeps our shared humanity at the forefront. A person does not stop being human because they committed a crime. Being in prison does not make a person any less worthy of dignity, respect, and compassion. It does not revoke their human rights to physical safety, economic opportunity, health, and freedom from torture. The Universal Declaration of Human Rights begins by recognizing the inherent dignity and the equal and inalienable rights of all members of the human family. As human beings, we have a deep and intrinsic connection to every other person on this planet because of our shared humanity. And with that comes the responsibility to uphold and protect the human rights of each and every member of our human family, whether they are behind bars or have committed a crime or not. To use the words spoken here earlier today, humanity is not political. That is why I am urging you to pass SB 459, HB 5390, SB 460, SB 445, SB 458, and all other legislation that recognizes the humanity and protects the human rights of all justice-involved people in Connecticut. The mothers, fathers, brothers, sisters, sons, daughters, nieces, nephews, grandparents, aunts, uncles, husbands, wives, and friends who are or have been incarcerated. Every single one of us is a human being, and every single human being deserves to be treated with dignity, respect, and compassion. Thank you.
Thank you, Ms. Davey. Are there any questions or comments from the committee? Questions or comments from the committee? Seeing none, thank you, Ms. Davey, for your testimony. Next up is Kanisha Boyd, followed by Jordan Olson.
Hello, chairs, ranking members, and members of the Judiciary Committee. Thank you for the opportunity to speak with you tonight. My name is Kevnisha Boyd, a resident of Hamden, Connecticut. I'm a professional counselor, former mental health counselor at New Haven Correctional Center, and former Stop Solitary CT board member. I'm here to share my story and professional experiences in support of Senate Bill 459. The hidden risk of working as a correctional staff is being vicariously traumatized. My mental health has started to decompensate while working at New Haven Correctional. After 2 years of working at New Haven CC, I was diagnosed with PTSD. My responsibilities as a mental health counselor required me to witness and listen to intimate details about the abuse and neglect incarcerated people were experiencing at the hands of staff. There are stories and images of men being beaten, chained, and neglected that still cause me great discomfort today. One of them is of Robbie Talbot. Earlier this morning, you heard Robbie's story from his mother, Colleen Lord. Mine's is from the perspective of his assigned mental health counselor. In 2019, Robbie was found dead, chained in isolated confinement, which since has been ruled a homicide. I worked second shift the day of Robbie's death, and I recall the overwhelming lack of regard for the loss of human life. Required change that typically happens after an agency causes a death never happened, and the same policies leading to Robbie's death are still in place today. I resigned from DOC 3 months after his death. I could no longer work for a department that was providing poor standards of care that conflicted with my morals and professional ethics. While most healthcare correctional staff have intentions to help, the toxic environment and harmful policies prevent most from fulfilling the ethical obligations of doing no harm. Lack of surveillance, public view, and oversight make correctional institutions more susceptible to abuse and neglect, as reflected in today's testimonies from incarcerated people. The experiences shared are identical to what was witnessed in my work experiences. The reports of misconduct and neglect by staff members were never addressed and often discouraged. Rather, abuse and neglect were often celebrated, reinforced, and made into humorous jokes among staff. The rigid chain of command, like the one that exists, does not support safe and secure procedures to report misconduct and/or grievances from incarcerated people. Through external oversight and accountability, incarcerated people will be safer, correctional staff will be safer, all fostering healthy communities. I urge you to pass Senate Bill 459, and in doing so, protect the lives of incarcerated people, as well as DOC staff and their families across the state. Thank you for your time and consideration, and I'm open to further questions.
Thank you, Ms. Boyd, for your testimony. Are there questions or comments from the committee? Questions or comments from the committee? Seeing none. Thank you, Ms. Boyd, for your testimony. Next up is Jordan Olson, followed by followed by Joe Genovese. Jordan Olson, you have the floor if you're available. All right, it does not look like he is available at the moment. So Mr. Genovese, you have the floor.
Thank you. Chairman Winfield, Chairman Strasstrom, ranking members Kissel and Fishbein, and to all distinguished members of the Judiciary Committee, my name is Joe Genovese, and I am the current Vice President of the Connecticut Auto Recyclers Association. I am in support of SB 446 with the requested changes. I am in support of addressing the current public safety crisis currently affecting the state of Connecticut related to stolen catalytic converters, but respectfully request that the bill be amended to reflect the current operational procedures that are membership practice when it comes to purchase of a single catalytic converter. We appreciate the committee's focus on this issue and welcome the opportunity to be part of the solution. However, we believe that the language as currently drafted can be clarified to better address our industry role while eliminating unneeded, burdensome paperwork. Respectfully, we ask that the Judicial Committee follow the recommendations of the Public Safety Committee with one change to their final language. We ask that we are not required to etch a VIN on each converter if the car that it has been recycled from is within our inventory management system. I would like the amended wording to say within lines LCO 3780, lines 63 to 65, to add language that reflects that recyclers can put vehicle stock numbers on each converter. Most converters, as they age, become corroded almost to the point where having to etch anything onto it would almost be impossible without forcing recyclers to hire additional help, as well as purchasing additional equipment to etch. In actuality, the etching should be at the point of sale from the manufacturer when it is in new condition. That way, the etching would be feasible. Some converters in extreme poor condition, which is common, will be next to impossible to etch on. Our management system assigns a stock number to each VIN number that is acquired by our facility. These stock numbers follow each part and vehicle. Every part that is sold within our facility have these numbers attached to them. It is how they are tracked. I currently put stock numbers on all my converters. The stock number is the way everything is tracked when in my facility. When sold, the company that I sell my converters to gives me a manifest and receipt of the numbers of pieces sold. The stock number placed on these cases would follow the converter all the way to the final recycling level, where it would be decanned and the material separated for further processing and recycling. I thank you for all the opportunity to provide testimony today. Is my video working?
Yes, it is, Mr. Genovese.
Okay. I actually brought a converter into my office just to show everybody. This was taken off a vehicle in my facility today. I have been doing this for over 20 years. By looking at this converter, I can tell you the make of the car just from handling these on a day-to-day basis. I could not tell you what model this came off of, and I handle these every single day. So, and you can see the corrosion level that's on it. There's not a real good way for me to etch this. The only way.
All right, Mr. Genovese, I think we've gotten your drift of your demonstration, and we appreciate it. But your time has expired, and we'll see if there are any questions or comments from the committee.
Okay.
Are there questions or comments from the committee? Seeing none, Mr. Genovese, first of all, sorry for mispronouncing your name earlier.
No,
Second of all,
you did it right. That's the
okay,
correct
I
way
did.
to do
Okay,
it.
that's good.
Can I just draw on this so I can show just one last thing?
Yeah, just one sec.
1 second. This would be my stock number. As you can hear it scraping along. That number right there would track it through my entire facility to a VIN number. There's no need to put a VIN number on these.
Okay. All right. Well, thank you for your testimony, sir. And did you submit written testimony as well?
I did.
Okay, that's good to hear. We'll be sure to review it. Thank you, Mr. Genovese. Mr. Olson, I see that you are back. So you have the floor whenever you're ready, and you will be followed by Errol Goodison.
Thank you very much. Little technical difficulties on my end. Appreciate your patience. Chairman Staffs from Winfield, ranking members Kissel and Fishbein, and members of the Judiciary Committee, good afternoon. My name is Jordan Olson. I've been a correction officer with the state of Connecticut for the last 11 years. My purpose today, my intent today was to speak to Bill 459, but I've since learned that some of the language has changed as late as last night, and I've not been afforded the opportunity to look into that. So it would not benefit anybody for me to testify upon that. What I would like to do is clear the air on certain issue raised earlier by one of your, by Ramon Garcia, someone who testified earlier. Representative Porter responded to the testimony of Ramon Garcia and stated, and I quote, "The story needs to be told." So what I'd like to do is I'd like to tell the story. Ramon Garcia made claims of being housed in what he calls solitary confinement. Solitary confinement, as he calls it, is what we call a restrictive housing unit. A restrictive housing unit serves the purpose of housing inmates who have committed a crime, which I will get into, while inside the correctional house. So Ramon Garcia claims that for two reasons he was brought to the solitary confinement area of his prison. One area in particular, one reason in particular was because that he used the bathroom during a facility count. The other example he gave was that he made a three-way call.
Mr. Jordan, I'm gonna jump in at this point. I certainly, I think we're getting a little far off of the language of the bill at this point, and also, I'm not sure how appropriate it is for us to get into the weeds of a particular case. I mean, if it's your testimony that the testimony received was not completely accurate, and there's another side to that, I think at a high level that's probably okay, but I'm not sure it's quite appropriate for us to get into the details of who, what, where, when, why.
Yes, sir, that was the point of my testimony today, was to just clear the air based on what's been reported and testified today and amongst some of the other participants.
Yeah. Okay. I think we certainly can all appreciate that there's always two sides to every story. And I think certainly, we hear from thousands of people a year on different stories and the like. And I think we all have to sort of take those with a grain of salt. But I don't want to get into a he said, she said, here, there of a particular case of why one individual person was in solitary confinement or isolated segregation. I think we're more interested in sort of the merits of the bill. So I'm gonna respectfully ask that we leave it there at this juncture on a Friday afternoon. All right.
Very good, sir. Thank you.
Thank you, sir. Are there questions of this witness on the substance of the bill, Representative O'Day?
Thank you very much, Mr. Chair. And sir, if you could just, without using names, why is the current system better at handling a scenario which you were describing without using any names? Like, how would this bill adversely affect your ability to address the situation that you were faced with previously?
Thank you, sir, for the question. This, again, I've read, I've brushed up on 459. I've read it line by line, but like I said, I know there were some changes made last minute. So if I'm speaking wrong as to to the information I have, I apologize. But to answer your question, sir, what happens when individuals are brought into segregation, what we call restrictive housing, which we refer to as segregation, inmates are taken out of their general population unit, away from all their commissary and out of their home, and brought to a restrictive housing unit where we do restrict movement. Inside that housing unit, though, the inmates are always afforded showers on a scheduled basis. They're offered medical, unlimited access to mental health, phone calls. They receive razors to shave with. They're afforded reading material, writing materials, and they are also in touch with a counselor who can act as their go-between to help them to send a piece of mail to their lawyer potentially, or to get a service, get in contact with another service for them. So if we were to take this system away, this unit out of the facility, we would then no longer be able to hold these inmates accountable for them breaking or violating the rules inside the facility, which in turn puts staff and the inmates at risk at the hands of the violators.
All right, Mr. Olson, I don't know if you submitted written testimony, but if you could reach out to either myself or my staff, I would greatly appreciate Rep. O'Day. Maybe I can talk to you offline, okay?
Yes, sir. Thank you very much.
Thank you. Thank you, Mr. Chair. Sorry about that.
Thank you. No problem at all, Representative. And thank you, Mr. Olson. I apologize for cutting you off, but we are getting late in the day here. I want to make sure we stay focused on sort of the merits of the bill before us, as opposed to anything else. But I appreciate you sticking around with us as long as you have today, and certainly for your service to the state.
Understood. Thank you for your time.
Thank you. All right, next up, I have Earl Goodison.
Yes, good afternoon. Not too sure if you can hear me.
We can. Go ahead, sir.
Yes, good afternoon, Earl Goodison. First of all, thank you, Chairman Whitfield, Chairman Sanford, and the rest of the committee for allowing me to take this time to testify before the committee. I've been with the department over 28 years now. I started at Old Summers when Northern Correctional Center was being constructed. Haven't had a chance to see the new proposal to the bill, but if it's anything like the previous bill, I can only say that this bill will get people harmed in a serious way. For what I'm understanding, all the testimony that I'm hearing, what corrections was designed for, or what the prison system was designed for, and what we are trying to accomplish, or this bill is trying to accomplish, will not work. There's two sides to the prison system. There's custody, and then there's treatment. There's not enough money going into the treatment side. I can tell you that much. From the time I've been there, as I said, I started at Old Summers. I did 25 years at Hartford Correctional Center. When I initially started at Hartford Correctional in '94, they had social services, we had counselors, we had outpatients for the mental health unit. As time went along, money disappeared, those people disappeared, and the mental health people fell through the cracks. Working at the county jail, we would see the usual people, the homeless get picked up, get shuffled in, and they fall into the windfall. What I would ask this committee to do, if we're gonna do this, let's have a real conversation. Let's go back and let's change this whole thing, as we call it, as corrections. Because what we're trying to do now, we're trying to play football in an ice hockey rink, and it's not going to work. And I'll leave it at that from there. Thank you.
Thank you, sir. Appreciate you sticking with us and sharing your perspectives today.
Yeah.
All right. Next I have Lien Case.
Yes, thank you for having me. I'm glad I made it. Good afternoon, chairs and honorable members of the Judiciary Committee. My name is Eileen Keyes, and I direct the Connecticut Children with Incarcerated Parents Initiative at UConn's Institute for Municipal and Regional Policy. Our mission is to improve the quality of supports for children with incarcerated parents, children with incarcerated parents by using the various data and knowledge that we gain to inform public policy and practice. I'm here to testify in support of Senate Bill 459 and House Bill 5390. Regarding 459, I'll reserve my testimony to focus on the requirement for weekly contact visits. Contact visits are an extraordinarily important aspect for the incarcerated individuals, their children, and other loved ones. Studies have shown that maintaining meaningful contact with loved ones during incarceration lowers the rate of recidivism for that individual, which suggests that supporting policies that promote maintenance and creation of social engagement with community members during incarceration would increase public safety. For children, physical contact with a caregiver that the child is securely attached to has a physiological effect on the child's body, which promotes physical health and emotional and mental well-being. Physical contact also promotes a smoother transition for all when the loved one returns home from their term of incarceration. Further, physical contact is seen by correctional departments in other states and nations as an important aspect of promoting a more positive and safer correctional environment. Just over the border in New York, maximum security correctional facilities provide several hours of full contact visits each day. When correctional staff were asked about the commitment to lengthy and frequent contact visits, the benefits in terms of institutional behavior were quickly cited by correctional officers. I'd like to address one specific provision on lines 925 to 928 regarding an individual for whom contact social visits are denied. I would love it if the social visit opportunity that is to be explicitly indicated as a non-contact social visit, excuse me, to be explicitly state that the non-contact social visit offered be an in-person and when available virtual. Our initiative and the families that we support are concerned with in-person visits being replaced by virtual. We would like it if both options were made available to incarcerated individuals' loved ones. And then quickly regarding House Bill 5390, the state already allocates the cost of one's incarceration to relevant state agencies. In 2014, the Prison Policy Initiative found that incarcerated people had a median annual income of just over $19,000 prior to incarceration. And families with a loved one incarcerated are already amongst the poorest in our state. The economic impact of incarceration itself then further nosedives the family into poverty. And we have several specific examples in a one-page fact sheet on our website and linked to in my testimony. I'll give one, I guess, example that on average, a family's income declines by 22% when a father becomes incarcerated, and it remains about 15% lower a year after that father returns home. So, receiving funds later in life could really change the outlook for an entire family and that child for generations to come.
Thank you.
And I think I will leave it at that because I know time is short and it's the end of the day and I have to pick up my daughter from daycare. So thank you so much for the time. And I would be very happy to answer any questions.
Well, I don't see any questions. Thank you for sticking it out and go pick up that daughter from daycare. Seems. All right. Next up, I have Nicholas Buckland. Nicholas Buckland with us. How about Ivana?
Can you hear me?
Oh, there we go, sir. Yep, your camera's off, but we can hear you.
Okay. Not very good with the technical stuff here, but I will start. Good afternoon. As you know, my name is Nicholas Buckland. I've been a correctional officer for 8 years. I have worked at Cheshire Correctional and I started at Osborne. I am going to talk about SB 59. I feel that the 5 hours of out of cell time is something that can't be done. The facilities are not designed with that with the current schedules. And if anybody knew the schedules and how the facilities were operated, they would know this. And just to give you an example, we have certain housing units where the only time they have their recreation is done on second shift. And there's not enough time allotted in the shift to even allow 5 hours of recreation. It also gives the population more time to not only hurt staff, but to hurt themselves, which is something that we can't allow. And as correctional professionals, it's our job to keep them safe. I also want to talk about what you guys call as solitary confinement, which we call restrictive housing. It is not the picture that has been painted. As some staff has already talked about this, the population who goes to restrictive housing has the ability for books. They have showers. They have the access to mental health if they request it. They get the medical attention if they request it. Staff checks on them every 15 minutes. They get the recreation time. They get telephone calls. They're not in a black cell. They have a window and they can have cellies. It's not the picture that has been painted. And I think that's unfair for the people who created this bill. So with that, that's all I really have to talk about.
Thank you, sir. Appreciate you sticking with us to share your perspective. Representative O'Day, briefly.
Yes, I just want to say thank you, sir, for your testimony. You're the second to last one here, and I appreciate you taking the time, sir. Thank you, and thank you for your service.
Thank you. And if anybody would like to email me personally, I'm more than happy to email and talk with you guys if we really want to talk about what goes on in the facilities, the ins and outs. And I'm sure if any of you wanted to tour these facilities, I'm sure that they could make that happen and actually see what goes on.
Thank you, sir. Thank you. We appreciate that. And if you submitted written testimony, then we do have your contact info. And I know I, for one, and I think most of the members of this committee have toured one or more of the facilities over the years. So we do appreciate the Department of Corrections affording us that opportunity. So thank you again for your service. Thanks for being with us. Ivana Bozic is next.
Thank you for your service, Officer Buckland. Okay, I'll try to make this quick since we're at the finish line. Thank you all for being so patient and focused for going on 8 hours of Zoom testimony. My name is Ivana Bozic. I'm a resident of New Haven, and I'm also a researcher at Yale with a background in neuroscience. My current research position actually focuses on studying the effects of solitary confinement or administrative segregation. Through this work, I've done a thorough review of the existing research on solitary. And based on this research, I just want to speak to 2 quick points. One, that's contrary to popular belief, getting rid of solitary hasn't actually been shown to increase violence in prisons. In many instances, it's actually been documented to significantly reduce violence. And 2, there's now scientific consensus that solitary creates undeniable physical and mental harm. I'll start with that first point about safety and violence that's been raised by a lot of correctional officers. First, I really want to thank all of them for their service. It's one of the most stressful and important jobs, and their voices are super important here. The main thing I've been hearing from them is we need to prioritize safety. I think we're all on the same page there. But how do we actually go about that? What does the evidence say? So in states that have actually limited their use of solitary confinement, they've seen decreases in violent incidents. Specifically in Colorado, there was a 40% reduction in inmate assaults against staff. And beyond that, there were improvements in correctional officer physical and mental health. So why is it that reducing solitary makes people less violent? That leads into the second point about the link between social deprivation and brain damage. The human brain was designed for social stimulus, and when it's denied that, it literally shrivels in on itself. It stops producing certain chemicals that act like fertilizer for the brain, and that actually kills neurons in the regions of the brain responsible for self-control. And that's when you see people act out against others and even on themselves. Even looking at people without pre-existing mental illness, there's a 6 times greater likelihood of potentially fatal self-harm in administrative segregation. Some examples of potentially fatal self-harm documented by medical professionals include hanging, self-amputation of fingers, banging their head into the wall so hard that it bleeds, fractures, biting through their own wrist veins. Now, I'm sorry to have brought up such gruesome things, but most of all, I'm sorry that these are the realities of what solitary does to the mind, whether we want to talk about it or not. And if it's so gruesome that we don't even want to talk about it, how can we justify spending tax dollars encouraging it? Thank you.
Thank you, ma'am. Appreciate you staying with us. Okay, I think we still have Mustafa Salahuddin with us, who we missed earlier.
Yes, I'm here. Can you hear me?
We can. Go ahead,
How
sir.
about see me?
You're all good.
All right. Thank you very much, and greetings to everyone that was here today and continued to hang out. I'm actually here to testify in terms of the SB 466 bill, SB 462, that increases penalties for assault on transit workers. I'm currently a transit operator, but I'm a former police officer of 25 years, and I also drove school buses in my life. And these assaults that are happening more and more frequently, throwing things at drivers, even spitting on them, even throwing urine on, assaulting them physically with hands and objects and throwing urine on. It's becoming more prevalent in the among public service workers, period. And it's basically because we're in the public eye each and every day and come across people from all walks of life. Some mechanisms have been put in place to deter these types of violence, like barriers and other methods, but it's very difficult to navigate and protect public service workers, public transit workers against these kinds of assaults, because nothing is foolproof. This bill clearly and explicitly places public transportation personnel in with public safety, emergency medical personnel, firefighters, Department of Correction employees, and provides the strength it needs to deter such acts of violence. Making this a Class C felony conviction that carries a punishment of a minimum to 1 to 10 years in prison and a possible fine of $10,000 definitely gives this bill the teeth it needs in terms of enforcing, being able to enforce the law against such acts of violence. So I'm here in support of that, and I hope that is the revisement. That revisement does get put in place. And I thank all committees that were involved in this. I thank you for your attention to the serious attention to this matter. And God bless you all.
Thank you. Senator Whitfield.
Yeah, just very quickly. I just want to thank you for sticking around. I saw you when you came in, and I wanted to let you testify, but if I did, that potentially opened up a whole lot of changes in our schedule. I thank you for sticking around, hanging in there to make sure we got to hear your testimony.
Completely understood. And it was my mistake. I didn't realize I had to come in as a panelist initially. So no worries. I got a lot done in the office, and at the same time got to be here for this entire thing. So it was very educational.
No better education than a day in the Judiciary Committee, right?
You got that right. I've been on these things sometimes, man. I remember Transportation Committee, man. I was there for like well over 10 hours. So it can go.
We
long.
got that beat though. We have that beat.
Yeah, it was well over that. I lost track after a while, but it was. I applaud all of you, and I thank you for your service. And like the young lady said earlier today, for you to stick around like this. We realize that it's your job and this is what you were elected to do. But just having the tenacity to do so, kudos to all of you.
Well, thank you. We appreciate being here. All right, Madam Administrator, for the record, I believe we have everybody, but could you confirm that we've got everybody who was signed up to testify, had an opportunity to log in, and we are finished? So I will call this public hearing to a close. This was our last public hearing of the year before the Judiciary Committee. So obviously a huge thanks to our staff. We had thousands of people come to testify remotely this year, and I think went off relatively without hitch in our public hearing process. So it is now 26 on Friday, so I'm going to let everybody go enjoy their night and their weekend. As for next week, we will not be meeting on Monday. We will begin our JF week in earnest on Tuesday. We will let folks know over the weekend as to exact timing and the like, but I would assume there will be caucuses on Tuesday morning for each side, and then we will begin JF and bills on Tuesday through to our JF deadline of 5 o'clock on Monday. And obviously we reserve the right to meet at any and all time between Tuesday morning and 5 o'clock on Monday. I hope there'll be some breaks in there, but we will let folks know accordingly kind of as the week goes on. But we will see you all on Tuesday.
Have a nice weekend, everyone.
Have a great weekend, everyone.
Weekend, everybody.